Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not proven.
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican please, verbus Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. It is so loud in my ears right now. I just don't know. Test 1, 2. It's just my ears. It's like somebody just cranked the volume in my ears and nobody else's. I almost went deaf this morning. We got to figure it out. Welcome. Let's see. Where's our chat? There it is. How's everybody doing? Now it's too quiet. Test 1, 2. Yeah, it's good. It's just loud there. Quiet there. That's a little better. We'll get it all balanced out. All right. There we go. Schmoopy69. Congratulations, Schmoopy. You were first in chat today. Everything IP related worldwide is your responsibility. Now, you're going to do great. But I need to move things around a little bit. Just noticed. They're not quite where they should be. Let's run this to A. There we go. And where's this one? Oh, counter's doing the counter things. There we go.
Alex stole it as well.
There we go. Now we can see. All the lights are on. And the blinds are down. All right. If you got that reference, that was a quick one. All right. YouTube kicked me out already. Says Red Pen, such a Monday. Red Pen, I happen to know that you've got an open invitation to a specific someone at your house. A specific muscular, I believe, shirtless Mr. Clean has been invited to your home. Is that the case? When it's when everyone else is gone, you invite him over and get the house clean. So I'm sorry. I do read mod chat a little bit. Let's see. We have Zion today. I knew that because I read texts as well. Any other birthdays for today? We have Bob as well. I'm sorry, bro, mods. Can we add Bob as well? Zion and Bob, both on the birthday list today. The Bob's my fault. The Zion's Ivan's. But let's see. I think that's enough. Let's see. Do we have anyone else to sing to? Zion's 18. I won't tell you how old Bob is, but it's more than 18. I think Bob's my age. Let's see. Beth, Bob, and Zion. There we go. Red Pen, thank you very much for that. Appreciate that. And Lois got them as well simultaneously. I'm going to take this one if that's okay, because I like the alphabetical style. Lois, thank you very much. Anyway, though, I appreciate that, both of you. Before we do that, ACDC Oversight Group member for 33 months make you an OG. All right, we have to celebrate because I'm a little late getting started because we had some things going, had to plug some stuff in. But it was birthday time. We can't avoid this any longer. So wherever you are, if it's legal and you're able, I want you to stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. We're gonna sing happy birthday to Beth, Bob, and Zion. Happy birthday to you. Happy birthday to you. Happy birthday to Beth, Bob, and Zion. Happy birthday to you. I don't know how old Beth is. I think Fran knows. 18 is an amazing age, Zion. There's all sorts of trouble you can get into once you turn 18. So be careful, have fun, but enjoy your 18th birthday party. It sounds wonderful. Grant says, we're not telling on Beth. So she's probably 18 as well, is what you're saying, right? I can't wink. That was my attempt at a wink, this double blink thing. To everyone who's celebrating their birthday today, happy birthday. We realize there are a million places you could be and a billion people you could have celebrated with, but you chose to be right here with us. The privilege, pleasure, the honor, the joy that is ours. Hopefully we can turn that joy right back to you. Make your day just a little bit more special. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Sandy's Grill, Bob Evans, and Cracker Barrel. I'm pretty sure Ivan's got like some Wagyu beef on the menu as well. So you can do pancakes and Wagyu. So happy birthday. You guys, enjoy the day. Enjoy the day. And the little party sound. There we go. Now the dancers. Not one of those names made it into the actual birthday form. The birthday form is amazing. Smoking the ribs. Birthday form's amazing. It's performed beyond its initial intention or purpose. We have an air drum solo at the end. You all have to help with this. Ready? Don't ask me why bass is on the left hand or right hand. Beautiful. There you go. Now the birthday party can begin. Congratulations all. Bada bing, bada boom. Big finish. Right now in court, there's a couple things going on right now, which we're not going to follow. Sorry, but I want to let you know we're not following
this is
the gray sentencing. The school shooter. I'm sorry, I can't start my week off with that. I realize it's day 2 of that. He pled guilty. This is the sentencing trial thing, and also we have opening statements for a very, very just a heartbreaking case with a mother accused of killing her 3 kids. We've got a husband, the victim in this case, or because he's a family member and lost his family. He lost his wife and he lost his 3 kids in this. He is devastated. He's moved on, tried to make a new life, starting over, literally, building a family. That case, first of all, it's got children as victims, 3 children as victims, which makes it incredibly hard to follow. And then at the hands of their own mother, I realize there are some important issues things that need to be addressed with mental health, with medication, with just a lot of things in that case that are important. And I'm not mitigating that in any way. It's just not the right case for us. So that's a tough one. So if you do choose, I've been saying that Trial TV Live was going to cover it. It seems like I've heard now that they're not, but there are a lot of people covering that one, and I know there's some great content creators, great legal minds, lawyer and not, that are going to be covering that case and giving you, if you want to go to one of the big channels like the Court TV and the Law and Crime stuff, I think you can get a clean, just court happenings over there, as well as a lot of commentary from a lot of different people. So whatever your fancy is, you can get that. Sometimes in summaries and sometimes in full coverage. So. Good luck to you, though. I know if you're going over there, it's heavy. It weighs on the soul in a way that you don't expect. And so if you do need a break, you're welcome to come back. We're not going to cover it here, so we're going to try to keep it out of chat a little bit. There are some people who are with us because they don't want to hear that, or it hits too close to home, or it's just for whatever the reason. That's it. Courtroom Confidential Trials is showing it. Okay, so Josh would be a great person to watch that with if you're going over there. So, Lawyer knows doing recaps. Yeah, I don't know what to say about that one, and obviously I don't know all the facts. We just know what's on the news and everything else. But there's a lot to it, and it's really heavy. So just, keep an eye on yourself. Watch your own personal, status as to see how you're doing. So STS is on it. That's awesome. Yeah. So thank you all. I appreciate all the requests. I don't feel, I'm not telling anybody they shouldn't watch it, right? There are a lot of people who that's exactly where they should be, and they can provide great insights and analysis and everything else. And I think it's going to be handled respectfully by the majority of the people that cover it, and everything else. It's just, it's not us. Gina's jumping beans. No, that's not my job. Welcome to the channel, though. You're learning a little bit about it today. That's not what we do. Anyway, all right. All right. That being said, happy Monday. Can I gripe for a little bit? If you'd be kind enough to let me vent for just a little bit. Had a daughter with a birthday over the weekend, and she wanted more than anything else to go to the water park. And I'm not sure if the weatherman just didn't. I'm not blaming Weather Watch, because he had nothing to do with North Carolina's weather. If it were Texas, it'd be different. But the weatherman just did not cooperate, and it rained all week, and all the water parks were closed in the area. All one of them. Okay, we have a lot of options here. We're like 2 hours from anything, and so that was up. And so her number 2 option for her birthday celebration was to go up to Rocky Mount and do this indoor climbing wall arcade center, which they have at their event center. It's like a little corner of the event center that's just it's like a jungle gym, like professional, like all these different climbing obstacle courses and ropes course, and just really cool stuff that they put together, run by the city. And it's indoor, so we're like, hey, that's good. So what do we do before we go? We check to make sure they're open. You go online, and they're like, yep, we're open here on Saturday from here, and they give us the hours. So we drive, because it's like an hour or something to drive up there. We drive up there, and the parking lot is barricaded off, and we drive all the way around the block, and it's like barricaded off at every entrance, yet it's full. I've never seen it full before. It's always just like empty. And then we find there's like if you like go back like a block ago, you could have gotten in the right-hand lane that would then put you in a path that would get into one entrance. So we finally do that. We jump in, a guy jumps out of the little van at the entrance. He's like, hey, it's $10 to park. I'm like, for the play center? He's like, oh, no, you can park here. Go ahead. And so we go in. And, of course, all the closed doors are locked, so you have to walk all the way around the building to the far side from the parking lot to get into one entrance. We go to the entrance, they're asking for wristbands. And apparently, I don't know, there was some pickup league tournament basketball for kids or something. I don't know what it is. I don't do community sports very well. But there was some basketball tournament put on by the town of Rocky Mount. And the guy's like, the play area is closed today. We just didn't have enough people to cover this event in that one, so it's closed. So we're standing out there in the rain. We're like, we're not going to pay $10 to go and watch kids play basketball against each other. And these are all like LeBron James wannabes. Okay, every single one of them. I'm sorry, they might be good, but every single one of them that we ran into was just like talking about how good they were. Like that's all we heard. And so we're sitting there soaking wet in the rain. Her second option for a party was completely just demolished. And we had that hour drive back home, soaking wet in the rain. And I got on the phone to complain. I wanted to leave a message, and I wanted to do it nicely, but it's like, that's not cool to, not tell us that you're closed that day, because we drove to get here. So I get on the message, I get on the machine, and it's a machine. It's like, hey, such and such, this July, whatever. It's like a custom message for this month. It's like, welcome, I just want, if you're coming up here, we're going to be open on Saturdays from here to here. It's literally their phone message that I'm calling to leave a message about not telling us it's closed, has a message telling us that it's open right then. So I left a very nicely worded message. I don't have any regrets. I won't have to like repent or anything else after leaving the message. But it was just, yeah, 1 star review for them today. All right, we've got a couple things we're going to go to. Now we can go to court, shall we? We've got some arraignments going on. We've got some a case with Judge Simpson, I believe, at least maybe possibly a preliminary hearing there. Let's see. We've got Judge Mercer, Jackson County, was doing a bit. Let's see if we can go there. Where's that? Is that this one?
Under Florida law, if you post a bond of $5,000 or more, I have to assume you don't qualify for the public defender's office. You still might, but I've got to get additional information. I don't see any bonds of that amount. We usually don't have those kind of bonds in misdemeanor court. The second thing I've got to look at is your assets or your income. Under current Florida and federal law, you qualify. Qualification depends upon the number of dependents you have.
That's a free public defender
Currently,
qualification.
if you have no dependents, that qualification rate's $15 an hour. That's the same thing as $2,660 per month, $614 a week. So if you make more than $15 an hour or $614 a week before taxes, you may not qualify unless you have dependents. If you have dependents, you can make quite a bit more than that and still qualify. For instance, if you have 4 dependents, you can make $32 an hour and still qualify. So I've got to ask, is there anybody on this side of the courtroom who's a defendant? It only applies to defendants who makes more than $15 an hour or $614 a week before taxes. Ma'am, come on up, please.
1 hand.
Sir, come on up.
2 hands. 3 hands.
Come on up, Mr. Poole.
4 hands.
Anybody else? We'll get one of you to come up, and the rest of y'all wait right there at the bar. Anybody besides these 3 individuals? And your name, ma'am?
Takaya Thomas.
Ms. Thomas is number 37. So, Ms. Thomas, you're accused of 2 counts of culpable negligence. Ms. Thomas, what do you do for a living, ma'am?
I'm a correctional officer at Florida Department of Corrections.
You get paid hourly?
Hourly.
What's your hourly rate?
$22 an hour.
Do you have any dependents, any minor children?
No, sir.
You're not going to qualify for the public defender's office. You simply make too much money. So when that happens, all I can do is give you this instruction. You need to try to hire an attorney. And I'm going to give you a month to do that. So I'm going to reset your case for next month. I need you to consult with an attorney or attorneys before then. One of the co-defendants went through some type of association through your employment. If you want to try to do that, that's up to you. But I can't appoint the public defender's office to represent you because you make too much money.
Yes, sir.
We're going to give you a notice for your court date. When will that be? August the what? 31st. August 31st at 9 a.m. Ms. Thomas, we'll give you that notice and get you to sign for it, give you a copy of it. Ms. Thomas, you will not get a notice in the mail. The one we're about to put in your hand will be the only notice you get. So don't lose it. Make sure you're back on that day. If you hire an attorney, then that attorney will let you know your court date, because once that attorney files notice of appearance, you'll get moved to a private attorney docket. So you won't have to come on that day if you hire an attorney. If you come to court that day and say, Judge, I can't hire an attorney, then I've got to get into more questions about why, how many have you talked to, what are your total assets, do you have any savings, do you own any land, do you own any cars, get into all that kind of stuff. But what I'm going to do today is just give you time to try to hire an attorney of your own choosing. Do you have any questions?
No, sir.
We'll give you this notice, ma'am. We'll get you to sign for it. Once you sign it, we'll give you a copy of it, Ms. Thomas, okay?
Yes, sir.
Watch, somebody's up here that makes like $200 an hour. Let's see. You're not going to qualify.
And this is Jalen Poole, number 33 on the docket. Mr. Poole, what do you do for a living?
I work for Collins Land Service.
You paid hourly?
Yes, sir.
What's your hourly rate?
$18 an hour.
Do you have any minor children?
I got a 2-year-old.
You have a 2-year-old?
Yes, sir.
Does the 2-year-old live with you?
No, sir.
Do you pay support for the 2-year-old?
No, sir.
You support it at all?
Yes, sir.
Tell me how you support your 2-year-old.
I pay for diapers, clothes, and shoes and everything, basically.
Is the 2-year-old with the alleged victim, or is that with somebody else?
It's with the other victim.
It's with the alleged victim?
Yes,
okay,
sir.
so you're going to qualify for the public defender's office given that you have a 2-year-old child that you're supporting. So just have a seat. Mr. McDaniel will talk to you shortly, okay?
Yes, sir.
And come on up, sir. Your name, sir?
Anthony Gosak.
Mr. Gosak
I think he's
is
a
number
fishing boat captain. What do you think?
19 on our docket. Mr. Gosak, you're charged 1 count of DUI with property or personal injury. Mr. Gosak, what do you do for a living?
I work at Identity Resources.
Is that an hourly rate position?
Yeah.
What's your hourly rate?
$16.80.
$16.80. Yeah. Any minor children?
Yes.
How many?
You qualify.
One.
Live with you?
Yes.
You support them?
Yes.
You're going to qualify then, so just have a seat, okay? He'll talk to you shortly. Anyone else on this side of the courtroom that makes more than $15 an hour or $614 per week? We got one more gentleman coming up. Morning, sir.
Yes, sir.
And your name?
Texroy Frey.
What's your last name?
Frey, F-R-A-Y.
Frey, Texroy Frey, number 16. Mr. Frey is charged with permitting an unauthorized minor to drive. Mr. Frey, what do you do for a living?
Self-employed, sir.
What do you do?
Self-employed.
I can't understand what you're saying.
Self-employed.
Self-employed. So what's your average weekly or monthly income?
It varies, sir.
Average, then. Average. That's what I've got to go with if it varies. What's your average weekly or monthly income before taxes?
$2,000 a week.
Okay, you're going to make too much money to qualify for the public defender's office then, okay? You do need to understand, in your case, the state's offer is a
average $2,000
fine,
a week.
Mr. Mitchell.
What
You're
number is this
qualify.
again?
Number 16?
16.
I don't know that's the right fine, though.
Should be $400 fine.
Yeah.
It's $400 fine, yeah.
So the state's offer in your case is a $400 fine within 60 days. But if you want to contest that, you have the right to do that. I have no idea what happened. But if you want to come back on another day, I'll do that. I'll give you a notice for another court date. If you want to take the state's offer, you can sit on this side of the courtroom. It's entirely up to you.
Yeah, I'm curious as to what's the procedure here. I'm being charged with my son driving my vehicle.
You're being charged with you allowing your son to drive. That's a difference.
I wasn't even there, sir.
Doesn't matter. Did you allow him to drive? That's what you're accused of. I don't know anything about your case, but that's what you're accused of, is allowing your son to drive. If you didn't allow your son to drive and you don't plead no contest, then we need to give you another court date and let you hire an attorney. If you want to take the state's offer, that's okay too. I don't know anything about your case.
I'm not even sure it was a procedure here, so I'm trying.
What question do you have? What procedure? I'm explaining it to you. You either can get another court date or you can plead.
I'm not guilty.
Okay, then we're going to give you a notice for your court date. You need to hire an attorney because you make too much money to qualify for a free attorney. They're not free, but they're almost free. $100 is what it costs. So the court date will be when?
You don't get a $100 attorney.
August 31st at 9 a.m. See an attorney, whoever you want to see, and get your prices from them. But you need to hire an attorney because I can't appoint you to the public defender's office.
Are you saying I need an attorney? Can I just represent myself?
You can't. You have the right to represent yourself.
Okay.
You have the right to make a bad decision. That's a bad decision. Almost universally, it's a bad idea to represent yourself. If you come back on that court date and you've spoken to attorneys and you want to represent yourself, there's a certain questions I have to ask you on the record. Mm-hmm. And then if you still want to represent yourself after me trying to convince you not to, which is essentially what the law requires me to do, then you have the right to represent yourself. And it's almost always a bad idea. But try to hire an attorney, think about it, and then come back on that date if you decided you want to represent yourself.
He's already thinking I'm going to represent myself.
We're going to give you a copy of that notice. Do you have any questions?
No, sir.
Okay. We'll see you on that day. And then if you want to represent yourself, we'll go through those questions I have to ask you, okay?
When do you ask me those questions?
On that day.
On that day?
Mm-hmm.
Okay, thank you.
Okay.
I'm good to go?
Yes, sir. Anybody else on this side of the courtroom who's a defendant who makes more than $15 an hour before taxes? Okay, so let me look at my list. I enjoy this process. A lot of these individuals are not here.
Bench warrants to issue.
It's up here, number 20.
FTA.
20 is Jonathan Grantham. Mr. Grantham, come on up. 22. Up here. Okay. So, Mr. Grantham, I get a list of individuals who may not qualify for the public defender's office based upon financial information. In your case, Mr. Grantham, I'm pulling up the notice that what it shows on your
shows you won the lottery last year.
Your application for criminal status, which were you arrested?
Yes, sir.
It's something you signed at the jail. It shows an income amount of $2,800 per month. Is that accurate?
Yeah,
that's
real close.
That says take-home income. Well, it's your form with your signature on it.
Well,
I'm assuming it's accurate.
That would be total before tax.
So let me ask the question again. You get paid hourly or salary?
My check usually runs $5.90 a week.
You get paid hourly or salary?
Hourly.
And you work full time?
Yes, sir.
Okay. And what's your hourly rate?
$15.45.
Okay, so you're slightly over the limit. You have any minor children?
I have a dependent, but it's not a child.
Who is your dependent?
It's a disabled family member.
What's their relationship to you?
Niece.
Niece? Does that niece live with you?
Yeah.
You support that niece?
Yes.
Who else lives in that home? Anybody else?
My grandmother.
Okay. So where's the niece's parents at? They don't support the child at all?
Deceased.
Okay. So you're going to qualify for the Pope Defender's Office, okay? So he'll talk to you shortly.
Yes.
Okay, thank you. So I'm going to tentatively qualify each of you on this side of the courtroom for the services of the Public Defender's Office. Mr. McDaniel, if you find out that they don't qualify for some reason or you have questions, please let me know and I'll ask some more questions of them. So now let me give some instructions to those of you on this side of the courtroom. I'm going to tell you the process we're going to follow. I should have said this at the beginning, but I often forget. There are microphones and cameras in this courtroom. That is not true for the jury room. The jury room is where your conversations with your attorney will take place. So be careful. Anything you say in here may or may not be broadcast on the internet or recorded. Even if you say things to Mr. McDaniel up here at this defense table, see the microphone right there by him, it could be recorded and picked up on the internet or at least on our record or both. So don't say anything to him in private that you want to be held confidential. Wait till that conversation take place in the jury room. There are no cameras. There are no microphones in the jury room. The process we follow is this. Mr. McDaniel is going to call your cases one at a time. Sometimes he'll call 2 or 3 names to have you seated in the jury box, but he'll take you in the room in private one at a time. When he takes you in the room, he's going to talk to you about what you've been accused of. He'll talk to you about any offer he has from the state. He'll talk to you about your side of the case, any defenses you may have. When he gets through speaking with you, one of 2 things are going to happen. Either he's going to say, we might be able to resolve this case today. Please have a seat back in the courtroom so you can see Judge Mercer in a few minutes. Or he's going to say, we can't resolve this case today. It's just impossible. You're too far apart. If it's the second one that happens, he's going to give you a notice for a court date, a written notice that you will sign for. That court date will be about 45 days away. You'll sign that notice. You'll get a copy of it. You'll be free to leave. You cannot leave the courthouse until you get that written notice from him or you see me up here at the bar. So that's the process we follow. Now, if you would like to speak to Mr. McDaniel at length about your case, and it's a complicated case, and you feel like you have some defenses that you would like him to be aware of, that's perfectly okay. Just understand that's not what today is for. Today is an arraignment date. That's all today is for. It's just an arraignment date to get you an attorney appointed, let them talk to you, make an introduction, and have a brief conversation. If you want to do something in more detail and more length, that's great, but it's not for today. So don't expect your conversation with your attorney today to last more than 5 or 10 minutes. That longer conversation will happen at a different day and time when you and he set up an appointment to do that. But it won't be today, not when he's got all these people waiting. So just be aware of that. He's going to take the cases in alphabetical order, usually, unless there's a medical reason not to do so. Mr. McDaniel, have I missed anything?
Just that one case that we're going to resolve.
But that's on the no contest, is that right?
Yeah, that's fine.
Is that right?
Yeah, that's fine. Yes,
okay.
sir.
And if she doesn't want to plead, then we'll let you know that.
Thank you.
Okay. So Mr. McDaniel is going to call his first 2 or 3 cases, and then we'll move over to this side while he's getting started.
Chevelle Belay, William Brown.
He already got reset.
Ashton Gerber. William Brown. Yes.
SoCo, SLP, Southern Colorado. Is that what it is?
All right. So now, ladies and gentlemen, let me speak to you on this side of the courtroom because your process is different because you're not asking for an attorney. In your cases, we're going to do something similar. At least the beginning is similar. Mr. Mitchell is going to call your cases one at a time. When he calls your case, I need you to come stand in front of the microphone. The reason for that is so that we can have you on camera, make sure I can see and hear you. You can see and hear me well. And then he has to advise you of what you're accused of, and he has to advise you of the maximum penalty for that charge. You have to be made aware of the maximum penalty. If it's a battery charge and carries a year in jail, that doesn't mean he's asking for a year in jail.
Okay, we're going to fast forward to the
telling you on the record
charges.
The maximum penalty for.
This judge does a great job explaining everything, but I think we've heard the part we need to hear right here. Let's see here we go.
You're waiving your right to a trial And at the trial, since the trial's not happening, you're waiving your right to call witnesses and cross-examine the state's witnesses. So all of those things happen if you enter this plea today. Again, if you have any questions, feel free to ask them when you get called up here. Mr. Mitchell.
Your Honor, first on the list is going to be number 9 on the docket, Katrina Chandler.
Ms. Chandler, come on up, please. Chandler, good morning, ma'am. Listen to Mr. Mitchell. He's going to tell you what you're accused of.
Like I said before you is Katrina Chandler in case number 26335MM. She is charged with the second-degree misdemeanor version of petty theft that is punishable by a maximum of 60 days in the county jail. If she wants to go ahead and resolve the case today, the state's recommended disposition would be 6 months probation. Don't think she was arrested, so it would only be a $270 fine. She would have to enroll in and complete the retail theft course. Total restitution amount would be $73.44.
Man.
She would have no contact with Walmart, and the state would not file on the following misdemeanor review cases.
6 months with no Walmart.
Don, whenever you're ready.
That's your penalty.
Okay. Well, I'll put them on the record. 26351, 26353, 26355, and 26356.
Are those state attorney numbers or clerk's numbers?
Those are state attorney MRB numbers.
Okay, thank you.
And that's the state's recommended disposition.
$73 bucks
Ms.
for
Chandler,
Walmart.
you've heard Mr. Mitchell's position on the case. Do you have any questions about what you've been accused of?
No.
And do you know how you want to plea?
I'm kind of confused. If I say no contest, do I get what the state recommends?
No. If you say no contest, I listen to you, and then I'll decide what sentence to impose. The state's asking for probation in your cases, and they're agreeing to dismiss 1, 2, 3, 4 other cases. So they're saying that 4 other cases have been filed against you that they're holding in their office to see what happens today. But if you enter a plea of no contest and you take the plea offer that they're asking for, or if you enter a plea today, they're going to dismiss those other 4 cases because I'll be collecting restitution through this one case number. So you can say, I want to plead not guilty, and we'll move you to the other side of the room if you wish. If you want to plead guilty or no contest, that's okay too.
That's guilty.
Okay, so we'll give you a waiver of rights form. This waiver of rights form, as I mentioned earlier, enters your plea of guilty.
She thought she was
waives
getting
your
away
right
with
to
it. They
trial.
were just
It waives your
building a
right to call and
case.
cross-examine the witnesses. Ms. Chandler.
Walmart
I'm
doesn't
gonna
mess
find your
around.
plea.
Neither
Go
does
ahead.
Target.
Date of birth. Ladies and gentlemen, there's a form, there's a line on this form, this plea form for date of birth. That is not for today's date. That's for your date of birth. Make sure you be aware of that. So, Ms.
Unless you
Chandler,
were
you know
born
what the
today.
state's asking for. Anything you want to tell me or you think's important, ma'am?
I'm on a monthly income of disability. Do I have time to pay the fine?
Yes,
Because
ma'am.
I don't have it all up front.
Yes, ma'am. You have the whole time you're on supervision to pay the fine. Any other questions?
The gentleman on this side said something about I could be released on 3 months.
Yes, ma'am. In just about every probation case, I let the individuals get off probation early at the halfway point. So if the halfway point, if you've got everything done, you stayed out of trouble, you got your court costs and fines paid, there's a very
Go back
good
to
chance,
Walmart. Unless
excellent
they've
chance of you
trespassed
getting on probation at the halfway point. Some people need the full time to get the full court costs and fines paid. Some people don't. They'll get off at the halfway point or, shortly thereafter.
Okay, and how much is the retail class?
It's around $40. It's online.
Okay,
Any other questions?
no.
Mr. Mitchell, anything else from the state?
No, Your Honor.
Ms. Chandler, I've already accepted your plea of guilty to the charge of petty theft in case 26335MM. It's a second-degree misdemeanor. I'm going to withhold adjudication of guilt, Ms. Chandler. I'm going to sentence you to 6 months probation with the following special conditions: $270 court cost, $73.44 restitution, and that restitution actually includes a total of 5 cases. Mr. Mitchell's put on the record that the state attorney's office review cases that are in his office that will not be filed on. There you have a condition: no contact with any Walmart while the case is pending. You can't go while you're on supervision. You can't go to any Walmart while you're on supervision. And once you're off supervision, as long as they haven't given you a trespass warning, you certainly can. Ms. Chandler, you may early terminate your probation if you get to the halfway point and have no violations and otherwise qualify. The probation office has some conditions. And I think I saw in here that may be a disability, a legal disability. So to get off probation early, ladies and gentlemen, you've got to do half of it. You got to have no violations, get everything
That's
done.
a pretty
You can,
pretty sweet
you've got to
deal.
either be gainfully employed at least 20 hours a week or legally disabled or full-time student. So as long as you meet those qualifications, there's a real good chance you're getting on probation early. Do you have any questions?
No.
See Mr. Goodson with the probation office, ma'am. I wish you the best.
Thank you.
Yes, ma'am. Mr. Mitchell.
Your Honor, we'll go back to the top, and that'll start with number 4 on the docket, Jeff Bell Jr.
Mr. Bell's coming up. Mr. Bell, come on up and listen to Mr. Mitchell, please.
Shorts and
Like I
T-shirt.
said before you is Jeff Bell Jr. He is here in case number 26343CT. He is charged with no valid driver's license. That is, I'm trying to see, based on his history, it could be a first-degree misdemeanor based on.
Doesn't he have one pending?
He does have one pending, and I was going to bring that up. But
What did you say, Don?
He drives without a license.
Okay, go ahead, Mr. Mitchell.
Or that he was sentenced to on August, I'm sorry, he was sentenced to August.
Sentenced to or set for sentencing?
Set for sentencing.
Set for sentencing on August, right?
So he's entered a plea. He's set for sentencing. Okay, go ahead, Mr. Mitchell.
Yes. I said it was a first-degree misdemeanor, but yeah, based on his history, I think this qualifies as a first-degree misdemeanor, punishable by a max of a year in the county jail. He wants to resolve this case today. State's recommended disposition is 30 days jail with a $400 fine. And I know we had 26122 CT in which he open pled, and there was possible discussions about it not being a jail offer, but given the fact that this is a new similar charge, that's the state's recommended disposition.
Mr. Bell, did you have any questions about what you've been accused of?
No, sir.
And how do you wish to plead, sir?
Guilty, sir.
Mr. Bell, I'm going to get you to sign this waiver of rights form. This form waives your right to a trial. It waives your right to call and cross-examine the witnesses. You don't have to say anything under oath. Just sign that form. If this is a plea you want to enter, put your date of birth.
How'd you get to court today?
And then I'll get some more information from you.
Is he signing up for 30 days in jail?
Yes, sir. So, Mr. Bell, in the other case, you were in court back in June.
Yes, sir.
The state was asking for a jail sentence. At that time, you were employed, I think, at Hardee's.
Yes, sir.
Where at Hardee's?
Yes, sir.
And so what I did is I set a sentencing to see if you were still employed because I wasn't crazy about doing something to cost you your job.
Yes, sir.
So that was June 17th. Did this charge happen before or after that court date?
It was after, sir. My lady had.
While you're waiting on sentencing, you get another one.
Yes, sir.
Okay.
That's not smart.
Okay, go ahead. Anything you want to tell me, I'm glad to hear.
I was just telling that I had already got the stuff that I was supposed to have. Got like my check stub and my certificate for the driver's license.
So let me ask a question.
Yes, sir.
Look at the dates here. June 17th, 2026, you enter a plea. I'm thinking about maybe giving you a shot at probation, set up for sentencing in August, June 17th.
Yes, sir.
It's a court date. 10 days later, June 27th, you're caught driving with no license again.
Yes, sir.
Why are you driving?
Taking my wife to the hospital because her chest was hurting.
Okay, that's good. So you got some medical records for that?
No, sir. I didn't.
Did she actually go to the
home? But
did you actually go to the hospital after the traffic stop?
Yes, sir.
Did you tell the officer that you were going to the hospital?
Yes, sir.
And you actually completed it and took her to the hospital, to the ER?
Yes, sir.
So you can get some ER records showing that she was seen at the ER on that day?
Yes, sir. She can get some.
Okay. Is that right, ma'am? Okay. Mr. Mitchell, anything?
That might be.
I'm probably just going to set him for the same sentencing date. Give him a chance to bring those medical records. And if he doesn't have them, I'm going to give him more than he was offered the first time because he's continuing to drive. If he has them, I'll evaluate them and see what they say.
I think that's the best solution, Your Honor.
So-
We'll just August 19th is what we had it for.
Dawn, is that what we got?
Yep.
So- 9 a.m. is what's on the computer. Mr. Bell, I'm going to accept your plea of no contest, plea of guilty and no valid driver's license. I'm going to set it for sentencing the same day.
Yes, sir.
August 19th at 9 a.m. That's the day you already got to be sentenced on the other one.
Yes, sir.
So we're going to sentence you on everything today. The reason I'm not sentencing you today is because you've got the employment records, but you don't have the medical records.
Yes, sir.
So on August 19th, I would encourage you to bring with you some medical documentation. Did you go to Jackson?
Yes, sir.
Jackson Hospital showing that you were taking your wife, fiance, to the hospital. Mr. Mitchell, I'm going to ask the state to contact the officer involved, because he said he told the officer they were going to the hospital. I'd like to see if you can verify that if possible.
Yes, Your Honor.
Because that's surprising to me that the officer still
Wrote a
issued a
ticket.
citation if that really was the case. But maybe something else, I don't know. He may have followed them to the hospital. He may have.
Because I had to go to work that same day too.
Say that again?
I had to go to work that same day too.
Yeah, well, work doesn't help you.
Yes, sir.
You can't drive to go to work when you got a pending charge. But if you were going to the hospital, that's something I want to know. I did sign a plea waiver. Sitting right here waiting on you, right there.
What do you guys think?
So, Mr. Bell, it's the same sentencing date, except you're going to be sentenced on 2 cases now instead of 1, okay?
Yes, sir.
Any questions?
Yes, sir.
All right. Do not drive between now and your court date.
Yes, sir.
Unless you have a license. You ain't got your license straightened out yet, right?
Yes, sir. But that's why I was going to show y'all this. I'm in the process of that now.
You're still working, right?
Yes, sir.
At Hardee's?
Yes, sir.
In Mariana?
Yes, sir.
All right. So keep the job. Come back on that court date. Bring some medical records with
Yes,
you,
sir.
and whatever other documentation you've got from the employer, okay?
Yes, sir.
All right. See you then.
Yes, sir.
Do not drive. Do not
All right, Mr.
pass
Mitchell.
go.
Your Honor, next is going to be number 7 on the docket, Jessica Lee Brown.
Jessica Lee.
Just a moment.
Ms. Brown, come on up and listen to Mr. Mitchell, please.
Like I said before you, is Jessica Brown in case number 26348CT. She is charged with giving false information at a crash. That's a second-degree misdemeanor that's punishable by a max of 60 days in the county jail. If she wants to go ahead and resolve the case today, the state would just recommend that the disposition be 6 months probation with I put $370 fine. It's $300? Okay, with a $300 fine.
Ms. Brown, do you have any questions about what you've been accused of, ma'am?
No, sir.
Do you know how you want to plea?
Yeah, I did it. Guilty.
Okay, so what we're going to do is get you to sign a waiver of rights form. Ms. Brown, this form enters your plea of guilty. It also waives your right to call and cross-examine witnesses and waives your right to a trial. Your name and date of birth.
Somebody's phone is messing
While
up.
you're
with the
doing
wireless
that,
system.
I'm looking at the citation issued by the officer, which has a short summary of the charge. Let's see what it says.
Let's read the report. Why did you give somebody else's name? Did you say I'm not the person who just caused the crash?
So William Brown was the actual driver, but witnesses say y'all switched. You actually told the officer you were driving. At least that's what you're accused of doing.
Yes, sir.
Who's William?
And then you later told the officer the truth that he was driving.
Yes, sir.
Is that right?
Yes, sir.
So what is your relationship to this William Brown?
Mama.
That's we're separated. We was married.
Oh.
Okay. All right. So I know what the citation says. I know that you're entering a plea of guilty. Anything else you think I need to know, Ms. Brown?
No, sir.
Ms. Brown, I don't know if I've accepted or not. I'm going to accept your plea of no contest or plea of guilty to the charge of giving false information and withhold adjudication of guilt. It's a second-degree misdemeanor, Mr. Mitchell.
Yes.
Place you on probation for 6 months. That surprises me. Giving a false name is a different charge, but yeah, I know that. But giving a false name, is that a second degree? Why would giving a false name be a first degree? What if they're both second? Obstructions is resisting without is a first. Obstructions is a second. So I guess it's a second degree misdemeanor. That means the most you can be sentenced to probation wise is 6 months. The most jail sentence you can receive is 60 days in jail if it were ever become a jail sentence, which it's not, as long as you do your probation.
Yes,
Okay.
sir.
6 months probation, withhold adjudication of guilt, $300, $270,
$300.
because that's a CT. CT stands for criminal traffic, because it was revolving around a traffic accident. It's different fines. Traffic cases have different fines and court costs than misdemeanors do. So it's 270, 300. Sorry. $300 court costs and fines, possible early termination. We're going to give you some paperwork, Ms. Brown, and get you to see Mr. Goodson with the probation office. Try to get everything done, ma'am, so you can get off probation early.
Yes, sir.
Okay, Ms. Brown, do you have any questions?
No, sir.
We've got Judge
All right, man,
Simpson
wish
to
you the
jump
best.
to as well. So if you guys get tired of this,
All right, Mr. Mitchell.
seeing what cases are coming up here in 14th Circuit.
Your Honor, next is going to be number 12 on the docket, Serena DeRee Davis.
Ms. Davis, good morning. Listen to Mr. Mitchell, please.
Your Honor, like I said before you, is Serena Doree Davis, case number 26332MM. She is charged with the second-degree misdemeanor version of petty theft, which is punishable by a max of 60 days in the county jail.
Walmart?
The state's recommended disposition is that she be enrolled in the PTI program for a period of 6 months with a $270 fine, with the terms and conditions that she enter and complete the retail theft course, pay restitution in the amount of $76.54, have no contact with Walmart. And if she completes the PTI program, then the state will not file on case number 26296 MRV.
So that case number, the last thing he mentioned, Ms. Davis, is a review case that's in the state attorney's office they have not charged on. And ma'am, the only thing I see on our system is a couple of old issuing worthless checks that were dismissed.
When I was like 18 years old.
Have you been charged with crimes other than
No,
those?
I'm 45 years old and I haven't been charged anything in that many years.
Ms. Davis, PTI, as I explained a little bit of earlier, is pretrial intervention.
You guys want the
based on
stalker
your lack
trial?
of criminal history, if you successfully do what they're asking you to do, the case against you is dismissed. So it's better than probation from a defendant's perspective, because if you complete probation, you're just off probation.
Right.
If you complete a PTI, the case is dismissed against you. So it's not a plea.
Let's jump.
You just, if you decide to do this, you're
That's
just saying.
fine. I just want it over and done with so I can go home.
So you
I
understand the
live in
terms?
Alabama. I don't want to be here. I hate this town. I can't stand Jackson County. I want to go home.
Well, if you're stealing down here, we'd actually prefer you to stay in Alabama, frankly. So
I wasn't stealing. My boyfriend was stealing.
Okay.
And they're accusing me because I wouldn't turn him in.
So sorry if
Because I
that's
didn't know where he
offensive,
was
but I kind of took a little offense that you belittling or talking
And
bad
that's
about
why
our
I want to
wonderful
leave because
community.
this county does not listen to anybody. Your officers literally put me in an asthma attack that night and did nothing when I asked them to let me go get my inhaler.
Really?
Yes.
What about the stealing? Who was stealing?
My ex-boyfriend.
Miss Davis.
And he ran and I didn't know where he was at. And they threatened me and got in my face, yelled at me and hollered at me and everything else in my family's yard. And I literally told them if I knew where he was at, I would have told him. And I asked them 5 different times to walk me inside with one of their officers to get my inhaler so I could breathe, and they would not walk me inside.
So what started the asthma attack? The stress of the situation?
Yes.
That's what the complaint says.
Judge is like, let me dig into this.
Under Florida law, you can only be convicted of a crime if you somehow participate in the theft. Being
They're
present
saying
with,
that
let me finish what I'm saying. Being present is not enough. You have to somehow participate. Be a lookout, somehow participate. So let's see what they're accusing you of. Okay, let's just see.
Let's just read this together. We'll be done in just a minute.
2 customers appeared not to ring up all the merchandise they had. We reviewed the video incident. During review, it was clear the customers did not ring up all the merchandise, but did use an EBT card and also use a debit card. When the 2 cards were run through the Walmart secure system, it gave us numerous transactions to review, and it gave back a name attached to the debit card of Serena Davis. Let's see what else it says.
There were some prior instances that Walmart
A
had
bucket,
a flag
some
on.
hardware, power tools, and they go to checkout. They don't attempt to pay for the 5-gallon bucket, and it just says customers started checking themselves out. It really doesn't break it down. Customers did not pay for what they rang up, didn't ring up everything, and they left with unpaid merchandise.
He might let her off.
Doubly fair to pay for 2 items totaling $17.42. The female, Serena Davis, was at the register the entirety of the time, and the shopping cart, she knew what had been scanned. 2 items were never scanned. So they're saying that it was a combination effort between you and he, that you had knowledge of the theft. I can't talk at the same time you're going to talk because I couldn't hear what you were saying because I was still talking. What'd you say, ma'am?
I said, just because I'm standing at a register or Walmart Belgie does not mean I know where everything he's running through that.
That's true. That's true. And so your options today are to enter plea of not guilty, and we'll see what the other case is about that the state's got.
No, I just wanted over with just do the pretrial.
Or to do the pretrial
I'm
intervention.
going to do the pretrial intervention and go home. Okay.
So I'm going to show you enter to the pretrial intervention program for the terms of Mr. Mitchell put on the record. $76.54 restitution. Is that right, Mr. Mitchell?
Yes, Your Honor.
6 months pretrial intervention. The state will not file on 26296. You do
Should've
have a
bought a
condition not
power
to go to
tool
any
and stole the
Walmart
bucket.
while you're on supervision because you've got a theft pending from Walmart. This case is technically pending until you complete the pretrial intervention and try to get it done early so you can get off early.
So if I pay all that off, I can get it done and over with?
3 months. You got to do half. So you can get off at 3 months instead of 6. Any other questions?
Nope, that's all.
All right, so ma'am, see Mr. Goodson with the probation and PT office, and I wish you the best, ma'am.
I gotta go to the probation office.
He's fixing to give you some instructions, okay?
Pay attention. All right. All right. We're going to jump.
Mr. Mitchell?
We're jumping. Oh, we're jumping right here. We want to hear this part. That's where we're going to. I think we've got a stalking bench trial preliminary hearing.
14 day district court for county of Washington, state of Michigan.
There might be some other business at the beginning. Let's see.
May be seated.
Morning, Judge. How are you doing? Little baby blue suit there.
It's okay. It'd be the same whether it's here. No.
Mr. Allen is here.
That's why he wasn't here.
Be all ready?
Do we charge for electric?
Yes, pay for my tax dollars.
Oh, is that how that works?
He's joking about charging his laptop on the desk.
Court does call the case of the people versus, is it Tesfaldet? Oh, right, yeah.
Tumwater Troy,
Good
what
morning,
a
Your Honor.
fast
Raymond,
month.
There's interpreters that we need to be.
No. Pickles waived that for today. And good morning, Your Honor. Dan Garrett on behalf of Mr.
34
Araya.
months, Miss
Testimony,
Hewitt.
state your name to the judge.
OG.
And he is waiving the interpreter.
He is, Your Honor.
All right.
On the jury.
I have before me a police form that indicates that he is going to plead no contest charge of domestic violence.
Ooh.
There is a sentence agreement of sentence under 7694A. That's where it's full in.
That's correct, Your Honor.
It is correct, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor. That's valid.
Sure, it is this court's understanding you're going to plead no contest to the charge of domestic violence. Is that correct? That's a misdemeanor, punishable by up to 93 days of jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
Okay, two things I have to make sure you understand. First thing is that it means that you're not further desirous or wanting to contest this charge.
Yes, Your Honor.
Understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis of no contest plea.
Civil liability.
Sir, to the charge of domestic violence, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Your Honor.
You signed an advice of rights form, is that correct? Any questions regarding those rights?
No, Your Honor.
Look at paragraph 5 on the podium there. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on them.
Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today?
No, Your Honor.
No?
Yeah, doesn't finish.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily and of your own free will.
Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2514772. Any objection from counsel to the review of that report?
None from the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time that I accept your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing will be August 31st, 2026, 9 a.m. Bond with its conditions will continue.
Thank you very much, Your Honor.
Thank you.
Let's see. It's for me here.
What about?
Wait, because I thought you marked a copy.
Okay, we're getting ready for this one.
Sorry. I do expect.
I'm supposed to know those.
Yeah.
All right, hold on.
Germany and she doesn't.
I get it.
Oh.
Yes, you're right. Thank you. I feel better now.
For integrity, doesn't.
All the people's.
Yeah, and you're sorry, you're
Do we even know what are they doing right now? I don't know what they're doing. Everybody's leaving. Bye. What? Oh, they did their own sequestration.
We did. It'll be $2.
It's a packed room, and now
Hey, good morning.
Ray started leaving. I was going to get up. So we're ready?
Yes.
We're ready.
We are.
Let's do this, Judge.
Court does call the case. People versus Michael Clark.
Good morning, Your Honor. Raymond Cook for the people. Your Honor, Joe Simon on behalf of Mr. Clark. Mr. Clark, state your name. That's Michael for future here.
My name is Michael Clark.
Thank you. And I appreciate you bending down for the microphone, but they're very sensitive, so they didn't pick you up. All right. It's okay. No.
Just talk loud.
I understand why you did that. Okay. This date time set for trial. Ready.
Court ready to proceed. We do have a preliminary matter that the court probably is likely going to guess what it is, but address that at the right time.
We have.
Well, I'm not guessing anything, but go ahead.
We've mutually sequestered our own witnesses.
Oh, sorry.
And asked formally that get ordered, but we've already done it.
And that was my request also, Your Honor.
All right. Witnesses are hereby ordered sequestered.
The witnesses are sequestered. That's why they left the
room.
room.
Right. Opening statements.
Thank you. Would the court prefer that I speak from the table or from the bench? Or?
Either is fine.
Podium. Your Honor, I'm sure the court is aware of the charges today of stalking, domestic relations, as well as domestic violence, as well as the elements of those and what the people need to prove. As just a brief opening, the testimony that I expect the court to hear today, I plan on calling 2 lay witnesses, as well as potentially 2 police officers. Specifically, I plan on calling the victim, in this case, Peyton Trelfa, as well as another individual by the name of Angel Lewis. The testimony and the evidence that I expect the court to hear will be that the defendant and Miss Trelfa were in a dating relationship for a relatively short amount of time, and that Peyton wanted to end that relationship and told the defendant in no uncertain terms multiple times that she did not want to talk to him anymore and that she hoped he would respect that and do the same. Nonetheless, the defendant continued to message Miss Trelfa, continued to message Peyton, and would leave coffee or left coffee for her in her workplace locker and approached her at work. And that during one of these incidents of unconsented contact, the defendant chased after the victim, causing her to be afraid of what he might do to her. And is that chase that would form the basis for count 2, the domestic violence. I would ask, after the court hears all the testimony, considers all the evidence in this case, that the court would find a verdict of guilty.
Mr. Simon.
Your Honor, some of these facts are not going to be contested. Some of the proofs are going to be pretty consistent, but there's going to be a general theme we think that the evidence will lead you to of a highly embellished presentation of allegations. This goes from the stalking charge to the DV as well. One of the things that you're going to hear, Your Honor, is when Mr. Cook said there was a relatively short dating relationship. That actually isn't true. This dating relationship lasted months. We're going to have evidence to establish that. And yet, when reported to the police, Ms. Trelfa told them that it was less than 1 month, and it was trying to, we believe the evidence will show, characterize the relationship as something different than it was to push forward this allegation. Interestingly, you're going to hear that she didn't even report the matter to the police, and we're going to argue that nothing here amounted to criminal behavior. She reported it to HR, and HR advised her, you'll hear, to call the police and make a report. When the police came, she told them things that were not so. The duration of the relationship being much shorter, that my client did creepy things even before they started dating, that he sort of in a creepy and stealthy way manipulated the work schedule so that they could be on the same shift. That was absolutely what she said.
That does sound
the implication was my words of sneaky and stealthy, but she used the word creepy. We're going to present evidence that's exactly false, but my client didn't do that.
We're going to present evidence that's false.
Ms. Trelfa switched the schedules. She told the police 2 things about that. She said, number 1, he did that. And number 2, he did that before we started dating. And number 3, I think I said 2 things. Number 3, she couldn't do it. She didn't have the status, as she described herself, as a D-lister. Well, we're going to refute all 3 things. She made the switch. She had the ability to do it by using friendships. And lastly, they were dating at the time. In addition, she told the police, he kept sending me gifts after we broke up. You'll hear evidence that my client ordered gifts shortly before Valentine's Day while they were dating, and that he had ordered them and told her, they're coming, just don't throw them away. He didn't continually order her anything. Your Honor, this breakup occurred on February 5th. The last contact from my client to Ms. Trelfa was February 12th. That's 1 week, but I'm going to now go backward and then forward. I'll go backward, middle, then forward. Here's what you're going to hear. They had a very good and strong relationship right up until February 4th. On February 4th, when nobody really knows how it happened, my client's ex, I don't want to say girlfriend because she wasn't much of a friend, his ex, mother of his children, somehow got Ms. Trelfa's contact. And she said, to interfere with their relationship, he's been cheating on you. He slept with me last month. This was false, and we'll establish that it was false. And that caused Ms. Trelfa very big trust concerns, as you may imagine. She expressed that. They had several phone calls, FaceTimes after their work shift, and she left it with, you know what, I can't do this. I can't do this. I'm out. You know how important trust was to me, and that's it. She also left him with another message, and this is a key. On February 5th, you can fight for this, but I won't. You can continue to fight for this, but I won't. Now, she also asked for some space. The uncontested evidence was my client did exactly that. Gave her some space. Didn't have any contact with her until February 7. On February 7, they had gotten off work at pretty much the same time. My client's shift was extended by 30 minutes. I think Ms. Trelfa will characterize that as he waited for her. But we challenged that. We're going to hear evidence that they got off at the same time. He saw her in the parking lot. He walked to her car, not ran. And the court may remember, we don't have video evidence of that parking lot, even though it existed. The court may remember that I'd requested that and it was recycled, et cetera. And so we don't have that. But what you'll hear is he knocked on her window. Can we talk? She got out of the car. They had a pleasant conversation. It ended with her not changing her position. He follows that up with a text message. These are the exhibits you're going to get. And the text message was, I'm sorry, I'm trying to respect your space. This is just so hard. I'm doing what you're asking. In that text series, we're going to ask you to focus on one thing. You said I could try and you wouldn't. She said, when I said that you could try and I wouldn't, that meant I'm not trying to reconcile this. And no matter what you do from now, there will be no second chances. He said, and she ended that with, that's all I have to say, leave me alone. And he said, well, I didn't understand that's what you meant by you could try. That will be an exhibit you'll receive. After that, he didn't talk to her or do anything until February 10th, a lone text message. Have a nice day, I miss you. Good morning, have a nice day, I miss you. That's February 10th. The entirety of the case will be from that text message, have a nice day, I miss you, to the next day, which is February 11th. On February 11th, they were at work at the same time. This is where the facts will really be disputed. Ms. Trelfa will say that my client approached her, that she repeatedly told him she didn't want to talk to him, and that he chased her down, chased her into the parking lot, that he chased after her and to the point that it caused her to feel unsafe. She notified a supervisor, and the supervisor, she documented with the supervisor. Here's what you'll hear on the other side, Your Honor. Number one, you'll hear that my client never chased her, only tried to approach her for really two reasons. Number one, an epilogue on a text exchange of, when am I going to get my stuff? That happened on February 7th. A misunderstanding of her 30-minute time window from when he could pick up his stuff from her residence. He thought, are you leaving it on the lawn? I may not be able to get there in time. He lives in Hillsdale and she lived locally. And he was worried about the time frame. They showed each other their messages. No, look, this is what you said. Yeah. And then what you'll hear is that she walked away. He walked after her. She went to her ambulance rig to start her shift. He followed her out there wanting to continue the conversation. She didn't want to. She drove her rig back to the port. He walked back up to her, not ran, walked, and handed her something she dropped, a device for her shift. Held it up to the door. She opened the door. She grabbed it. That was it. There was no more contact between them. Supervisor contacted my client, said the same supervisor that Ms. Trelfa contacted said, hey, listen, Michael, it's your best interest to just let this go. No more contact, no more thing at work. And he said, okay. And he said, I'm going to sit here in my car until she goes away, and then I'll leave and I'll be fine. He abided that advice. It was not an order, but it was advice. The only thing he said was, but wait a minute, we have an arrangement to get my stuff the next day on February 12th. He said, that's fine. There was a brief exchange in text on the 12th that she replied to as well about the stuff. Where's my key? It's in your locker, that kind of thing. That's it. Oh, I forgot, Your Honor. February 11, my client did put a coffee and say, have a nice day, or words to that effect, in her locker. And the thing about that is they put things in their lockers all the time. Locker. She put stuff in his locker as a gift. He would put stuff in there too. But maybe that was not wanted. But that's it, Your Honor. February 10, the lone text, and the events of February 11. Now on February 11th, I have spent so much time trying to get video, and I showed Mr. Cook today. I don't think I can authenticate this and admit it as an exhibit. I finally got from a Honigman lawyer representing HVA last night. I can show date stamps and time stamps, some video that of February 11th. The other incident is gone, long gone. I showed it to Mr. Cook, and it has gaps. It's a weird system. It leaps forward 30 seconds every now and then. I'm going to be using that video to refresh witnesses' recollections because I don't have a witness to authenticate it as an exhibit. In lieu of bringing a witness here, they said, here's your video kind of thing in response to my subpoena. But then, Your Honor, there was one more contact. not to my client, to her. She went on a vacation. That's why he ordered the Valentine's gifts ahead of time. He knew she was going on a vacation, and she was with a mutual friend on the vacation. He contacted the mutual friend. He said, "Can I talk to you? What's up?" And why did he do that? He got the smoking gun. He got the evidence that showed his ex lied about everything. Do you think Peyton would want this? I'm condensing. The exchange is longer. And she responded basically, no, she wouldn't want it. We already know. That knocked him off his socks. He was in disbelief. How could that be? And then Peyton got on. Peyton took the phone and said, "Hey, this is me. I already know you're all a bunch of lunatics. F off." With that, he knew that even by clearing his good name, if you will, and by getting the truth out there, there was no reason to ever communicate with her again. And he didn't, and he never even tried. She came back from vacation. She had the meeting with HR that was scheduled before she went on vacation. They said, make a police report. The police came out, and she told the police a very different story, as I've outlined. The police left that day, you'll hear, with an admonition to each of them. Now, she's not a party to the case, so they can't make orders, but it was advice. Don't contact each other. My client abided. But you'll hear evidence that she called my client that very night. That very night, the day she reported, which is February 22nd, 2026, about 5 hours after the report, she called him. He let it ring through. He wasn't on a bond condition, but if he had been on a bond condition, what would Your Honor have instructed a defendant? Don't even answer the phone. And that's exactly what he did. He didn't answer it. It rang multiple times. Was his heart aflutter? Yeah. Did he probably want to answer it? Yeah, but he didn't.
Was his heart aflutter?
No voicemail was left, but we'll provide evidence of the call. That was told to the police, by the way. No epilogue investigation on that. There was one more contact, Your Honor. And I think that I'm offering this to show Ms. Trelfa's state of mind, because one of the key elements here is, did she feel actual harassment? That call, I think, is going to be excellent evidence of why that isn't so. But another thing happened in April of this year, where either Ms. Trelfa directly or Ms. Trelfa's roommate at her direction did something to my client's locker to harass him at work. And there's such specificity with what they did to the locker that the information that was there could only have come from Ms. Trelfa. It was populated with the case number, and such a specific case number, including the case codes, the SM at the end. It was populated with the next court date for pretrial, April 20th. It was populated with the date of the complaint. It was populated with such information that only one real person really could have. Oh, well, I mean, there are public records, but the inference will be very strong, beyond reasonable doubt. We say, even though we don't have that burden, that was at her direction or she did that directly. Again, that's April 8th of 2026. This all goes to the state of mind that we ask the court to consider. This is not anything other, we'll argue, than a sudden shift, an end of a relationship that puts somebody into a funk and a broken heart, who wanted to salvage his good name in his relationship, the person that he loved, for a short period of time, that never achieved criminal behavior. And Ms. Trelfa's own actions demonstrate that that's not how she earnestly felt about it either. Something funny happened when she talked to the police. She tried to slant it in a very different way, and then she became very invested as a victim. And that's why she did what she did in April of 2026. The good news is I think we're going to have enough evidence to support our theories, Your Honor, and that's why we will eventually. Oh, I should ask. I didn't even address the DV. Now, I don't even understand the DV charge. I've never understood the DV charge. I don't think you're going to hear one piece of evidence to support that charge.
And I don't mean to interrupt.
I was done.
Okay.
I was done anyway.
Shocking. Oh, I'm kidding. The
Said that's shocking.
Cook, is it your understanding that there's a domestic violence charge?
Yes, Your Honor. I see 2 counts on the complaint. Count 1 being stalking, domestic relationship, and count 2 being domestic violence.
I have when obviously this be unclear to me when it came for authorization for the magistrate. There's no probable cause as to count.
I felt that way from day one, so I didn't know that.
That was not reflected in our notes, so I was not aware of that, but I appreciate the court letting me know that the people would be willing, the people are still able to proceed on the complaint as it was found by the magistrate.
Okay. It's just the one count of the stalking.
Understood. Thank you.
Thank you. And I didn't say formally for the record. That was the conclusion of my formal remarks, and we'll be asking the court to find a verdict. Thank you.
Can they call your first witness?
Here we go.
Peyton Trolpa.
This is Peyton. This is the girl who claims the stalking.
Please come forward and be sworn.
Solemnly swear from the testimony you're about to give will be the truth, the whole truth. Thanks.
Trolpa, T-O-N. Last name T-R-E.
All right, you may inquire.
Good morning, ma'am. How are you doing? I'm going to be asking you a few questions here, and just as some background. Do you know an individual by the name of Michael Clark? How do you know that individual? What relationship did you and that individual have?
Judge, can you ever speak up?
It was just a regression, and then
When you say you had a relationship for about a month, what sort of relationship were you talking about?
See if the mics get fixed.
Do you know roughly when that relationship began? And when did that relationship end? And this individual, Michael Clark, do you see him in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing?
That bad man right there.
Mr. Simons, I believe, is blue. So if the record may reflect that those witnesses identified the defendant.
Thank you, Shelly Small. Appreciate it. Fluttering Heart song.
Peyton, how would you describe the breakup in the romantic relationship between you and the defendant?
while we were together, initially things were normal, a normal relationship. We had been arguing a lot throughout the relationship, and it had ended over time.
Who ended the relationship? Why did you end that relationship?
I had been reached out to and was told that he was cheating on me. So
what day did you end the relationship? Do you remember? When you ended the relationship, was that the end of the contact between you and the defendant? How did that contact continue?
mainly over text. And then the text messages that I managed out one thing that
Do you remember what day you blocked the defendant?
believe it was the 12th for a little bit for that, whenever the text messages had stopped pretty much.
Showing defense counsel with the Marcus Peoples proposed exhibit 1. I showed this to defense counsel earlier today as well. May I approach the witness?
Ma'am, I'm handing you a copy of what's been marked as Peoples proposed exhibit 1.
For the record, that is a 17-page document. Can you please look through that document and let me know if you recognize what it is? What is this document or these documents?
The conversation organized throughout like the last.
Looking on page 1, does this document indicate when these text messages are from? When?
The first one is.
And flipping through it, are you able to see what date other text messages are sent? And specifically going to the last page, what does the last text message give or indicate as far as the date that that's sent?
February 12th.
And have you reviewed these texts prior to testifying today? Are the texts contained within this document the full dialogue between yourself and the defendant's text messages between February 5th and February 12th? Your Honor, I move to admit what's been marked as Peoples proposed exhibit 1.
Any objection or what here?
No.
Okay, exhibit 1 is admitted.
May I approach to publish to the court?
Yes, you may.
Let's see if we can see these.
Ma'am, looking at these text messages, there are some text messages that are in blue and some that are back with gray. Which text messages are the ones that you sent? All right. And so starting with page 1, that long blue message, just for clarity, you sent that one? All right. Looking at these text messages, how many times did you tell the defendant that you did not want to talk to him?
Throughout the text messages, there's a lot of different times that I had explained that I did not want to be friends anymore. I think that's 4 times.
Did the defendant abide by that request not to talk to you anymore? How did it make you feel when the defendant continued to text you after you told him not to?
When I continuously asked him to leave me alone, I felt that obviously that request was not, accepted. It made me feel very
might skip ahead. I can't, she's just so quiet. We can't hear anything she's saying. The questions are a little insightful, but.
What about it made you scared?
When I had to not talk to more, I felt like I would never get that piece of being able to be with her in a situation.
What about the 11th specifically made you scared?
When he followed me out into the parking lot.
Where do you work? Is that at 1200 State Circle? Is that here in Pittsfield Township, Washtenaw County, state of Michigan? You said something happened that day. Were you working that day? What shift were you working? Was the defendant working that day? What shift was he working? Do you know? What happened at work that made you concerned?
I was in our lease and he had attempted to come up to me and talk to me, and I said like multiple times that I did not want to talk to him. I wanted to be left alone. And I had texted my supervisor and asked him what I should do, as I had been reporting to my supervisor about everything that was happening. Because there was already HR involved, so I was just making sure they knew everything that was going on. And I had left out the back door of resupply after I had texted my supervisor.
I want to focus on what happened in that resupply room. You said the defendant tried to talk to you. Do you know what the defendant was trying to talk to you about?
He wanted to talk about the breakup, and he just wanted to talk about the part.
Do you remember specifically what the defendant said? Was there anyone else in the resupply room with you? Who?
Ali and one other person that I don't remember his name, but he.
And by the company, which company is that? When the defendant approached you in that resupply room, how close did he get?
I'd say it was about like me to like very close.
And just for the record, you're pointing sort of at the armrest in the witness box, so that maybe like a yard. Would you say that's a fair approximation?
Yeah.
Okay. How did that make you feel when the defendant approached you in the resupply room?
I was extremely anxious and quite nervous. I did not want contact with him.
Was that the end of your contact with the defendant on the 11th? What happened next?
I had walked out the back doors of our resupply room, and I went to go get my ambulance ready for my shift. And he had followed me out into the parking lot to my ambulance.
What happened in the parking lot?
I had gotten into my ambulance. I had dropped my AG, which is a machine that we use at work. Dropped that outside of my ambulance as I was attempting to get in it away from him. And he had picked it up, came up to me, up to the ambulance. I took it from him, and then I drove into our ambulance.
When you say the defendant came up to you, how quickly was the defendant moving? Was it a walk, a run?
It was to me in the moment, it seemed like a speed walk kind of towards me.
And you said you drove your ambulance to a different location. Where was that location?
It was from where it was parked. I just pulled it out and up into our garage bay, which wasn't too far away, but I don't know, like a exact.
Was that the last time you had contact with the defendant on the 11th?
That day.
What happened after you moved your ambulance? What did you do then?
I pulled it into our garage bay. I was outside of the garage bay. I walked back inside and I went to the back of resupply where Julia Kelly. And I had asked her to come outside with me because Clark had been following me. He followed me out to the parking lot. And then I asked her to come help me pull my truck in the garage so I wouldn't be alone.
Did you tell anyone else about what happened in the parking lot?
Angel Lewis was there as well.
And why did you feel like you had to get someone to come out with you to move your truck?
I had continuously that day and prior to that day and asked Clark to leave me alone and to stop contacting me and just not come up to me and talk to me. And he did not respect that. And he had followed me out to the parking lot and made me fear.
Fear for him or for something else?
For my safety.
Made me fear for my safety? There was no threat?
At any point on the 11th, did you ever find anything in your locker?
Yes, there was coffee in my locker.
Before I go on, I need something clarified. You said feared for your safety. Was there anything?
Thank you, Judge.
Prior to that point that the defendant had done
or said
where you felt it was a threat to your safety?
Other than him, um, continuously contacting me and
Right, I get the context. You made a specific statement about a threat to your state. And so I'm trying to figure out what you mean by it.
when he had followed me out into the parking lot when I had to
you thought he was going to rob your ambulance.
not talk to me anymore. And then he had followed me out and I wanted to be.
Right, but I guess the way that it was said, I just want to make sure I have context to it. Was there a fear on your part that he was going to do something?
Yes.
What?
I don't know. I was fearful for my safety. I didn't know if he would do anything. I didn't know if he.
Had there been anything in the past that would be indicative of him where one might perceive that there's a threat? That he had done something in the past that, no? It was just your belief that he was going to do something? Okay, go ahead.
For some additional context,
I can
when
rule now.
you're out in the parking line going to your ambulance, what time of day is it?
I was at nighttime. It was around 11-ish at night.
Was there anyone else around at the time?
Outside, Angel had done it in the parking lot. I don't know if she's seen anything. I don't know what she specifically witnessed, but I know that she was out in the parking lot, in our separate parking lot.
Okay. When you were walking to your ambulance, were you walking with like a partner or were you on your own? Going back to the coffee that you referenced, I believe you said that you found some coffee in your locker. Did I remember that testimony correctly? Did you ever photograph that coffee?
I believe I did, and I believe I have that here.
Going defense counsel Marcus Peoples proposed exhibit 2. May I approach the witness?
Right.
I don't object to it.
All right, exhibit 2 is admitted.
I'm still going to hand you what's Marcus Peoples. What's in that picture?
The coffee card I left in my locker with the note.
And Your Honor, I have an extra copy. May I publish to the court? How did it make you feel that call?
It made me feel honestly diminished at that point. I felt very like kind of overwhelmed with the situation.
Was that, do you know, let me see if I can phrase this question here. How often do you go into your locker at work?
Every time ever, at least once a day.
Do you know when that coffee was placed in your locker?
It would have probably been around around 5:24 on the 11th.
Do you know who put that coffee in your locker? How do you know that?
He sent a message to me and said that there was coffee in my locker.
I guess their lockers don't lock.
With a woman named Julia in the resupply room. You ever reach out to your supervisor?
Yes. Okay, good.
You ever reach out to your supervisor about anything that happened between you?
That day, yes.
Who is your supervisor? What did you tell your supervisor?
I had explained to him that work was in resupply and he was not leaving me alone. I was unsure what to do because I was scared.
Showing defense counsel with Marcus Peoples proposed exhibit 3.
No objection to it. Exhibit 3 is admitted.
And approach the witness.
Man.
And I'm going to have to copy for the court.
Yeah.
And just for clarity, what is this document I put in front of you?
This is the conversation between my supervisor and I.
And when are your text messages the one in blue again?
Yes.
When you say I'm in I believe at the top there it says, quote, I'm in resupply and Michael won't leave me alone. Is that referring to the February 11th incident? In here, you text, quote, I'm shaking and he won't leave me alone. Was that true? Were you shaking at the time? Why were you shaking?
I was nervous because I did not want to talk to him and he would leave me alone.
After
All right.
the 11th,
I'm not saying Michael
did
did
you
the
and the
right
defendant
thing,
have any contact?
Person,
but
What about over text?
I'm not sure what he did wrong either.
well, he had contacted me and he on his.
And then going back to People's Exhibit 1, the final page there, it looks like at the end you blocked the defendant. Is that true? Did you report this incident to police that day on the 11th? When did you report this incident? To the police, I should say.
I don't remember specifically what day it was, but I believe it was the day after I had gotten back from Ayden.
Would looking at the police report refresh your recollection as to when you reported this? If I may approach the witness, Your Honor.
Wait.
For the record, I'm just showing you the cover page of Pittsfield Township Police Report 26-931. If you can just take a look at this and let me know if you're done with it. That refresh your recollection?
Yes,
What day did you report this to police?
it'd be February 22nd.
So that would be 11 days after this incident occurred. Why'd you wait so long to report it?
I was on a pre-planned vacation. And I I had informed my supervision and my work of this incident. Obviously that day I had told my supervisor, and since I was on my vacation, I wanted to see if he would stop contacting me, which he's not. And that's when it went further, and I put an HR complaint at our job. And
When was that?
I believe it was the 11th or the 12th, or no, the 11th or the 12th that I had, when I told my supervisor about it, we had put in an HR complaint about the situation before I had left.
So at some point over this vacation, the defendant tried to reach out to you. When did that happen?
Well, I don't,
Sustained.
thank you.
That's not
Sustained.
rephrase.
What happened, if anything, between yourself and the defendant while you were on vacation?
He had contacted my friend that I was on vacation with.
How do you know the defendant contacted your friend while you were on vacation?
My friend had showed me the messages.
Do you remember what those messages were?
He was attempting to reach back out and make contact.
That, you know, I wasn't gonna object to hearsay until I got an answer that isn't accurate. So object hearsay.
Sustained.
Did you ever reach out to the defendant while you were on vacation? Since the final text message
Sorry, I just want to make sure I heard that.
Did you ever try to reach out to the defendant while they were on vacation? She said no.
Thank you.
Since the message saying it's in your locker on February 12th on the last page of People's 1, have you reached out or made contact with the defendant?
She says no. Since the coffee message.
I can have just 1 second, please, Your Honor. Well, you do that. How long was your vacation? Starting on the 12th?
6 days?
14.
Then I'm a bit confused. The testimony that I'm hearing was the contact that occurred on the 12th became I think the prosecutor asked you, why didn't you contact the police until, why did you wait until the 22nd to contact the police?
I had left on vacation and I honestly did not want to, I didn't want anything to do with the situation through all the contacts and the messages and everything. I obviously wanted to be left alone. And
well, I'm hearing you. Yes, I get it. But your response to the prosecutor was you didn't contact the police until the 22nd because you left on vacation. Yeah. But so that we're clear,
you left
the
on
last
the 12th.
Contact, at least that I'm hearing here, would have been in February 12th, which 2026, which is a Thursday. Then there's the 13th, which is a Friday afterwards. And then you said your vacation started on the 14th. And now at least I'm hearing that there's a different reason why you didn't, after the 12th, contact the police.
I just hadn't contacted them to like on vacation, and then I did not want, I wanted to be left alone. I had contacted them once I had a HR report in at work, once I had gotten back from my vacation. They asked me to put a police report in.
Who advised you?
Our HR coordinator.
I just want to try to get this timeline correct. On the 12th, you said there was contact with HR on the 12th. What then happened on the 13th?
I had left for vacation. So I contacted HR on the 12th about the incident. They did not reach back out to me until I had gotten back.
What day did your vacation start? The 13th or the 14th? Okay, so what happened on the 13th is what I'm trying to get at.
No.
So HR didn't reach back out to you. You did not reach out to the police department. So nothing happened on the 13th. From the 14th through, you said it was 8 days. So the 14th through the 21st, I'm presuming. Was there contact from the defendant to you?
Not me.
In either direction. You didn't contact him, he didn't contact you. On the 22nd, prior to contacting the Pittsfield police, what happened that led that to occur?
To me to contact the police.
Yes.
I had spoken with HR and I had put in an HR report.
Didn't the maybe it's terminology. Didn't the HR report occur prior to?
Yes, so I put in a report on the 12th.
Okay.
They did not reach out until the 22nd, so they could get my statement. So they could go forward.
Go ahead.
I actually have no further questions. Let's ask the
cross-examination.
Let's see how this one goes.
Can I start sort of there at the end, ma'am, and then we'll go back to the beginning just to try to keep it somewhat. By the way, how would you like me to address you? Would you like me to call you by your first name, last name? Okay, thank you. And you can call me if you need to, Joe. Peyton, on the 22nd of the February, that's the day you met with HR and they said you should call police. Is that right? When you met with the police, you were asked, by the way, if you reviewed the exhibits. Did you review the video interview you had with the police before testifying by any chance? Okay, see if this refreshes your recollection. If it doesn't, maybe I can use it if you need it. You told the police, hey, I just met with HR. They told me to contact you. Is that true? And that's why you called the police. Yes. Well, and on that day, you met with them and did you tell them specifically, the HR report has been done on their side and they just wanted me to make an actual police report with all this personal stuff that's going on. Is that what you told them? You didn't tell them any other reason for contacting them, did you? All right. The other thing I want to ask you about at the end, you met with them, the police, on February 22nd, and the judge asked you about any further contact you may have had in either direction. I'm sorry, the mm-hms are yes or no. That's okay. We're not trying to pick on you. It's just the record needs to reflect what you're saying. That's too ambiguous. You called Mr. Clark that night, didn't you? About 10:30 at night?
I did not. What?
Your phone contacted his phone.
Calling Clark Bob.
So if there is a record of a phone call that's incoming on his phone from your phone on February 22nd, you're saying, I don't know how that happened.
I had looked back in through my call logs and had not.
Well, that's who asked you to do? Who asked you to do that? Go through your call logs.
I had heard from other people that he was saying that I reached out to him.
Did you hear specifically he told the police that you did that? Did you read the police report? Let me show you what's been marked as proposed Exhibit 5.
5, is it your exhibit?
Yes, defense proposed.
It's going to be
E. Thank you. It is now. Ma'am, that is not anything you can authenticate, as we say in the law, but having looked at that screenshot, 10:43 p.m., a call from your number. Is that your number?
Yes.
And do you admit making that call at 10:43 p.m. to Mr. Clark? Did somebody else at your request? Did you live with Angel Lewis? And she's one of the people here today to testify. And did she make the call to your knowledge? All right, let me have that back if you don't mind. Then I'm gonna go backward and then forward again one last time, then I'll go in order, I promise. Going backward, you told the judge and you told Mr. Cook that you didn't contact my client during your vacation. Is that true? Didn't you specifically grab your friend's phone, say, hey, this is Peyton, and start communicating with him?
I did not start communicating with him. We had sent that message.
May I object to non-responsive and
I'll sustain that, and I'll ask you to re-ask your question. Go ahead.
You had told Mr. Cook on direct examination, and you had told Judge Simpson that you did not communicate with my client on vacation. I ask you to repeat that just now as a predicate to the next question, and you confirmed that's true. So then the question was, isn't it true that you grabbed your friend's phone and texted Mr. Clark, this is Peyton, and texted him 2 text messages?
2 text messages, I do not remember. I do remember sending him one saying to stop contacting me.
Okay. So you actually did communicate with him, correct?
Yeah.
Okay. So let me tell you if this is accurate, and if you need something to refresh your memory, I will be glad to help you.
It's a bad
Isn't
trend.
it true let me back up and set the stage for this. Did you become acquainted while you were dating with Mr. Clark with the mother of his children, Gwen? Did you become knowing who Gwen was? Just knowing who she was.
Yes, I know who she was.
And Gwen started to contact you at the beginning of February, correct? And you have no idea how she even got your number, true? She reached out to you through other social platforms? Did you want that contact from her? Okay. Gwen had told you, hey, Michael's cheating on you, right? Yes. And that violated your trust, wouldn't you agree? Hurt you deeply. Then Gwen, fast forward to February when you're on vacation or maybe shortly before, she confessed to you that she lied to you. Isn't that true? And Mr. Clark had been maintaining that that was a big lie all the way. He was trying to tell you that she was lying. Isn't that true? And when you texted him from your vacation, you said, look, buddy, I'm paraphrasing, I know. She already told me. And it still doesn't matter. I don't want to have anything to do with you. Words to that effect. Yes? Okay. Remember I said we'll go backward, forward, and then I'll go right to the beginning. Here's the forward. As this case was pending, you became an active participant in it. Would you agree? You wanted to keep informed? Yes. You talked about the lockers at work at HVA. This is not like a male-female locker room, is it? It's like a common area where employees can gather, right? The lockers, maybe they're capable of being locked, I don't know, but they're not locked, are they? And you have left gifts in Mr. Clark's locker, right? Let me show you something that might refresh your memory on that. Let's go to the day before your breakup.
He's coming at her quite hard, but if he can pin down that she's
February
lying,
4.
that's fair game.
I'm going to show you, this is not marked as an exhibit yet, just something that might refresh your recollection. Just review that whole thing. And the only thing I really want you to focus on is the last page, but I'm trying to make sure the date stamps are all there. Okay, so the reason I handed you all of that, by the way, just for the record, those are screenshots of text messages between you and Mr. Clark, correct? You acknowledge that those are real exchanges between the two of you? They're dated February the 4th, 2026, is that right? And they end with you leaving a present in his locker, right? And you did leave. You said, just as you testified that Mr. Clark said coffee in your locker, you testified to him, or texted to him on February 4th, present in your locker, yes? And you left a present in his locker.
What was it?
He was actually in the lunchroom, and I had taken it after coffee and breakfast, and I had actually brought it into a lunchroom.
From his locker? That's where you left it for him to find. Okay. Speaking of the lockers, you knew which locker was his, obviously, right? In April of this year, back up. In your job, you have access to hazardous materials, right? Sometimes you have to handle them. And when you handle them, there's protocols you have to follow, I'm imagining. And one of those includes putting biohazard stickers on things. Would you agree? Biohazard stickers have fields of information. Would you agree? In April of this year, didn't you take Mr. Clark's name tag off his locker and replace it with a biohazard sticker? Did you witness someone do that? You had direct knowledge of who did that, didn't you, ma'am? You supplied the person who, do you know, did you see it? You're aware of it? It had specific fields of information. Would you agree? Tell me if I'm right or wrong. It had the case number. You didn't supply the case number of this case to anyone? Right down to the digit of what we call the case codes, the SM at the end. It had the next pretrial date, April 20th, 2026. Would you agree?
Yes.
So you know a lot about what's on that sticker, but we'll come back to that. And you didn't tell anyone at work what the next court date was?
Other than the witnesses?
Well, you didn't know who the witnesses were in April of 2026, did you?
I'm witness. So what we had.
No, I'm talking about in putting the sticker on the.
I was not actively out.
Who did you provide April 20th, 2026 to?
Other than the people that were here, nobody else.
What about
that year when?
When we had the pre-trial, I had an angel was with me. Well, they didn't even know that Jane was because they were here.
So, are you familiar with the nickname Tobis?
Yes.
Whose nickname is that?
Or Tobis.
And on that sticker was the name Tobis. Would you agree? Yes. I've not shown you a picture of the sticker, but you've just verified everything that's on it. How did you become acquainted with it?
My supervisor asked me if I could knock his locker the next morning.
And what did you say? Speaking of that, by that time, shortly before, HR had concluded their investigation of what happened between you and Mr. Clark. Do you agree? HR determined, and this goes to your state of mind, that not even by a preponderance of evidence, that's the phrase they use, they say, we don't find harassment, correct?
I'm going to object. I understand why defense counsel says it's proper, but I still believe that that's hearsay.
So I'm asking what her understanding was toward her state of mind at that time.
I'm going to allow it as to her state for only that purpose of state of mind. Go ahead.
You would receive that information, yes? From HR.
They have not phrased it like that. No.
They said there was no harassment. Would you agree? You weren't happy with their finding? Okay. And that was before their finding was before April the 8th of 2026?
Yes, so.
Did you ever have a discussion?
Even to your state of mind, I'm sorry. What was their finding?
They never gave me like a final list of what they found. They had.
Well, but ma'am, you just said in answer to Mr. Simon's questions, you weren't happy with their conclusion.
They didn't.
Okay, so what was their conclusion to your understanding?
That they weren't gonna do anything about the situation. They were just keeping us separate. They were putting us on different days. So I'm guessing, from what I believe, that they believe he must have done something because they switched both of our schedules around so we wouldn't make contact. And
or that you had.
Yeah.
Okay, go ahead, Mr. Simon. Sorry.
Okay, let's now, one more thing, since she's here today. Angel's your roommate, you told us that, correct? Did you ever have a discussion with Angel about that sticker?
Yes.
I mean, even for purposes of how to answer HR, right? Like, you were going to be talked about it from HR, right? Did you ever say, Angel, are you the person who put that on there? I got to talk to HR. What'd she answer?
Objection, hearsay.
It's not for the communication, Your Honor, not for the substantive truth. I'll ask that of
Not for the
Angel.
truth of the matter.
Here.
Yeah.
Okay, I'll allow the answer. Go ahead.
You asked what again? I'm sorry.
What'd she tell you in response to that question?
Don't remember.
Earnestly, you don't remember, ma'am? Okay.
I know that anybody that I had asked that had done it, I don't know what's going that works. They had told me something.
What day did you go into HR to talk about this sticker?
I had never been reached out about the sticker.
What
I
day?
had no information on it. The only person I asked about it was my supervisor.
Oh, hold on. I thought you said you had to talk with HR about the sticker.
I talked to my supervisor about the sticker.
Did I mishear that?
I don't think you did, but now you've invited another thought of questions, so.
Right. Did you talk? Okay. So we're clear. Did you talk with anybody from HR or HVA management about that sticker?
Yes.
Who did you talk to?
My supervisor, Dave.
What day did you talk to Dave?
It was in the day, like, placed on locker. He had came and asked me about it. I do not know what day it was placed.
But it was. Correct me if I'm wrong, because it was the day after the pretrial date where the date set was April 20th. Is that right?
I don't know when it was placed on his locker.
Okay, but when you talk to your supervisor, it was before the 20th of April, right?
I honestly don't remember when it was.
Go ahead, Mr.
The judge's question invited another set of questions. I didn't mark this as an exhibit, but I am now. I'll bring it to you in a second. But I just need to make sure what the judge asked you at the beginning of that is that I heard it right. You said you never saw the sticker.
Correct.
So I'm now going to approach you what's been marked as defense proposed D as in dog. These are several pictures of the same thing. Can you take a look at that, please?
Pictures of the sticker.
When I ask you questions, you express personal knowledge of the following things. Let me make sure I get there. That the case number was placed on that sticker to the extent that it was the complete case number, including the case codes -SM. And you said you knew that, right? Yes? You see that on that picture there? Okay, we haven't moved to admit it yet because you say you've never seen it before. Did you ever see it since, by the way? Did you have to look at it? I said the date of the next pretrial of April the 20th, 2026 was on there. And that is what you're looking at. Would you agree? I also said that the exact date of the complaint that's alleged here of 2/11/26 is on there. That's on there, isn't it? Also, the nickname, it's Tobis, that's on there. Who provided you the personal knowledge of all those very specific things that was on? He said things like I just said, the case number down to the SM is on there. He said, who's Tobis? He didn't have any idea what Tobis was, did he?
Objection, speculation. I don't know how she would know what.
He had no conversation with you about Tobis. Would you agree? He had no conversation.
Objection, go ahead.
He had no reference point of what 4/20/26 was. Would he, or did he? He didn't ask you.
420.
Okay. And didn't tell you that was on there, did he? That's a no, ma'am. You shaking.
Sorry. I believe he did tell me, he told me what was on the sticker. He did tell me that. He did not tell me how he knew what, or it was not on the locker. And
let's go to the beginning now. I told you we'd eventually. Oh, sorry, Your Honor.
Sorry. So your supervisor calls you in to question you about a sticker. And doesn't show you the sticker?
They had already taken it off of his locker.
Okay, I get that. But you're brought in, questioned about this. And nobody shows you anything?
No, I had knew about it from the other people that were there the night previously.
What?
Supervisor's asking you about the sticker. They're asking you, do you know anything about it?
Yes.
They don't show you the sticker.
He had explained what was on it and what was placed on the locker.
And you're meeting with this person face to face. And they don't show you the sticker. Go ahead, Mr. Simon.
I said we'd jump back to the beginning. Let's jump back to the beginning. You
Don't
told
think he believes
Mr. Cook on direct examination that you had a work friendship with Mr. Clark that blossomed into a romantic relationship. Do you remember that?
Yes.
And you said that the actual dating part of the relationship was less than 1 month starting in January. Isn't it more accurate to say, ma'am, that you were involved romantically with him as early as late October, early November?
No. It was after November-ish.
Well, that's different than January. So let's start piecing that down. Wouldn't you agree with me that you guys actually started to become closer friends when you and Angel offered to him in September to crash at your place because of his commute to Hillsdale?
Correct.
You guys live in the Ypsi area, correct? And he started doing that right around September, yes?
Yeah.
And eventually what happened was he started to, you had come out of another relationship, right? And you were feeling vulnerable and sad, right? You turned to him for comfort. Isn't it true that sort of in that time frame now, October-ish, you said to him, "Listen, can you sleep with me in my space for cuddles, to cuddle me and comfort me?" Is that true? And
Just
then
for the cuddles?
after a while, he started to exclusively stay in your room with you. Is that true?
That's a lot of cuddling.
November, December time, yeah.
Okay, these when we talk about less than a month, and then we're talking about a span of 3 months, this is something that's important. So let's do our best, okay? Okay, hold on, please. I'm getting there. I'll let you answer, I promise. Just let me frame it. You told Mr. Cook that prior to testifying, you had reviewed the text messages between February 5th and February 12th. You remember that? Yes? And then I don't mean disrespect. How old are you, ma'am?
20.
Okay. In your generation, the primary form of communications is text messaging. Would you agree with that? Did you review your text from November, December before testifying? All right. Maybe I'll have some for you to review. Would you agree that romantically you spent Thanksgiving together? Romantically, in a romantic relationship. Would you agree that you spend Christmas time in a romantic relationship? Okay. Would you agree that
How does the relationship start in January?
So we had not officially gotten together. We were friends up until January. We had been romantic with each other sexually, yes. But we had not been.
Yes, when?
Okay, excuse me.
So just so I can clarify that, yes, that last yes. Sexually, romantically in early November through February 5th. True or false?
Sorry, can you repeat?
Sexually romantic. I use the words that from early November through January or February 5th, 2026. Yes? And I said November, which was November 2025. Okay. In fact, on December 19th, maybe as a thing of Christmas shopping, you were in a Barnes and Noble and saw a coworker. Is that right? Jojo? Do you remember telling Mr. Clark on a text message, "Hey, you wouldn't believe what happened to me. I just ran into somebody," and he said, "You're Clark's girlfriend, aren't you?" And you responded, "Yes."
They were not Facebook official yet, so it didn't count.
And again, ma'am, I'm going to give you sort of a stack of things, but the stack isn't relevant. It's just to get the dates correctly. And I'm gonna, sorry. Here's the.
You can have just a second to look through. This is the first time seeing these though.
Yes. Ultra.
Are there a lot of them or?
So, Your Honor, in order to make sure the dates stay sequenced so you can't manipulate that, I've put a lot in there. There's only a very short of is the relevant part. I just put the string in there to show that the dates weren't manipulated.
Here's what I'm gonna do. I'm gonna take about 15-minute recess, come back at 1:45.
Thank you.
We're going to skip
step down me. Court's in recess.
And the sequestration order remains in effect.
Yes, sequestration remains in effect.
And we'll make sure they're not talking.
Stay here. Don't go anywhere. Okay, we're going to skip ahead. Give me a second while we skip ahead to when the judge comes back in. All right, I think he's back here. Let's see. It's a long break. Here we go. All right. Witness is coming back in. She's wiping her eyes. She's not happy.
And if you can please come back up and stand.
In here, I don't care.
No cuddles on break.
And before you begin again, Mr. Simon, I just remind you that you're still under. Thank you. And Mr. Goldstein and Ms. Rosmitsky, I will take care of you once we finish. Get you guys.
You want, if Your Honor, I don't mind if you, whatever you.
No, I don't really want to talk.
I want to help him.
You're
okay.
There, and I don't know what's going to happen to me. Okay.
All right. Ayden, we were on the topic of the status of your relationship with Michael, and I specifically, wrongfully, by the way, I've learned, asked you about an incident on December 19. Is it true that while at work, JoJo approached you about running into Michael at Barnes & Noble? And he asked you, you're his girlfriend, right? Yes? And you confirmed that. Oh, okay. I did say. Okay, on December 19th. Okay. So,
and not technically boyfriend and girlfriend because that's what you didn't call each other. Okay, but you were involved at that time in a romantic relationship.
There were some
a sexually romantic relationship. Thank you.
And that started in the beginning of November of 2025. That status. Okay.
Thank you.
Now, when you spoke to the police
backwards.
on the 22nd of February, you were mindful to volunteer that piece of information repeatedly. Here's what I mean specifically. We're only together less than a month. It was less than a month. You said that to them 2, 3, 4 times. Would you agree? You said that to them kind of spontaneously, right? I mean, like just a filler to kind of document why Mr. Clark was reacting the way he was about the breakup. Would you agree with that? Like, boy, look how bizarre he's being. We were only together less than a month.
I guess you could say that, yeah.
You never told the police that you were sexually romantically involved since the beginning of November. True?
Yes.
The status of your relationship with Mr. Clark, in fact, was very solid up to the date of February 4 when you left that present in his locker. Would you agree? Would you be surprised? Tell me if you remember on the February 2nd and February 3rd. I miss you. I miss you more. Nobody, it's impossible. I can only miss you more. Good morning, sweetheart. How are you? That was the status of your text
Can't wait
messaging on
to
the
cuddle
2nd
again
and the 3rd of
tonight.
February. Would you agree?
Yeah.
I mean, if you like, I can refresh your recollection, but having,
No, I don't need it.
okay. And then on the 4th, that's when Gwen reached out. Yes? You were working together at that time, you and Mr. Clark. You were on the same shift. And you started to get withdrawn, right? Or I'm sorry, I said text again. I'm just not of your generation. Some other means of electronic. Okay. How did you come about the information? Okay, thank you. And then while working together on the 4th, you became withdrawn. You were not happy. You were sad. Is that true? Finally, and I'm speeding through this. Finally, he was asking you, what's the matter with you? Are you okay? What's wrong? And you finally spilled the beans. You've been cheating on me, or worse to that effect. True? He denied it immediately, right? And he begged you not to trust Gwen as a source of information, right? And you expressed, to Mr. Clark, you know how essential trust is to me, and now my trust is gone in you. Okay.
Does Angel know Gwen?
No.
Okay, go ahead. You got to make counsel a person really fast. It's relevant to that question. Sure.
See if we can skip ahead. Here we go. All right, everyone's walking back.
Would you agree with me that the duration of your relationship wasn't the only subject matter that you told the police on February 22nd that seemed weird or out of order, or in your words, creepy about Mr. Clark? Did you say specifically that he was sending you gifts and repeatedly? But you knew full well that because you were going to be gone on Valentine's Day, that he'd ordered gifts ahead of time for you to be delivered. He told you so, true?
He told me after we had broken up.
Right. On February 7th, in a text message contained in the exhibit that I'm going to return to, Peoples should still be over. Peoples 1. In February 7th, he said, as you were going dialoguing, look, I got you a lot of stuff. Please, I don't want it to go to waste, or words to that effect. Would you agree? Yeah, you have no reason to believe he sent you things after that, do you? But when you told it to the police, you didn't quite tell it that way, did you?
I told him. He said he was going to be sent.
Isn't it more accurate to say you told the police he's sending things to my house, like present day? Yeah. And also, you told the police things like this. Before we started dating, you know what he did? You used the word creepy, kind of creepy. He got himself onto my shift, right?
That's like dating 101.
You told them that?
I'm sorry, say it again.
You said to the police that Mr. Clark, prior to you dating, worked it out so that he could work the same shift as you.
I don't remember.
Let me see if I can refresh your recollection with the video.
With the video. Oh, that's bad. I think the judge is ready to rule on this case. Are we going to see the video, Judge? Can you show us?
You sat down with the police at the HVA conference room?
Yes.
You were aware of the body and they were activated?
Yes.
God, I think I'm plugged in. Oh, I'm not plugged in. I'm still in. I'm gonna show you what's timestamped at 1790. Body cam.
Just so that way I'm clear, is this being admitted as an exhibit or is this just for refreshing her recollection?
I certainly would not object to the whole thing coming in, but right now it's for refreshing recollection.
Okay.
So we're working on one together.
Not hiding much here.
Okay.
Yeah. So. You know. But no, I just figured it. So.
The audio cuts out a lot.
But it would just be like. Awesome. Sure.
Here's what you told the police, see if you'll agree with. Told them that he caused the shift onto your schedule, to your shift. True?
Yes, can switch with a different C-lister.
Okay. Just yes. You told the police that you couldn't do anything about that because you were a D-lister. And you even added, I had, meaning yourself, had no control over that, right? And you told the police, in addition, that that was before you started dating. Again, staying on theme with the police, that you weren't dating at that time. Would you agree with me that, in fact, on November 10th, 2025, you're the person who caused the shift to be on the same schedule? Can I ask you to please review some text messages in just a second?
Does she not know that?
Mr. Handing back.
Okay.
All her devices are tattling on her?
If I just review these, again, more information than is necessary, but it's because of the dates. Let me just give you date thing.
Hello, hello.
Hello. Yep, it's right there in full color. HD screenshots. Who made the shift change?
You caused the shift, didn't you, ma'am? You asked a friend of yours to shift so that you could be on the same shift with Michael. Isn't that true?
For to switch, that was not, it had nothing to do with the I gave her Clark's number, to, if they wanted to switch ship it.
You asked her to do it.
I asked her if she would at the time, but I didn't ask her, so I have no control over it.
You have no control that she would do it, but you desired it and you asked her to do it, right?
I asked her according on his behalf. Yes.
You bragged to him,
behalf?
look, people love me. I got it done, right?
I said, I have a little pull with people because people like me at the company. Yes.
I have a little poll, meaning I got it done. You, the D-lister. He didn't control this. Well, if he did, why did he need your help? Didn't he say in that same exchange that
Which was the other person?
you made the police think that he had authority to
Look at the
do it
judge.
as a C-lister?
I told them that he was able to switch on to my shift bit. That we have no control of that.
You wanted to be on the same shift, didn't you, ma'am?
Yes.
Because you were romantically involved, yes? And you enjoyed being together. And actually, you were quite a good duo at work, weren't you?
Yes.
You complimented each other at work.
Yeah.
Lots
In
of
fact,
cuddles.
on November 21st, he had an opportunity to shift to a different thing, something called an ALS. Or is it AIS? Yeah. And what is that, by the way? he had informed you that he had that opportunity. Would you agree? And that would have caused you to not work together on the same shift. He also informed you that he turned that down because it wouldn't line up with his schedule seeing his children. Do you agree? And you expressed, oh, thank goodness, or words to that effect, because you wanted to stay on the same shift. Okay.
This is witness number one. We have
turning
a
out
whole
of the
room
5th
full
of
of witnesses
February,
out there.
would you agree that from the 4th of February, when you learned this information through Angel from Gwen,
Hey, Ruth, welcome.
through the 5th, there were some phone calls between you and Mr. Clark, FaceTime, a lengthy hour and a half or more FaceTime with Mr. Clark, leading up to your February 5th long text breaking up. Would you agree with that? Would you also confirm that in one of those communication forms, you said to him words close to exactly this: you can continue to try to fight for this, but I won't be. Okay. You also asked for some space, right? So from February 5th, when you asked for space, to February 7th, there was no communication between you, was there? On February 7th, after work shifts, he came up to you while you were seated in your car in the parking lot. True? Knocked on the window and said, "Can I talk to you?" Yes. You got out of the car? Yes. You had a talk. And in that talk, you had said, I'm not really interested in words to this effect, man. This is not exact. I'm not interested in your denials, my trust violated, move on, or things like that. Would you agree? He followed that up with a text message saying essentially, and it's in front of you, so you can say, "Mr. Simon, you don't have it right." Essentially, hey, look, sorry, I don't mean to crowd you, or words to that effect. This is just so hard, and that kind of. Would you agree? Yeah. In addition, there was an arrangement to get his belongings that you began to discuss with him. True? Yeah. He had belongings at your home. I mean, he has children and had to go back and maintain his residence in Hillsdale, but when he wasn't there, he was basically living with you. So you started talking about possible times and started to discuss February 12th. This is a probable date. Okay? And arrangements were going to be made as to how that was going to take place. Would you agree? So, on February 7th, just to be abundantly clear, he never chased you down to your car, did he?
You followed me. I was like,
Well, he came up to your car and knocked on the window, right?
yes.
Okay. You didn't really know how he got there, but you just saw him at the window knocking. Okay. The next contact that you had was a text from him on the 8th saying, "Will Thursday the 12th be acceptable for me to get my belongings?" And you replied, "That's fine." Excuse me, "That's fine." And he said, "Thanks for the reply, means a lot."
Yeah.
That's part of Exhibit 1, People's 1. Yes?
Yeah.
And that was the only communication on February 8th. Would you agree? On February 9th, and again, paraphrasing, so if you say it's not fair, Mr. Simon, you fill in the blanks, okay? That you have every right to do that. He wrote a long diatribe. I mean, like laying it all out there, essentially saying, I want to fight for this. I love you. And Gwen can't be trusted, and just a long pouring his heart out kind of message. Would you agree? In that, you said to him, "I don't want to talk to you or have a conversation about any of this." Would you agree? You added, "There's nothing else to talk about. I don't trust you anymore. You lied to me when we talked about it. Okay. In other words, you weren't buying what he was selling. Okay.
No more free cuddles.
You said in that string that you were going to tell him again. You used the word again, leave to not talk to you or that kind of thing, right? And in the end of that string, he said, wait a minute, you told me again, words to this effect, I could fight for this and you wouldn't, right? And you went on to explain what that meant. You said, when I said you could try and I wouldn't, that meant I'm not trying to reconcile this. And no matter what you do from now, there will be no second chances. Agree? And you said, that is all I have to say. Please leave me to here. Please leave me alone. Would you agree?
Yeah.
And he wrote back, I didn't understand that that's what you meant by you could try. True? The next contact was on the February 10th, a single contact, a message to you. I hope you're doing all right and have a great day. I miss you. No more contact on the 10th.
That's the stalking activity
Correct?
right there.
Now, I'm going to skip over the 11th and come right back to the 11th. On February 12th, Mr. Cook asked you about contact with that he continued to contact you. This was the arranged date for him to get his belongings, weren't you? Would you agree? And he was merely inquiring as to the key, right? Where's the key? I need the key.
The long messages that he had sent me after I told him to again stop texting me, he did end up saying that he was asking for his house key.
Yeah, let's go back to where I'm asking you. On February the 12th, the only exchange he had to you on February the 12th was about the key and getting his belongings. All right.
He had sent multiple different messages after during the 12th.
About getting his belongings, and you were replying to them.
There were, I have to count how many messages.
I don't.
Your microphone, Mr. Simon.
Turn your microphone on. We can't hear you.
Mr. Simon,
Yes.
the microphone.
Yes.
Just to make sure.
Oh,
Now he turns it on.
no, she said. Whatever. All right. What's in the exhibit is what you're referring to. We'll just let the exhibit stand. Okay. I told you we're going to come back to the 11th, and I promise we will. On February 12th, you testified you blocked him. Is that right? You know a lot more about phones than me, but tell me if I'm right. If you block a person, they don't know it on the other side. They don't get a notification, do they?
That's correct.
And if you block a person, that means they can't reach you. Is that true? Tell me, is this true? For you to call someone that you've blocked,
you have to unblock
do you have to unblock them? You can call them anyway.
You can call people that you've blocked, yes.
Okay. Could you message people that you've blocked?
I don't believe they would go through.
Okay. Let me ask you another question. In addition to blocking him on February 12th, you also stopped sharing your location with him on February 12th. So
No more
through
Life 360.
February 12th, you were sharing your location with him. So when you were talking earlier about your state of mind, being scared and all that kind of thing, you were still sharing with him through February 12th.
Remember vividly sharing my location, also my message location.
I wish we could hear.
Let me
what she
approach
said.
you with. This actually comes from the original
The
police
judge
report.
is so great.
It's part of it. It's the same thing you have. Let me see if you can take a look at this.
Yes.
Yeah, except that's, it's not, I don't know if it's still there. Yeah, okay. All right. So part of the exhibit shows that you stopped sharing your location on February 12th, right?
Yes.
And none of the other part of the exhibit shows that, like from February 5th through up to that date. The judge asked you some questions on when you were on direct about threats. You specifically were asked that question by the police. Were there any threats, ma'am? Anything like that? And you quickly and definitively answered, tell me if I'm right or wrong. No, there weren't. Never threats. Because there weren't. And you said just this was kind of harassing to you, or use your phrase.
Yeah.
Okay. Now I said I'd come back to the 11th, and I will, and then I'll be concluding after that subject matter. We'll go to one more thing, and I'll be all done. On the 11th, and unfortunately, this may get some. Maybe we can do it through words, and maybe I'll have you review something. In the resupply room, Mr. Clark approached you. First, there were other people in the room. Is that true? There were at least 2 and sometimes 3 and maybe 4 people in that room.
There could have been, I don't necessarily remember. I'm going to get people that were right with us.
Would you agree with me that you were sort of standing in the middle of the room? Mr. Clark came in with somebody else and eventually walked up to you and said something to you. And you responded, talked back. Whatever was said, maybe it was leave me alone. Maybe whatever was said, you responded. Yes. That conversation ended, right? He walked away. Yes. Oh, okay. And then you came back to essentially the same spot in the resupply room?
So she walked away, then she came back.
Well, maybe I'm going to have you review something in just a minute, ma'am. But that'll take time. So before we do that, let me ask you this. When he came back to you, he came out with his phone and he was pointing to his phone like this. Mr. Cook asked you if you remembered what he was talking about during that time, and you said something like he just wanted to fight for the relationship, although you don't specifically remember what he said. Wasn't he saying, look, no, you said I could only have 30 minutes on the 12th to pick up my stuff tomorrow, and I need more than 30 minutes. Wasn't he showing you that text message?
I did not look at the text message he was trying to show me. I wanted no contact with him. When he messaged, all I said to him was, I don't want to talk to you.
And then you pulled out your own phone and scrolled to see what he was talking about, right?
I don't remember that.
And see if it refreshes your memory. What he was asking about wasn't fighting for the relationship, was the time and the arrangements to get his stuff the next day.
I don't remember that.
Okay. All right. On that date or after?
That date. I don't necessarily remember saying anything about it prior to either, but I can look back.
Hold it. You don't remember him saying anything about getting his items?
Yes, I do remember that. He wanted to come pick up his things on 12th. We already talked about that. I'm saying that day. For example.
Go ahead, Miss.
The direct testimony you rendered about what happened in the parking lot, when asked to by Mr. Cook to categorize how Mr. Clark approached you, I think you said, in the moment, I tried to write it down, but I'm not that fast anymore. In the moment, I thought it was more like speed walking. Do you remember that testimony? In retrospect, he was just walking, wasn't he?
He had been what felt like chasing after me.
Well, I'm not talking about what felt like. What'd you observe?
Is that he was speed walking and following me.
Okay. You told the police he ran after you.
Speed walking ran.
You never said speed walking to the police, ma'am. Oh, no, I'm asking. That's a question. It wasn't very well phrased. You told me he ran after me. He ran after me. Scared you. Yes? Chased me to my car. You actually used that phrase, chased you to the car on February 7th. Yes? You told the police that on February the 7th, the night he knocked on your window, can we talk, that he chased you to your car. Is that true or false? That you told that to the police?
Yes.
And the truth is, you were actually already in your car when he just came up to you and knocked on the window, said, can we talk? And you got out and talked to him. True or false? Okay. And you used the same language about February 11th, correct? Okay. You said Mr. Clark stopped texting you after February 12th. Would you agree? You seem to attribute that to you blocked him, right? He had other methods of communicating with you, didn't he? Instagram, messaging, other social media. You guys did communicate that way with one another?
After the 12th?
No, just in general. But he didn't do that after the 12th, did he?
No.
And you didn't block him on any of those abilities, did you? Well, he didn't come to your house, did he? Other than to get his stuff. Okay. And there were guidelines put in place at work to keep you guys on different shifts and that kind of thing.
At work?
Yeah. All right. My last area of inquiry goes to your state of mind when you two questions. When did you learn from Gwen or whatever source you learned it from that Gwen's insertion into your relationship was all a lie per her own admission? When did you learn that?
Over text with vendor.
Over your vacation, you learned that directly to you?
Yes.
From? Oh, you don't know her. Somehow or another, at some point, gains the ability to text.
She found me on Facebook and then
Okay, good.
Mr. Clark, I don't know, try how to phrase this because it's like trying to prove a negative. You believed Mr. Clark cheated on you because of what Gwen told you, right? And when Gwen told you that was all a lie, did you believe that? That it was a lie? Okay. I believe that I'm
okay. I'll ask. Why not?
Since the situation kind of went the way that it did, and I didn't, and I did not believe her. I didn't.
Hold on a second now. Somebody sends a message somehow or another, well, to somebody else that gets to you that says he's cheating. Believe that, right? But that message is coming from somebody else to you from this Gwen.
Yes,
right?
She had video and text message proof that he was contacting her and making physical contact with her.
Okay. But then when she tells you directly that's not true, right?
Yes.
You don't believe that.
Yes. Her friend had also reached out to me and said, trying to backtrack herself and say that it was not true. That when she had reached out to me first time when she said that it was just a lie, just to get us separated, that was a lie, which is what I did not believe. So her friend had reached out to me and found me on Instagram. That's why I decided to call them and didn't.
Okay. People need other stuff to do. Were you done, Mr. Sun?
I was, but if I can just retrieve the things I've left up there, because I'm not sure, I think I'm done, I just want to verify. Yes, I am concluded. Thank you, ma'am.
All right. Thank you. Go ahead, sir. No, right.
Pete, and I want to draw back to the beginning of your cross-examination where defense counsel asked you about why you called the police. And I believe the answer you gave was that you partly called police due to HR telling you to. Do you remember that testimony? What was the other part to that?
Had not, just due to everything that had happened. I had been meaning to put in the police report before I had left, but I left for vacation and I didn't want to do with it. I was partly scared because of the February 11th situation. And I wanted no contact. I wanted that to never happen again. So.
Okay. And then there was also some question near the there at the end of People's Exhibit 1 where it shows that you stopped sharing your location. When the incident happened on the 11th, were you concerned at all with your phone sharing your location at that time?
I honestly, after the situation that happened, I didn't even think about any of that. I was not concerned with anything else. Like I said, my iMessage location does not work.
What was your main concern on the 11th then?
To get away from our station, get away from him.
Okay. Nothing further. Thank you.
May step down.
Your rates would just be excused.
Please.
Mr. Simon.
I'm sorry.
He's asking if this.
So, yes,
I don't know that I've asked, but I'm not going to do that. She's not excused at this time.
Understood.
On the courts.
I was about to say,
whoa,
Mr. Cook is going to call Ms. Lewis. I may want to not excuse her. If that's possible with her.
Right. I given everything, I figured that's probably going to be the case.
The people we call Angel Lewis.
All right, hold on before we go on to Angel Lewis. Otherwise, Mr. Goldstein's going to take a nap in my courtroom, and I don't want that.
Do it. I'm doing it.
What'd you say?
Do it 1 o'clock to Judge Slays.
Yeah, no, I got you.
That's the schedule.
That's it. And I have
Judge pauses for a second. Going to do some
Yeah.
quick.
Mr.
Insert a case.
Stewart, you're going to have to step back and bring somebody from in custody. And just so that we're clear on my previous statements, I was always happy to see from Mr. Smirsky is Mr. Goldstein. That's the problem.
I do. It's going to be in Judge Slays' courtroom rather than this courtroom.
Okay, thank you for clarity.
Yeah, chief officers. If they did.
Sorry.
Man office. When was that today?
Correct. But they understand if I grant it, what's gonna, maybe.
Yeah.
Okay. Court does call the case of the people of the state of Michigan versus Stefan Scott.
I'm just trying to get this one case done. We could fast forward this, but I'm curious what.
David I.
it's about.
Goldstein, appearing on behalf of the defendant.
Scott. All right. Two things here which kind of dovetail onto each other. There's a request from I believe coming from the people to adjourn the preliminary examination, but also at the same time, there's defense counsel's motion to withdraw.
Oh.
All right.
Your Honor, just briefly, actually, I did file a motion to withdraw. That was at the request of the defendant. He indicated he no longer wishes to be represented.
Is that correct, sir? Okay. So you would understand that your preliminary examination, which is set for today. Well, let me ask this. Are you going to represent yourself?
No, sir. This was supposed to happen at the last court date. I don't know why it didn't happen. At the
What was supposed to happen?
withdrawal.
The withdrawal?
Well, the reason, Your Honor, is I did make an oral motion to the judge. It wasn't you. The judge requested that I file a written motion.
Yes. Okay. So you understand, though, sir, that
your hearing goes
if
on.
I grant the motion to withdraw, in this case, that your preliminary examination will be adjourned. You understand that? All right. And is that what you want me to do? This may take care of your portion of it also. All right. So I will grant defense counsel's motion to withdraw. Mr. Wilson is discharged from any further obligation in this case.
I'll bring the order tomorrow morning, Your Honor.
Thank you. I believe, and Mr. Scott, you can help me here. I think at some point you were represented by Mr. Killowald.
My last court was Sam
Bernstein.
And was he appointed to represent you, sir?
Yeah, he was my lawyer when I first got here last year. Back in April.
Gotcha. So is that what you see?
How many cases do you have, man?
Your Honor, it's a little confusing, just so the court understands. There was a prior case, which was started last year. Sam Bernstein was appointed to represent Mr. Scott. Subsequent to the exam, I was then retained. That case was dismissed, and then this case was then charged at that point. So Mr. Bernstein was never on this case. He was
on the other case. And I think, though, what we had is the
We can fast forward a little
PD's
bit.
off Killowald.
They'll figure this out.
Substitution for Mr. Killowald in this case. So
we're gonna fast forward a little bit. There we go.
you would understand that your preliminary examination, which is set for today. Well, let me ask this: are you?
Yeah. Sorry, I went the wrong direction. He's still there. He's still there.
And that she is available August 11th at 2.
See, this what
No, she always does that. Every time she walked into the courtroom, we're all smoothly going along, and then we have to put on the brakes.
all in.
Yeah, all right.
All right. Is defendant none?
On the 11th.
They're still starting to sort out his new court date.
12, 1, you know what I mean?
We're already on
We're
the
on
date.
the yeah.
And then we will look and make sure that counsel happens for you, and then you'll be contacted.
Okay.
Okay.
Done.
Thank you.
Back
Bye.
to our trial, preliminary trial,
Oh, sorry, sir. No, you good.
which I think is going to get a judgment of acquittal.
Sorry.
That one warrant I needed to do. So the warrant, I'm going to go Court's gonna stand in brief recess. Let me take care of one matter before you bring the next witness out.
Okay, court goes to recess. We're going to skip ahead. We're catching up. Here we go. All right, judge comes back out here just a minute. Can you believe all this is happening with an empty courtroom? We need people there.
You may be seated.
What?
What?
See.
Judge is in a good mood. That might change.
You
Let's
may
see what
call
this
your
next
next
witness
witness.
does.
The people we call Angel Lewis.
Angel Lewis.
So the
witness number
record is
2.
clear. We're back in the record in People versus Clark. Yep.
Please talk
Main
loudly,
court.
ma'am.
Good afternoon, ma'am. How are you doing? Good. Just one thing, make sure we're speaking up. You have a microphone in front of you. We need to make sure that that's recording and getting everything okay. Thank you. I want to start off by asking, do you know an individual by the name of Michael Clark? How do you know that individual?
I work with him and he did Peyton.
Peyton, last name Trelpa? All right. And how long have you known each of them?
Peyton for over a little, maybe over 2 years now. And Michael, maybe a year, if that.
Do you see Michael Clark in the room?
Yes.
Can you please point to him and identify minor article of clothing that he's wearing?
Wearing a black tie.
The record may reflect this witness has identified the defendant.
Record shows so reflect that objection.
How would you describe your relationship with the defendant?
We were cordial when he was dating Peyton, but that's just mostly it. I respected him. He respected me. I was mainly trying to stay.
I want to draw your attention back to February 11th of 2026. Do you remember that day?
Yeah.
All right. And at that time, where did you work? Were you working that day?
I was working that night, yes.
What was your shift?
11 a.m. to 5 a.m.
What time did you get to work that day?
I got there a little early, around 10 to 10:30 to complete schoolwork before my shift.
And just be clear, is that 10:30 at night or 10:30 in the morning? Did you observe anything happen between the defendant and Peyton that night?
When I arrived the parking lot, I put my car in the park and was facing the lot where all of our ambulances sit. And I witnessed Peyton pull up in an ambulance, quickly stop, run out of the truck, and run into the building. And I observed the defendant running after her at full speed.
So let's go a little bit more into detail on that. How far away were you from all of that happening?
Yeah.
And when you say that Peyton was running, how fast?
She was as fast as she could get within short distance from our door to the door to the garage.
And what about the defendant? How fast was he going?
Full run from what I could see.
Full run, huh?
Other than the two of them running, were any of them doing anything? Or were either of them doing anything?
And then was reaching his hand out while Peyton was going through the door.
Sort of made a gesture there. Can you describe what that gesture was?
Hand out like this.
And that's your right hand?
Come back to me. Like that.
Right hand up.
Okay. How far away from Peyton was the defendant when he reached towards her?
Close.
Were you able to hear if anything was said between the two of them? After you observed this
Someone
interaction, what did you
shouted,
do
"I
next?
just want to cuddle."
Tried to get my belongings, which had my work badge, so I could go into the building and find Peyton.
Did you find Peyton?
I did.
Where was Peyton when you found her?
She called me and I found her in the resupply room.
Roughly how long after the incident in the parking lot?
Judge is
or
chewing on
let
a
me
pen.
rephrase this question. How long did it take you to find Peyton?
Getting into the building maybe 3 to 5 minutes.
When you found Peyton, could you describe what her apparent emotional state was?
Very distraught. She was shaking. She looked like she was on the verge of tears.
The judge.
And I
asked
don't
questions.
want you to say what exactly was said, but did Peyton say anything to you?
Yes.
Was her voice steady and calm? Was it quivering? What was her voice like?
Was halting and wavering.
Did you observe the defendant in the resupply room at any time?
No.
Other than that incident in the parking lot, did you observe the defendant at all that night?
No.
And how do you know it was the defendant that was behind Peyton in the parking lot?
I saw his face and I recognized from the side that it was him.
How long did you have to look at the individuals in the parking lot while that incident was occurring?
40 to 50 seconds maybe.
We can have just one moment, please, Remember?
Yeah.
Brian Koberger is seeking to withdraw his guilty plea. Would like the state to refile those charges, including the death penalty, and take it to court. Didn't see that coming.
I'll pass the witness.
All right.
Says
Hang
it
on
was
before I just
ineffective
want to make
assistance
sure
of
I
counsel.
understanding of what you're telling me. Peyton pulls up in an ambulance to one of the garage doors. And you see her do that? Okay. And at the point you see her do that, where is the defendant?
I hadn't seen him at that moment. She got out of the truck and that's when he's from behind the row of trucks that we that face came off.
And how long did you see him for? How far from the point at which you see him to the truck that Peyton's in, how long a distance is that?
Maybe 5 to 10 feet.
And he was
So-
full on sprinting 5 to 10 feet.
And so the time at which you saw the defendant was that 5 to 10 feet,
Yes.
and then he came. How do you know he was at a full sprint?
I could see him running from behind the truck. It's like when I saw him going from behind the truck,
Okay.
he's right next to me there.
Okay, but you described it as a full sprint. But you, right, okay, and I'm not necessarily cook, but you didn't see him in an open area sprinting, right?
There is a gate that is see-through that we have, and between the row of trucks and where I saw him, where the door is, where Peyton was trying to get in.
Okay, I get you, but when I just asked you, you saw him for a distance of about 5 to 10 feet, right? Would you agree with me that if I'm observing somebody for 5 to 10 feet, that I really can't make an assessment that they're running at full speed? Mr. Simon.
The first time that you spoke to the police about this incident was the 16th of July, is that right?
That sounds correct.
The police first contacted you then about anything you might have to say about this, is that right? And you would agree that
5 months had passed since February 11th.
Yes.
Had you reviewed anything about this case prior to talking to them about this observation of yours in the parking lot that night? Had you reviewed any writings? Had you reviewed any videos, anything like that?
Not seen any.
Judge Simpson asked you a question just now. I think I understood your answer this way, so I'm going to ask this very particularly, and if I confuse you, put your hand up, say, I don't understand. It's important. I think you said you saw Peyton from the time she had the ambulance parked pull up to the building. Am I correct on that?
Sure.
Yeah, you were in the parking lot when she moved the ambulance from the parking spot that it was in to the building?
Seen the ambulance roll too, so.
Did you see Michael at that time in the parking lot somehow going after her?
She.
Okay, did you see him hand her ALR? Did you see him go up to the door, hold up the ALR, and for her open the door and grab it from him that she had dropped or anything like that? Did you see that? Did you see Michael walking? I'm gonna do this pace. Watch me very carefully. At this pace.
Because we have video.
Up to the ambulance where Peyton was at the truck bay. If I played you some video. I'd like to see if it refreshes your recollection at all as to what you may have seen in the parking lot.
Oh my goodness. There's got to be a TV show just about.
I'm gonna have to object for the purpose of refreshing her recollection. I don't think she ever testified that she didn't remember.
Oh, I think she actually did. About
that she didn't remember.
seeing Michael.
Yeah, I mean, I think she did. Kind of just, well, quite frankly, there have been two different statements. So go ahead, Mr.
Roll tape.
This is not very long, ma'am.
Watch carefully.
And there's no audio, by the way.
We should get to see this one. Okay. Here comes
I'm gonna pause real quick.
That's the
You see
victim.
an ambulance leaving a parking spot, right?
That's a lot of ambulances.
Stay with me. Do you see an individual, right? I'm circling with my cursor who's walking.
Yes.
Are you able to tell from the walk or the shape of who that is yet? Okay.
Ooh, the dead sprint. Ease up there, buddy. Ease up. Slow it down. Slow it down, man.
Can you tell now, man?
Not exactly.
Can you see the time of day and the date here?
Yes.
Would that be consistent with the time of day that you were in the parking lot?
Yes.
So this would be the time.
If that were Peyton in that ambulance, and if that were Mr. Clark that we saw, would that be consistent with what you observed? Would that be consistent with your memory as to what you observed about Mr. Clark in the parking lot?
In the parking lot. Yes.
Okay, and then
So he
from
didn't
that
sprint.
bay where the car is parked now, where we last saw it, where the ambulance parked, to the gate is about 5 feet. Would you agree?
In person, it's
Closer than me and you right now? About the same distance? Okay. Okay.
Did he start sprinting there in the snow?
Ma'am, I'm sorry, Mr. Simon, but you would agree that if the individual that we saw in that video was Mr. Clark, and that the ambulance that we saw pull in was the one that Peyton's in, that individual is not at a full sprint. Would you agree?
I would agree.
In fact, not even necessarily
He's
a
barely
fast
walking.
walk. They're actually just walking across. Agree with that? Yes? All right, go ahead, Mr. Simon.
Your Honor, I can play some additional snippet of that video. It's fractured, unfortunately, that could tie this up. But I will admit, as I showed to Mr. Cook, there's a 30-second gap that is unaccounted for. So if I can just play another section of this for you, ma'am, which is the front end of what I didn't show you. See if it will help you identify the people involved.
Okay, go full screen. Go full screen. Come on. Can we see this?
Actually, I'm going to speed this up.
There we go.
You know who that is by the Walkman and the gear?
Okay.
Okay, well, let's watch her where she goes.
Surprise, surprise. I'm guessing she's going to that
She
first
running,
one
by
on
the
the
way?
left.
No, she's not.
Okay.
She hits the
Do you
alarm.
see that the lights of this ambulance came on and flashed?
Yes.
Is that consistent with use of a key fob? And then, can you tell by who that is right there, the male at the bottom? Yeah, sorry, that's when the gap is. Right there. No offense, by the bald spot, or the body posture. Can you tell who that is? Okay, and that all is consistent with the very same vehicle we saw at the end that was pulling out, etc. Okay. Can I ask about a different subject matter?
Please.
You're Peyton's roommate, yes? And you were Peyton's roommate in the fall of 2025. And in the fall of 2025, Michael started to hang out at your place at your guys' invitation. Would you agree? I'm sorry, Peyton's invitation, and even spending the night. Would you agree? And the three of you were pretty good friends. Would you agree? Well, you referred to him as sister husband, right?
Something being started, I just go along with it to make her happy.
Oh, okay. Well,
Sister
you're pretty
husband?
defensive of Peyton. Is that correct or not correct? Well, the way you answered that question, let me ask you this. Did you ever put a sticker on Mr. Clark's locker? Do you know who did? Did you see it happen? You ever supply information to another person about a biohazard sticker being placed on his locker? Did you ever tell anyone you did do this?
Well, Peyton that I had heard someone else that did it.
Did you tell her you did it? Do you know who? Strike that. Would you have known Mr. Clark's high school nickname? Have you ever heard the nickname Tobus? Have you ever heard Peyton circulate that to anyone else? Have you ever heard do you know anything about this case in terms of its case number? Do you have any idea what's the date on the complaint of this case? Okay. Have any idea what any of the court dates were? Have you ever heard Peyton exchange that information to anyone else, you or anyone else? Is it fair to say, being roommates, you and Peyton are like probably the closest she's the closest of your work friends? Okay. Thank you. I have nothing else.
Biohazard sticker, had you seen it? You have not seen it? No. Did management
Nobody saw
at
the sticker.
HCA talk to you about it at all? By HR? About the sticker?
He's self-soothing his way
When
through
you
this.
were questioned, did they show you the sticker?
No.
Just questioning about the sticker never showed it to you. Go ahead.
Man, when you say you saw the defendant running, would that have been
a lie?
Well, let me phrase the question this way. You saw the video that defense counsel played to refresh your recollection, correct? Did that capture the entirety of what you observed? The running that you saw, when did that happen in relation to the video?
It started as soon as Ayden was going towards inside the door.
She doubles down. She could have said it was in the
if we
30
need to,
seconds.
we can put the video back up. After the vehicle well, I don't know if I'll need it just yet, but after the vehicle comes back around, comes to a stop, were you able to see Peyton at any point at that point? In the video, were you able to see her? All right. And so it's
judge.
After then that you're saying is when you saw the running?
Okay, she doubled down. She could have said before.
I guess I'm trying to figure out when this full sprint was. I see in the video, we see the ambulance basically come toward the camp, correct? An individual then approaches that from this court's perspective looks like Mr. Clark, right? From my observation, and at some point they're along the side of that ambulance, right?
Where the snow is.
Is it from that point that the sprint happens?
One Peyton is outside of the ambulance door and halfway in the garage door to the side that's not the actual garage door. That's when he tried to get closer.
Okay. All right, go ahead.
Nothing further, Your Honor. Thank you.
Anything else? Go ahead, yes.
One question. Distance from the door of the ambulance that pulled up to the front door of HVA. Hold on, I'm not done. I'm going to approach you and you say closer, further, okay?
Maybe up there.
Okay, and I would estimate that's about 8 to 9 feet.
Yeah. Okay.
Thank you.
So he walks
Anything else,
50 feet.
No, Your Honor.
And
I
then
step down. Thank you.
Dead sprint 8 feet.
I don't know.
That makes sense.
I don't have to vote.
This witness may be excused.
Your Honor, people call no further witnesses and would rest at this time.
Maybe the people should drop their charges.
Depends.
Here we go.
I'm moving for a directed verdict at this time. I realize the bench trial, but in the court.
We're about to get one.
6.419D.
Save your breath. I think you've already
It
won.
says that a judge in a bench trial can render a directed verdict, not on the traditional standard, but by saying the people's proof didn't make it beyond reasonable doubt. Weirdly, inexplicably, in the scope rules, that rule doesn't seem to be included in the district court rules. Why? Because most of the bench trials happen in district court. I've actually talked to the SCAO. Nobody can explain the oversight. And one day before I actually die or retire, I'm going to make sure that gets fixed. But the point is, it's what I call the cut to the chase rule, because it allows a judge to say, instead of even on traditional standards of no reasonable minds can differ, look, if it's not there, it's not there. I'm asking the court to use that standard, but even the other standard, I don't think the people have met their burden. All of this requires a state of mind that somebody actually possessed the state of mind that Ms. Trelfa tried to
project,
display, or tell people she had, but none of it was so. It wasn't so because the span of time from 2/5 to 2/12 really shrinks down to those 2 days and those 2 contacts. It really does. They're going back and forth on other things, including the return of his property. And she doesn't, but the way that we know I'm right, Your Honor, and what I think you can use in making and granting this verdict, directed verdict, is the cuteness in what she tried to be. What do I mean by cuteness? Plain cute, insultingly. She started that on February 22nd. I didn't think she'd dare continue to today, but she did. She told the police, we didn't date, but just for a few weeks.
how his reaction was crazy. And then even she continued that in court under oath before your honor. And even getting to that, she tried to parse it out. Well, sexually romantic and dating is a very different thing. I called him my boyfriend in December, but we weren't dating. She still maintained that. She was cute about the presents in the locker. Didn't do that. And then when I refreshed her, okay, she didn't remember. Oh, no, I didn't leave a present for the locker because I gave it to him. Well, you started by putting it in your locker, right? Yes, that's where you intended to find. Yes. This goes to witness credibility in her true state of mind at the time. She used terms today like speed walking. Well, that's what I think it was, speed walking. When she told the police on 2 separate occasions he chased after her. And on today, thankfully, she told the truth about February 7th. He didn't chase after her. He came up, knocked on the door, said, "Can I speak to you?" She got out and talked to him. It was just not even close to what she told law enforcement. I think that it's fair to say she played cute with your honor when you kept trying to figure out how come she contacted the police and when. And then she finally answered, okay, well, the HR told me to make the report, and she clarified as to when, but we had to poll for that information. How about this one? Did you contact him while you were on vacation? No. You sure? No, absolutely not. You didn't text him? No, I didn't. Well, let me refresh your memory. Yeah, no. That's because my friend, whatever. I mean, she played so cute with that and tried to actually say that her reaching out to him in text messages at first wasn't really a reach out. You couldn't have been clearer in your questions. I couldn't have been clearer in the questions. All of this adds up to what her true state of mind was. In fact, what's really a tragic thing here, Your Honor, is the lack of investigation of this case that could have supported so many things. But thankfully, I think we've established them here consistent with my opening. She was annoyed maybe a little bit, but having a broken heart and being wrongfully accused of something isn't criminal. I mean, here's a guy who had this great relationship, or he thought he did, and he's trying to talk to her and vindicate his name. And it turns out that the person who, quote unquote, whistle blew on him confessed. She confessed. I lied. I made the whole thing up. She's an interferer in the relationship. And how we get I say it's a 2-day period. At maximum, it's a week, but it really isn't because there weren't continuous contacts. To stalking on a criminal level, I think on the people's most favorable interpretation of the evidence, it just isn't there. But now I want to talk to that lack of evidence. There are so many points here that could have been helped by this case. The February 7 video that I was not able to get and tried, and law enforcement didn't try until April, and then they said, oh, it's no longer available. Nobody ever tried to get the February 11th video except us, and I had to go through Honigman lawyers representing HVA to get them only last night. Law enforcement has far greater authority than me, and they could have gotten that. And how about this one? The text message, the screenshot, I'm sorry. She provided all text messages to law enforcement. What about on February 22nd, it was communicated to police that she called him that night. What's the follow-up on that? Where's the evidence of that? How come nobody has to look at her phone? Because had she called him on February 2nd, Your Honor, and she doesn't deny that there's an incidence of her phone calling of her phone, she just can't explain it. That also goes to her state of mind. Lastly, Your Honor, the biohazard sticker. Okay, there was dancing around that sticker. Your Honor had a hard time getting a direct answer.
He still can't keep a straight face.
I had a hard time getting a direct answer, but who could possibly have populated those fields of information other than Ms. Tralfa? Now, maybe she supplied it to somebody else to do that. But she also told us today, before I showed her anything, she expressed knowledge of every detail that was in it. The case number to the SM, the nickname, the dates, the pretrial date, And then she said she's never seen it. And then she even said that HR never told her what in it specifically. Stop it. So, Your Honor, on any standard by which you have it, before I call law enforcement and not only ask them what they were told and why they were led to believe the case was A when it was really B, and then more importantly, what they did not do, I'm asking the court to essentially cut to the chase and grant the motion for directed verdict. This is not a credible witness. And the only thing I think you can reasonably believe is that she wasn't of the state of mind that's required by the very limited context.
But if I were to rule on your motion for a directed verdict, I have to take all of that evidence, maybe rightfully or not, in the light most favorable to the non-moving party. That would be the people.
I actually think the drafters of that rule think otherwise, but I admit what I said.
So, which rule?
6.419, which says if you think the proofs aren't here beyond reasonable doubt.
Right. However, you're also right as to its applicability here in district court, which just, I don't understand it myself. So.
But even still, yes, Your Honor, that's the traditional measure. And even still, I just don't think that it suffices.
Mr. Cook. Thank you. Your Honor, I would agree that the proper standard here is light most favorable to the people under 6.001 and the applicability of the court rules cited by defense counsel. I think the court, viewing the evidence in the light most favorable to the people, could find a verdict of guilty here, frankly, based off of the text messages alone. On February 5th, the very first text message, the victim is saying, I can't do this anymore, Michael. I'm not doing this again. This is nothing but pain and suffering. February 9th, the victim again texts the defendant. I told you once and I will tell you again, I do not want to talk to you nor have a conversation about any of this. And then a little bit later that same day, I will not talk to you anymore nor text. And I expect the same again on February 9th. I will tell you once more, I do not want to talk. End of story. On February 9th, the defendant responded saying, I'm sorry that you don't want anything to do with me or this conversation, but I just needed peace. I think that's an acknowledgement that he understood that the victim didn't want to have any communication with him and that she wanted no more contact, but he persisted anyway in sending many more text messages. Again, on February 9th, the victim told the defendant, I thought I was very clear in my multiple statements of I don't want to talk. This is all I have to say. Again, please leave me alone. Fast forwarding to February 11th, the defendant admits to leaving coffee in the locker for the victim. On February 11th, the defendant also says, I'm going home. Don't worry. Not going to have to deal with me anymore. I believe that shows that the defendant had that altercation in the parking lot, while the exact nature of what happened in that parking lot on a different standard may be up for review. I think in the light most favorable to the prosecution, that the victim felt afraid of that interaction. The testimony of the victim, as well as Angel, shows that at least afterwards in the resupply room, the victim was shaking. She was emotional. She was on the verge of crying, I believe was Angel's testimony. I think on page 14 of People's Exhibit 1, the defendant says, I know you hate me for sending that. Thank you. If you read it, you don't need to reply. I know you won't. So he knows that this is causing her distress, but continues to reach out and recognizes that he's doing it for his own gain so that he can find peace while denying her peace. I believe, like most favorable to the prosecution, a directed verdict of acquittal would not be appropriate, and I would ask this court continue and hear evidence from the defense before rendering a judgment.
Yeah, the problem is that that's cherry picking. Mr. Cook was reading those February 9th messages and then he left this part out. When I said you could try and I wouldn't, that meant I'm trying not to reconcile this, and no matter what you do from now, there will be no second chances. And that string ended with, I did not understand that's what you meant by you could try. Everything up to that point, Your Honor, is an exchange that is not, don't do this. She was told him, she acknowledged, you can keep trying. I'm not going to fight for this. You can. And he did, and he tried. And after that, there's a single text on February 10th. I hope you're doing all right. Have a great day. And then February 11th, we all know what happened on February 11th. Your Honor, I don't think under any standard that meets stalking. I just, there are some behaviors that can be annoying. There are some behaviors that can be whiny and maybe, no offense to people, wimpy or whatever. When we do things with a broken
Judge is
heart,
laughing.
Lord knows, I tell clients all the time, don't make admissions. So I'm not going to make the admissions of things I've done, but it doesn't mean they're criminal stalking. That's a different standard. That's something different. And that's why I say under any standard, this should be
Dismissed
the
with
motion should
prejudice.
be. Also, I know Mr. Cook left out the whole phone call thing on the 22nd. I think if any fair interpretation of the facts is that she placed a call to my client on the very day she reported this to the police. Also,
While I'm listening to everything, the one thing that was sort of remarkable is Mr. Simon's belief that he has a heart to be broken. All right. So, what, and I do absolutely agree, actually with both sides. I think the standard that I have to apply is I have to take the evidence in light most favorable to the non-moving party, that being the people, in ruling on this. When I look at it, and while it might be slim, I think a reasonable fact finder, were they to believe certain things,
no way,
could conclude that the offense of stalking, I mean, barely, you know.
It's no secret why we're not covering it. We've said it for weeks.
Could make that finding regarding stalking, for the reasons as stated by the people.
So he's bound
and
over
so
for
for
trial.
those reasons, they will deny the motion, and we can proceed on. I am going to take a very brief break to decide whether or not defense wants to put on it.
That's fine.
So the court will stand in.
Thank you.
We're not covering it. We've said this for weeks. We're not covering it. We're not covering it. We encourage you to go somewhere else to watch it. We're not going to cover it. We're still not covering it. If you're here more often, you would hear why we're not covering it. But don't be surprised that I'm not covering it. I literally, of all the things I tell people in advance, that's one we've talked a lot about. It has child victims. We don't do well with those cases. Our audience, our community doesn't like them. They don't watch them. They feel miserable when they do, and it's incredibly heavy. It's depressing. I mean, people quit watching true crime because of cases like this. There's a lot of reasons, but yeah, we're not going there. Let's see what he rules on here. See if they put on a defense.
All right. The 14A District Court of County of Washington, I'll say the next, and now that, yeah.
You may be seated. We are back on the record in the case of the People versus Michael Clark. Are there any witnesses for the defense?
No, Your Honor. Defense.
All right. Closing arguments.
Thank you.
And I'll keep this brief as the court had just heard arguments on the motion for directed verdict. And I would incorporate the arguments made there, except as it relates to the standard of proof, in my closing arguments. Outside of that, I know the court heard a lot of contradicting testimony today. Contradictions both from internally with their own testimony, as well as some contradictions between what the witnesses testified to, and contradictions between what the witnesses testified to, as well as some videos that were shown. I'm not asking the court to overlook those contradictions, but what I think is not contradicted, and frankly was difficult to contradict in general, are the text messages that were sent and the communications in real time as they were happening. I know I already went over the text messages contained within People's Exhibit 1, and while opposing counsel says I cherry picked some of those. I was emphasizing some of them. I would invite the court, if the court feels appropriate, to read through all those messages again to get the sense that Peyton was having and the ongoing attempts to cease this communication, this contact, that were not respected by the defendant and his recognitions thereof. As it relates to People's Exhibit 3, the text messages that Peyton sent to her supervisor when this incident, or right after this incident occurred, I think it's telling that she says, I'm shaking and he won't leave me alone. I think that goes to her state of mind, that she really was afraid of and concerned by this defendant. I think adding in the context that she is a young, I believe she said 20-year-old woman at night walking to her rig on her own with a man, her ex, following her, who she had told not to have contact, but he's following her. I believe that would put a reasonable person in fear and would lead to that feeling of intimidation, threatening, harassing, molesting, etc. All the language that the court is aware of in the jury instructions that the police have to prove. Normally, again, I would walk through each one of the elements and what evidence shows those elements beyond a reasonable doubt have been met, but I know the court has listened very attentively to all the testimony and the court knows all of the elements. So I would just ask the court consider all of that when rendering its judgment, and I would ask the court find the defendant guilty of stalking. Thank you.
Mr. Stein.
Just really briefly, I'm not going to repeat what I said on the motion for directed verdict because that was essentially a closing argument.
So this
I
isn't
just
a
want to say
preliminary.
in
This is
terms
a
of the
trial.
last
It's a full bench
argument from the
trial.
people, and if Ms. Truffa in fact communicated she was shaking, I don't know that we have to accept that that was truly occurring, or that there was really a reflection of a state of mind or fear or terror, because it could have been a reflection of the emotion of the situation, that this is the second time they'd seen each other since the breakup only 6 days earlier of a strong and steady relationship, until somebody interfered with it, and interfered with in kind of a vile way. And also, Your Honor, in my opening statement, I said we got to this place because there's a great amount of embellishment, and I believe the proofs supported that. And, you know, the duration of the relationship, what it was really like, the gift giving, what it was told to the police, what it was really like, how about this one? How she got onto his shift. I'd forgotten that in my list of cute, what I say, cute things, or playing cute things, how I phrased it. I'd forgotten that one, and I don't know how I'd forgotten that, because that one, Your Honor, is a multi-layered onion. Just to refresh the court, she didn't just say that he was responsible for the bid switch. She said that was before they were dating, false. She said she had no control over it, false, because she accomplished it. And she then said because she was only a D-lister. In other words, I couldn't do anything about that. Then, of course, she acknowledges that, yes, it was her, but she didn't even answer that question. And that really goes to her credibility. And then when pressed further, she said, yeah, 2 weeks later, I did express my happiness that he did turn down the other job that would have kept us from being on the same shift. Your Honor, the true state of mind was this. It's what she said, and it's responded to the court's question. It was, I reported this to HR. They said, when we got back from vacation, they brought me in. They said, you're probably going to want to make a police report. She did make the police report, but the report she made and the truth were two very divergent things. They were embellishments. And I say to Your Honor that what I said in the motion, from February 5th through 9th, he's doing what she authorized him to do, fight for the relationship. And February 10 and 11 are really why we're here. I don't think that meets, by the reasonable doubt standard, the elements of stalking, because it's not a willful course of conduct. Willful course of conduct to harass another person, and there were no threats or any other adjectives in that are in the statute. So I asked the court to find him.
Anything else?
All right, Judge, you need to think about this one.
All right. The court listened very closely to the testimony. I don't think there's really an issue as to the elements of stalking and what those comprise and what they can comprise. The real question in this case is a belief by the court that what was going on here was that the defendant was indeed stalking Peyton. Frankly put, I don't believe that the defendant had the intent to stalk her. I don't believe that the defendant, even by his actions and what he said, did indeed stalk her. I think what happened here, and I think it's
All right, we got some verdict music to kick off the week as Judge Simpson is about to give his ruling in a bench trial where, man, I'm going to say, I don't think he has the capacity to commit the crime he's charged with. If he was running after love, he was never going to catch it at that pace. Yet the spurned lover, the fellow hospital, or excuse me, ambulance employee, whose heart was crushed and devastated after his ex falsely claimed that they were back together and going at it. She turned vindictive, I think. She flipped the tables, flipped the script, blamed him for everything, turned things he was doing just normally into something that might have been a crime, went to HR, then went to the police, and then went to court. And HR may have believed her. And the police may have believed her. The prosecutor sure did. But the judge, thank goodness for the judge had 2 ears and a brain between them. And when she started spinning those stories, he asked a few insightful questions, and that was all he needed to give us the look which we know and love from Judge Simpson. And now he's going to give us the verdict as he lays down the law here in this case.
Probably an appropriate term that Mr. Simon put forth, that there's all of this embellished to make it look as though this is something far beyond what it is. And it's not until this process that Peyton and, quite frankly, Lewis, in terms of some of her statements, gets called on get called to task as to what's really being said. Mr. Simon called it being cued. I think that when you're in a court, you testify as to certain things that you indeed have to.
Other people call it perjury.
That you indeed have to tell the truth for what it is. The contact with the police and with HR prior to vacation, when I started pointing out the dates, he began sort of obfuscating when exactly she could have contacted, somebody advising her to contact, but then she's on this vacation and she doesn't do it until at some point she comes back, and then somebody from HR does something, tells her to do that. Could have happened that way. I don't think it necessarily happened that way. I also think that had she been in great fear, HVA would have done something very different, and that she would have contacted the police if she believed that this individual posed that kind of threat. But you look at what she was trying to do. Going to make this relationship as short as possible, so that there's no explanation as to what might be the defendant's behavior vis-a-vis me. So that if I lessen what this was, he shouldn't be acting this way because it was really nothing. We spent all of the time questioning the length of the relationship. It was very clear that it was January. Just said January, which would have made this basically a month or a little over a month long relationship, only to find out that this relationship then went back, covered two major holidays, well, including New Year's. I mean, but just covered
three.
Thanksgiving, Christmas, certainly, may have gone back to Halloween, but certainly Thanksgiving and Christmas. And all of those things were covered. But then when caught on that, on the time, she wanted to play a game. And this is the court resented it, quite frankly, of playing game as to what kind of relationship this was. Was it a romantic
sex, but
relationship?
no
Was it
benefits.
successful? She's kept using these words to try to again say that, yeah, while we knew each other, it wasn't that. And then finally, it just had to come down to, we spent, in my opinion, a great deal of time trying to sort that out. And the court had to specify particularly that it was it was a romantic relationship and a sexual relationship. And finally, she had to answer yes. I don't know why that couldn't have been answered at the very beginning. The exaggeration of the gifts being sent was also hugely problematic, particularly if it's relayed to the police that he keeps sending me gifts, but he's sending Valentine's gifts that he's already ordered and she knows they're coming. It's almost as though what she's doing at that point is attempting to try to set him up. That all of a sudden these gifts will come in and now he's going to have to go back and he's going to have to show that he ordered these well before any type of breakup. But quite frankly, I think that if it had come down to that, your breakup would have occurred at a different point. Because I think she moved the calendar to fit what she wants to show. The other part, because I also believe that not only was this victim, and I'm not one in the victim bashing, I think that if somebody were truly the victim of stalking and somebody's doing something like that to them, that ought be clearly, it should be, that person should be held accountable. But by the same token, when somebody's attempting to try to then say you're doing these things, and this will happen in workplace relationships, to attempt to try to damage not just this relationship, which may have fallen apart and it's nothing there, but also just to damage the ability to work. Your employment, whether it be that employment, your future
Almost becomes
employment,
criminal.
and the like. I said the things that I'm not happy with what was said to the court, but I think they were outright lies.
Perjury.
And I'll just put it bluntly in regard to the work schedule. Even when called on that, she listened to it. She tried to go around on that, tried to find a way out of it until, to his credit, Mr. Simon got her pinned to the point that she couldn't say anything else. But yeah, okay, that's right. Shouldn't take that much for somebody to just tell the truth. Other problem, the bio sticker and the label. This is where I had problems both with Peyton's as well as Miss Lewis's testimony. I think they were, I don't believe for one moment that two people got called into HR, 4 supervisors, questioned about an item that they've never seen. That makes absolutely no sense. And I don't even know how they could then speak on it. But then you listen to Peyton and she's going through each of the things that is on it of something that she has never seen, been questioned about, but has never seen. Do I believe that? Absolutely not. I think she came before this court. I think she lied. I think Miss Lewis was complicit in that lie. And she was going to try to do anything for whatever the reason. And I'm not saying, Mr. Clark, I don't know you. I don't know if you're an angel or not. I don't know any of that. But what was clear to me in this case is there was this attempt to try to destroy you in some way. Regrettably, in that whole thing, also is really problematic to me. All of that starts from your ex-wife. Because all of this just flows from there, and it just becomes this thing that frankly doesn't make the whole thing doesn't make any sense. Taking anything that you do, and going back to Peyton, taking anything that you do when you're looking at trying to contact her regarding retrieving your property on the 12th, well, all of a sudden that turns into your stalking. No, I'm trying to get my property. I'm trying to make it clear. I'm trying to make it clear as to when I can do it and what I can do and everything. That doesn't make it stalking. I don't know that. And again, I don't know where the line is often drawn, but usually one can tell that when a relationship breaks up, parties may want to try to find a way to get it back together. I'm not even sure at the beginning of this breakup that it was a breakup. I'm glad I'm not here to call that. Because I think if you tell somebody, yeah, we've been together, but I'm mad at you about whatever I'm mad at you. I'm not working on it, but you go ahead and do it if you want to. That means you've got to somehow, what that says to me, maybe in my old fashioned way, is that says you got to somehow or another woo me. You got to win back my trust. You got to do that. And then you go about trying to do that. And then next thing you know, it's not working. And then she just says, it doesn't matter what you do. I'm going to make it clear what I meant, which I think given her testimony here, I don't think that that's what she meant at the beginning. I think it's something that changed. And it changed to try to get you to do something. Well, this court's not going to have any part of that.
Yeah.
And, just plain and simple, she wanted to put you into the system for whatever the reason. And you had a whole lot of folks out there just mad at you. So sometimes I just say be careful.
Have better taste to me.
For those reasons, the court does not believe that people have sustained their burden, haven't shown, frankly, in this court's mind, the major elements of stalking. So for those reasons, the court would find that the defendant is not guilty of this charge. The defendant is further released and discharged from any further obligation to this court. Thank you.
May I approach to retrieve the exhibits?
Yes.
Prosecutor, you may have more evidence of perjury than you have evidence of stalking. Oh my goodness.
Did everybody else clear out there?
Yeah.
Yes, everyone else was.
Okay.
All right. That's Judge Simpson's morning.
That being all I have, 14A stands
adjourned. All right, now I think Judge Clark is about to do something. Is it not Clark? Excuse me. Judge our Romulus judge, Judge Oakley. There we go. Hang on, I need to go back. Wait, until they stand. Here we go. All right. Oh, we need to go to 6, though. There we go.
And I thought it was 1:45, not 1:30. And when you showed up here this morning,
Give him a minute. The judge is going to come in.
that he was given.
We're going to talk about Koberger in just a minute. I'll read you a letter. He wants a trial. He wants to withdraw his guilty plea. We'll talk a little bit about what his reasoning for that is.
And it doesn't fall. I should be telling him.
I don't think it'll go anywhere.
Well, it should have. I've had that happen before, so I was staying up too quick.
All rise, 34th District Court back in session. I will get with you guys.
Good morning, sir. How you
All
doing?
right, Mr. Hadley, your appearance for Miss Miller.
With Miss Crystal Miller, stating her name.
Thank you. Go ahead.
For the people who are in the arraignment, we have reached a resolution on this matter. So we spoke with the prosecutor. She did print out the attendance record. It's consistent with what my client stated. It's a couple months of school. So we're not contesting that. We stand humble pretty much before the court today, as much as anything else. And when the court's ready to hear us, my client, I would treat us brief allegation.
Thank you. All right, Miss Miller, you understand your rights and options? You understand the possible penalty for this charge? And understanding all of that, are you pleading guilty freely and voluntarily today? All right. Son or daughter? What's his name?
Okay, maybe we don't want this one. We're going to bail. All right. I'm sorry. I thought it was something else. New York Times letter, just so more people will talk about BK. Possibly, we're going to talk about it. It worked for us, so we're gonna bring this up. This comes from an interview, I guess, that he did with somebody from the New York Times, and this was a letter or something that was sent to them. This is Brian Koberger writing this, I believe, and it says, over a year later, it is self-evident that in State v. Koberger, justice was not served. Unanswered questions seem to multiply with each piece of discovery unsealed, and the public demands the truth. Unfortunately, the truth shall never be derived from the state's myopic narrative, a work of fiction which has yet to evolve since the PCA was released nearly 4 years ago, and its faulty premises were never challenged at trial. Circumnavigated by a broken plea, the trial never provided the public the clarity conducive to closure, and justice shall remain abjectly miscarried unless that plea is withdrawn. I hereby declare my intention is to enter a not guilty plea and welcome the state the opportunity to prove their case at trial, as well as to, again, file for the death penalty. My actual innocence is my truth, and the plea, hinged on by false promises and blatant disinformation, must be withdrawn. Thank you for all who believe in my innocence and continue to critically analyze the case. I send my love to my family, who have never wavered in their belief in who I am, their belief in my innocence. Now, let me just say, I'm not red pen, right? I'm not an English teacher, but there is something strange about how he writes the first 2/3 of this letter. He's almost making the argument for us as trial watchers, expressing our frustration with not getting to hear what actually happened, with not actually getting to understand the facts of the case and what the evidence showed. And he's sort of citing the misinformation and the conspiracy theories and everything else that still abound out there in spite of his guilty plea, saying that we can't get to that peace that we need without having a trial. And so that's when he steps in sort of in first person and says, so I am going to ask to withdraw my guilty plea and ask for a new trial, face the death penalty again and ask for this new trial because I'm innocent. Oh, and by the way, ineffective assistance of counsel. He won the lottery. He won the Publishers Clearinghouse lottery of free lawyers. And he's claiming ineffective assistance of counsel. They worked their butts off for him. I don't think that argument's going to fly. I just don't. What do you guys think? Blamed his guilty plea on false promises and wrong information. It's just wild. He has to convince the court that he has the right to appeal this. He's trying to cost the state more money and get death penalty so his life will end with him as a martyr. I don't know. I don't know what his reason is behind it. I know he doesn't like prison. Like, of all the people that prison is a punishment for, Brian Koberger is the top of the list. He is not doing well in prison. He does not do well with people around him. He doesn't do well by himself. He doesn't do well with the limited amount of flexible time and scheduling and everything else, and the chaos and noise of prison. There's so much that he hates about it. It's asked to be moved and transferred, and he's not getting his the food that he wants. It is a punishment, a big punishment for him, and maybe it is. Maybe he is saying, I'd rather face the death penalty and to get the death penalty than this. I'm not sure. I mean, he'd still serve 10, 15 years minimum in prison before the death penalty is carried out. Yeah, prison sucks. Maybe Chad could build him a portal. There's an idea. If only they got along. Can he even do that? I don't know. I think the judge will, if there's an actual motion filed, a letter to the editor at New York Times is not sufficient to grant this sort of change. But it could do something. Possibly. I think the judge will at least address it. All right, Judge Clark is, I think, done with that. Let's see where he's at right now.
Okay.
What are we doing with Ms. Brown Beelan?
The case is being dismissed.
Ms. Beelan, that's all right with you, I assume? We can dismiss? Have a nice day.
Dismiss. Go home. No, just leave. It's dismissed. You don't.
You stop downstairs if you like to get happy to order.
Mr. Armour, we're going to adjourn this till the 24th?
Next month. I'm so possibly this. Yep, I have September 28th.
September 28th work? We'll get you a notice.
They're just moving everything around. All right, let's see if we have anything else to look for. Simpson is not live again yet. Let's see if Kansas is. Or Thurston. Or Boyd. Oh my goodness. Judge Wiggins is doing something.
Spanish.
Yeah.
Yeah.
Sorry.
Rehabilitative programs, reimbursements for the cost of prosecution, and governmental expenses. Do you understand those charges and the potential penalties?
Yes.
On
Let me
felony
back up and
complaints, you have
hear the charges.
5 years in prison and or a fine of $1,000 to
Back up. I need to hear the charges.
All right, person at the jail, please state your name for the record.
Jonathan McGrew.
This is case number 26-3131 FD, the people of the state of Michigan versus Jonathan Earl McGrew. Sir, did you have the opportunity to meet with somebody from the public defender's office today?
Yes.
And it looks like you met with somebody from community corrections and gave them some contact information. Was that information accurate?
Yes.
I have a complaint that alleges that on or about July 26, 2026 in Springville Township of Wexford County, Michigan, it's alleged in count number 1 that you committed the offense of marine safety operating while intoxicated causing serious injury. That is a
Boating
felony
drunk.
punishable by up to 5 years in prison and or a fine of $1,000 to $5,000. The court to indefinitely suspend the privilege to operate a water vessel and reimbursement for the government for emergency expenses and the cost of prosecution. In count number 2, it's alleged that you committed the offense of operating while intoxicated or impaired as a second offense. That is a misdemeanor punishable by a fine of $200 to $1,000 and 5 days to 1 year in jail or 30 to 90 days of community service or both. In rehabilitative programs, reimbursements for the cost of prosecution and governmental expenses. Do you understand those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you can consent to, and the right to stop answering questions at any time. You have the right to be represented by an attorney, and if you could not afford one, one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
Likely hire one.
You have
I do
financial means?
consider that you consider giving me bonds. My family really needs me at the moment.
Well, sir, we'll get to that in a moment. So do you have the financial means to hire an attorney?
Yes. Should be able to.
You can sell your boat if you're not allowed
All
to
right.
boat anymore.
The court will enter a not guilty plea and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove 2 things. 1, probable cause that the felony had occurred, and 2, probable cause that you were the person who had committed the felony. If the prosecution is not able to do that, the felony charge would be dismissed. But if they are able to, you'd be bound over to stand trial in circuit court on both charges. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the community. Also, I believe the praxis scores him at a risk level 2. And due to my schedule this morning, I was not able to get through the criminal history. Any comment regarding bond from the defender's office?
Yes, Your Honor, thank you. Mr. McGrew and I got to speak earlier. He informed me that he has been in the area for 12 years. He has family in the area. He takes care of his 3 children as well as his elderly father. He has his own business doing flooring that he has had for 25 years. As you mentioned, the praxis scores him at a 2 with only 1 prior conviction. So we would respectfully request a PR bond. Thank you.
Thank you, Ms. Dole.
Your Honor, I believe he was a danger to the community. He has an OWI for 2023, which is not that long ago.
He has a prior operating while intoxicated.
Under the referral statute in 2015. In this case, there was a PDT that has him at 0.194. The allegations are that he was operating a boat and was pulling his dog. When she was taken by ambulance, he drove his vehicle and was told to come back, and when he came back, the field sobriety tests were done, PDT was done, and arrested at that point. So there was a blood draw, so we don't have the results of that, but we do have the PDT, so it's very concerning, the facts of this case. I do believe daily testing is appropriate in this case for alcohol, considering he just had an OWI 3 years ago. And this involved a serious injury. I do believe a monetary bond is also appropriate to ensure the safety of the community and to make sure that he is not a flight risk. Thank you.
How much time elapses between the boating accident and law enforcement encountering him?
When law enforcement arrived, he has not driven yet. She was just being taken into the ambulance and about to be driven off. So I imagine it wasn't that long of a time from.
So then he drives a vehicle after that?
Correct.
Allegedly.
Yes.
I did not. I got this
Hold
car
on.
with my son.
Mr. McGrew, you had the right to remain silent, so I want you to exercise that right because anything you say can be used against you. So I want to make sure you're protecting your rights there. And also just understand anything that the prosecutor is presenting to me is for bond condition considerations. So, and the child, as far as we know, is still at the hospital.
I don't have any further information besides her needing surgery, so I imagine she's still in the hospital if that's the severity of her injuries.
All right, Mr. Grew, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm going to order no alcohol. Given that you have a prior drunk driving in your past, I'm going to order daily alcohol testing. The court does find that Mr. McGrew presents himself as a threat to the community, but I believe we can mitigate those. So I will authorize the personal recognizance bond with those conditions. So Mr. McGrew, at some point, you're going to be released from the jail today. You're going to need to come over immediately to the community corrections office located on the ground floor of the courthouse and get signed up for your testing requirements.
Okay.
Now, if something happens that you are not able to retain a lawyer and want the court to appoint one, you need to let us know and we will make the referral to the public defender's office. Your attorney that you hire will not receive any communication from the court until they actually file an appearance. So make sure they're aware of your next court date, and you will have that court date before you leave the courthouse today.
Okay.
Do you have any questions for me about your bond conditions?
I mean, is there any way we can do that machine daily? Because
So that's the daily testing. You'll be assigned a machine and you'll be ordered to blow at certain intervals throughout the day.
Okay.
All right.
Yep.
All right. Thank you. Next arraignment.
All right, let's switch. Who dis? Magistrate Cadenella's personal meeting room. Magistrate Rogers. It's the Michigan State Seal. Who dis? Hello, sir.
Sir, the Grand Traverse County Jail, could I please have your name?
Hi, Maxim Mickiewicz.
So I will call case 268006 FT1.
Why does she sound like she's in
Mr. Mickiewicz, you
jail?
are appearing for arraignment purposes this afternoon, and you're appearing with Ms. Mistley, who is the defense attorney with the Michigan Indigent Defense Commission, here to assist you. Ms. Mistley, did you have the opportunity to review the allegations on the complaint, nature of the offense, and possible maximum penalties with Mr. Mickiewicz?
I did, and we will waive further reading of the felony complaint.
Tank top in
Under
court.
pleas of not guilty and request assigned counsel, please.
It's funny. The Zoom courts are quite informal.
So in that case, that not guilty plea will be entered on your behalf. In order to complete a petition for assigned counsel, I need to place you under oath and ask you some questions. Can you please raise your right hand? Do you swear that the information you're about to give will be the truth to the best of your knowledge?
Yes.
Thank you. You may lower your hand. What is your phone number?
867-5309.
And your mailing address?
123 Sesame Street, Anytown, USA.
Center.
And your email, sir?
It is to be deleted at yahoo.com.
MAT.
No, that's not it. To be deleted.
At gmail.com.
Or Gmail, either one.
At the address you provided, are you renting, buying, or living with others?
I'm living with my mother.
Right now I'm living with others at the jail.
Are you working?
Currently not. I'm seeking employment.
Options are limited in the jail, though.
Do you have any sources of income or assistance?
No, currently I do not. I'm just living at home with my mother.
Do you own a vehicle?
I do not. Or the vehicle was ours, and I was on her policy.
DUI.
Do you have any money in a checking account, savings account, or any cash on hand?
I do not. I have very little money, if any, very little to none.
In that case, an attorney will be. So in that case, an attorney will be assigned to you. I will remind you that you have the right to remain silent. Anything you say orally or in writing can be used against you. You have the right to have an attorney represent you and to have the attorney present at any questioning. If you cannot afford an attorney, one can be assigned to represent you. If you have the right to have that attorney represent you at all future court appearances. You have the right to a preliminary exam. In this case, it will be scheduled on August 11th at 11 a.m. and that's in person here at the district court. You will also have a probable cause conference scheduled for August 4th at 2 p.m. You should be hearing from your attorney within the next week, so if you have any changes in your contact information, you need to let the court know immediately. Not only is that where we will send your notices, but it's also the information that we will give to that attorney in order for them to reach out to you. Do you understand that?
Yes, Your Honor.
In that case, Ms. Mistley, it does appear that bond has been set in this case. Is there any further comment regarding bond?
Well, yes, we are asking the court to review the bond. You previously said, I think just yesterday, at $25,000 cash or surety.
Whoa.
This gentleman has no prior criminal convictions. At home with his parent for the last 9 years.
He's lived at home for the last 9 years.
Does know he needs to get back into some mental health services, and he is interested in doing so. He had a pretty low PBT when he was tested at a 0.06. Well, certainly this is a serious matter. $25,000 cash or surety seems excessive to me and far beyond that, which would be necessary to assure his appearance and compliance with bond conditions. I would suggest to the court that a 10% bond, which would be the least restrictive, perhaps it's available here, that would be far more appropriate than a cash or surety bond. Thank you.
Ms. Missy, I did set the bond at a 10,000 cash surety.
What did I say?
25.
25.
Sorry. Same reasoning applies to the 10,000 cash or surety. Thank you.
You're welcome.
Okay, we're going to
switch. The cash surety bond was set because of the court is concerned about the serious nature of the case. Yes, the PBT was fairly low for this type of situation. However, the allegations improve what I would consider a threat to the public safety in general. It also included a car accident, so it's very lucky that there was not any further injury in this case.
All right, so she's leaving it. All right, got another case, Wiggins.
The person at the jail, please state your name for the record.
Okay.
My legal name or my God-given name, sir?
What is your name? What name do you go by?
I go by Squirt.
All right, Squirt, were you also known as Wyatt William Briggs at one point?
I was. That was before I was born in the light of Jesus Christ.
All right, this is case number 26-3134 FY, the people of the state of Michigan versus Wyatt William Briggs,
5 minutes
aka
ago.
Squirt. Mr. Briggs, did you have the opportunity to meet with somebody from the public defender's office today?
I did, and I told him I didn't want to talk to nobody unless I was talking to a Native American red blood. With the Council of Four Fires, please and thank you.
All right, well, Mr. Briggs,
you know
I
what
have
Mayor
a
of
complaint.
Cadillac, Michigan is, sir?
I'm sorry?
Said, your face is frozen, sir. I'd like it to move.
I didn't hear what you said about Cadillac, Michigan.
So, who's talking to me right now?
Give it a second.
That's what I fucking thought. Fix your shit. I ain't talking no more. I told you fuckers, there's more going on at play right
Corrections, are we froze on your end?
The courtroom is not frozen, but you are.
And you're frozen on my end as well. All I've been able to see is his forehead. So,
Squirt's forehead.
I'm going to put you in a waiting, and we just lost Zoom.
You know, I've been telling you motherfuckers, let me out of this hellhole.
It is storming outside.
Yeah, I don't give a fuck if it's a storm or not. It's God pissing on all you bacons.
All right, Mr. Briggs, are you able to hear me now?
I can see you moving too, sir. Yes.
All right.
That
I have a
fucking with
complaint.
everything, ain't it?
I have a complaint that alleges that on or about July 26, 2026, in the city of Cadillac, Wexford County, Michigan, it's alleged in count number 1 that you committed the offense of malicious destruction of fire or police property. That is a misdemeanor that's a felony punishable by up to 4 years in prison and or a fine of $5,000. Mr. Briggs, I understand that you may not agree with that charge, but based on the information the prosecutor has, that's what's been presented to the court. In count number 2, it's alleged that you committed the offense of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. Sir, do you understand that that is what you have been charged with? Not that you're guilty of it, but that's what you've been charged with and what the potential penalties are. The court will make reference for the record that the defendant is moving his fingers across his lips, as in zipping his lips shut. So the court will consider that as a mute, enter a not guilty plea, and will set the matter for a preliminary examination. The court will also appoint counsel for the defendant. Mr. Briggs, you do have the right in felony cases. You do have certain rights. One is the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time.
No, I don't, because I don't have an attorney present right now, sir.
You also
Thank you for saying that.
have the right to have an attorney appointed, and if you cannot afford one would be appointed to represent you at public expense.
Not unless they're red
They
blooded.
are required to repay a portion of that expense. You also have the right to represent yourself or to hire your own attorney. As I said, the court will make the referral to the public defender's office for the appointment attorney, as I do not believe allowing Mr. Briggs to represent himself would be the best decision to be made today. We will set the matter for a preliminary examination. That's where the prosecution is required to prove to the court 2 things. 1, probable cause that the crime had occurred.
Get out your
and
calendars.
2, probable cause that you were the person who had committed the felony. If the prosecution is not able to do that, the case will be dismissed. But if they are able to do that, you'll be ordered to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to be considered for bond. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Mr. Briggs, you're muted, but I can see you pointing to your wrists. I assume you're showing me some sort of marking on your wrist. Am I correct about that?
I'm not speaking to you if you're gonna keep muting me like a dog. I'm a human being, I will be treated as such. Who keeps muting me then?
It is not me.
I'm not talking.
All right.
I'll be treated like a human being and I'll act like one. If you guys are gonna treat me like a dog in the
All right.
streets
Any
looking for a
comment
ride
regarding
home,
bond from the defender's office?
No, Your Honor, we were not able to speak to him. He indicated he did
y'all
not.
better let me out.
So
I ain't done nothing wrong to be here.
Thank you.
I was
Ms. Dahl, any
hitchhiking.
comment?
I didn't get hit
from
by
the
no cars
prosecutor's
either.
office?
Yes, Your Honor, I have serious concerns about safety of the community and flight risk in this case. The defendant
Mental
was
eval.
found walking on Mitchell Street in the middle of the day with lots of traffic around and waving cars past him while he was walking within a lane in traffic. When he was contacted by law enforcement and told that he could not walk in the road, he started cussing at the officers and using profanity at them. They arrested him, and while he was in the patrol vehicle, he damaged, he was hitting the inside of the patrol vehicle and damaged the door to the point where the officer was not able to actually exit the driver door and had to crawl through the front of the patrol car and exit through the front passenger door.
What?
So the front driver's side door would not open due to the damage.
You damaged it that badly on the inside?
There's also damage to the rear seat camera and the rear driver's side door, along with the front driver's side door. And they don't have an estimate at this point, but I imagine based on the level of damages, it would be in the thousands. So in this case, I do believe he is a danger to the community. I do not have criminal history convictions for him, but his behavior today is extremely concerning. I don't know if this is a mental health crisis or what is happening, but it's very concerning, and I'm concerned for the safety of the community. So I believe a monetary bond is appropriate. I don't know if drugs or alcohol are involved in this case, but I am concerned something is an issue here, whether it's mental health or drug use, since it's very concerning behavior.
He's trying to talk.
I would ask for no weapons or firearms while this case is pending, and also no threatening, intimidating, or harassing behavior, and also community correction services.
He's like,
if he needs any services, hopefully they can direct him to it. Thank you.
All right, the court does find, based on the presentation of Mr. Briggs today, that he poses as a flight risk and a threat. His actions today are
off the chain.
And the courts believe that he does pose as a threat, along with the allegations contained in the probable cause affidavit and presented to the court today. Mr. Briggs, as a condition of your bond, you are to appear as ordered, to keep your contact information current, not leave the state without permission, and to commit no new crimes. You are not to consume any illegal controlled substances, and you'll be subject to random testing. You are not to purchase or possess any firearms or weapons, not to act in any threatening, intimidating, or harassing behavior for the time being until I know more. The court will set bond at $10,000 cash surety. Ms. Dahl and Ms. Austin, I'm going to ask you, because of the way the arraignment went today, do you believe that today's hearing would satisfy the requirements for an arraignment?
Your Honor, I do. The court advised him of his charges and the penalty. I don't believe he had any issues hearing the court. I think he had some objections that were not relevant to being able to understand the charges, and him not wanting to speak would be a sign of him pleading you to the charges. So,
Ms. Austin, do you agree with that?
I agree, Your Honor.
All right. Thank you. Thank you, Jail.
Wow. So that happens. My name is Squirt. Oh man. What's the date? What's the date he's hearing at? We might have to. I think he needs a mental evaluation. I'm pretty sure either he's using drugs or he needs some medical intervention in some way to get things fixed up. We started late, so we didn't really take a lunch break. What do you guys want to do? We could go down to Judge Boyd's courtroom in Texas.
The caseworker are not seeking to terminate.
If only we could read.
How about his rights? They were seeking to terminate his rights.
Yeah, they're not seeking to terminate either one.
Would that be a possibility if he didn't get his visitation with?
The problem is he hasn't had his visits in the last 6 months. And those visits, the children look forward to him every week. Now, I understand mom is going to say, and I've heard
family
it in court,
law, so we're going to jump to Judge Middleton.
The electronic version.
See what Middleton's doing. The echo's terrible in this courtroom, but we miss him. Trying to see if Thurston or anybody's up.
All right, we have this and then a brief criminal matter.
What you got?
And then we'll get ready for tomorrow. I think I need a vacation.
Me too. Where should we go, Judge? Just you and me, maybe fishing, golfing?
You're outside
How
of
much of a
when you're on break because you look like you have a lot of sun.
Yeah, I live at a lake
Oh, let's
and
go
I have
fishing
my
then.
grandchildren and they'll swim for 12 hours at a time. So that's a lot of it. Then I'm outside working on things. And it was hot and sunny.
Yeah.
Well, if they're going to come, I wish they would come.
We're waiting for somebody. Here's Heather.
How do I do this?
Just push the camera on button.
More. How do I turn on my
Good afternoon. This is Judge Middleton.
Hello?
Are you sitting in a completely blacked out room?
Hello? I am trying
Yeah.
to figure this out.
Maybe take the
All
tape
right, well,
off.
maybe you should have practiced a little before.
Got something up. The judge is talking. I don't know if we're in the right spot. There's like a pinkish, mauvish color.
You're in the right place. You're in 3B District Court. I just can't see you.
So you guys see her?
Video.
I can hear you.
Oh, because yeah, she's like, how do I get my video to come up? But okay.
Maybe take the tape off the camera.
You're the plaintiff. You're late for your own hearing.
And now you're gone for your own hearing.
Now I can't hear you either.
Unmute
So we're-
yourself.
Oh, geez.
All right, just hold still for a minute. Who am I speaking with?
My name's Heather Stapp.
And Miss Stepp, Do you work for Hog Slat?
I do.
What's your position?
I am store manager.
Please raise your right hand. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, sir.
All right, this is file number 26871SC, Hogslat versus Magley Farms. Magley Farms made a purchase from your business and supplied a check which bounced in the amount of $2,321.06. Has anything been paid on that check?
No.
It's still due and owing?
Yeah.
What did they buy? Do you remember?
They purchased basically like a feed line supplies, like a motor, stuff to
automate like a cattle farm,
yeah,
chicken farm,
stuff to. I guess they were gonna do it for like some beer bottle stuff. I don't know, but we use it for hogs, feeding hogs.
Okay.
So
pig farm.
So
all right, they are not here. They were served by their resident agent, and they're aware of it. Even though I can't see you, I know that you're there. I find by default that the plaintiff is entitled to damages in the amount of $2,321.06, plus court costs of $86.25 and $60.89, for a total judgment of $2,468.20.
Okay.
Now, they have 28 days to pay that, and then you can pursue collections, which would include a discovery subpoena. If they do not pay, contact the court clerk about getting a discovery subpoena to compel them to come to court. Now, actually, under the bad check law, you can sue for 3 times the amount of the check plus $250. You didn't do that. You simply sued for the amount of the check, and I respect that. But they could be sued for 3 times the check plus $250. So they're lucky that it's just the amount. You just want to get paid for the service and product rendered. All right, I've given you your judgment by default, and if they do not pay within 28 days, contact the court and ask about a discovery subpoena.
Okay, I appreciate it. Thank you.
All right, I know you run a busy store, but I've been sat there for 19 minutes waiting for you to show up.
I am so sorry.
All right, you'll get
I
your
apologize.
order. 246820.
24601. There we go.
All right, thank you.
Thank you.
Could have sued for 3 times the amount. Instead, just went for the actual price. So now they got a judgment saying they should be paid that money, which is what they should have been paid when they they already were owed that money, but now the court recognizes it. So they have to. The hard part, the easy part is getting the judgment.
Hi,
The hard
Sergeant
part's
Army.
getting
Could I
collection.
see Amy Richards? This is Judge Middleton calling.
Judgment.
Amy Sue Richards. All right, thanks. Bye. Somebody's coughing in his ear. All right, Kim, that's all my small claims.
Yeah, we read the letter a little bit earlier. Ashley, that's it's crazy. I'm not sure if it'll be granted. I really don't think it stands a chance, but
I'm just going to leave this live stream on while I do this criminal matter.
what's your criminal matter, Judge?
Laura, you indicated how much money Amy Richards owes. You gave me something, and I don't know what I did with it. Thank you.
BK wants to withdraw his guilty plea.
Well, shows more than that. She's got some tickets, unpaid tickets. But shows 198 in this case.
No, not. I only saw a couple cases in there besides this one. I'm looking at the wrong person.
Shows impeding traffic
That's the one I had.
and 9 failed. That one I don't care about,
Okay,
but
that's
how much is show in this case?
$518. $510.
$510 on a traffic ticket?
510, okay.
510, sorry
All
about
right,
that.
thanks.
You're welcome.
All right, we're on the home stretch here. We're now waiting for the public defender to join us. When they log in, I'll bring the defendant in.
Gonna miss this judge. I know he likes, I'm not sure if he actually likes this courtroom, but for his last couple months in office, this is where he's going to, on the bench, this is where he's going to be, in this old, like 100-year-old courtroom with hand stenciled wallpaper. He loves the history of it, but it does seem like he got pushed to the background. When he should be, right in the best office due to his seniority. A lot of checks don't last a year. It's like some of them are like 30, 60, 90 days you have to cash them. I guess it depends on the state. Yeah, Squirt's a good name. It's our first Squirt we've had in court. Judge, we just chilling. Chillaxing. I'm not seeing a lot of other courts to jump to. Tomorrow we should have that, what court is it we're going back to? Josh was going to remember for us. It's on the calendar, right? It's a court we had last week that we're going back to tomorrow. Somebody remember for me, because I don't. I don't have to go back and watch, see where we were. It was that hearing with the lady judge. Wasn't it the guy that was accused of the firearms offenses? He's like, every gun he's ever bought has been legal. He had all the forms and everything for it, and he picked up some charge. Did BK cite takesies v. backsies? Pretty much. That and ineffective assistance of counsel, which is laughable because they were incredibly good. He says he was made some promises too, which is weird because he said he wasn't made promises when he took the plea. Brady B, member for 22 months, makes you an OG. 8 weeks and I get my Raspberry Courthouse. I'm so excited. Love you all. It's awesome. It's going to be 2 years. Hey, there's
Good
a court
afternoon,
case.
Ms. Richards. I'm waiting for the public defender to join us. And as soon as they do, I'll bring you back in, all right? So don't go away.
Yes, sir. Yes.
If that was a jail shirt, it's pretty nice. It's got like a picture of a boat on it and stuff. Looks pretty nifty. Judge Satterfield just went live as well. Yep, Judge Satterfield's in Kansas. She's got a room full of people.
Hi, Matt. This is Judge Middleton. I'm about to do an arraignment on Amy Sue Richards on a domestic violence. Could you log in for me, please?
We'd like you to be here.
Yeah, but I can't tell whether she did any other terms of her probation. All right, thank you. All right, bye. All right, the public defender said he would join us at 3:30. He might be occupied somewhere.
Let's do a quick arraignment. No lawyer needed.
One of the things you're supposed to do as a judge is have patience. And I've been working on it, but sometimes today I lost my patience and I feel bad about it.
Do we need to go back and watch?
I get too old to be patient.
I think we need to go back and watch.
All right, let's see who we got now. The jail and Matt Huff. I need the public defender.
We're going to go back. We're going to go back and see if we can find when he lost his patience. It's before this one.
And 4688, 49662.
Go backwards. I don't see him
Patient
getting really
versus
angry.
Gurren. Joseph
Of course, he
Gurren.
never has.
We're back to conduct our small claims docket, and we do have a criminal matter.
I only see one side present for the small claims. Yeah, I'm not seeing when he got mad. It must have been on another stream.
Keith Stickley.
Okay, we'll take this one.
For joining us.
Here we go. Sorry, no more jumping around for a little bit.
One day. All right. This is file number 231972SL. It's entitled People versus Amy Sue Richards. Is that you?
Kells Bells.
Yes, sir.
30 months.
Also
OG.
present is Mr. Keith Stickley, the Chief Public Defender, and Matt Huff, your probation agent. You were convicted of domestic assault by plea, and you were put on a probation with a deferral with anger management and other conditions. There were fines and costs that were due. You also have an unpaid traffic ticket. Anyway, Mr. Huff indicated to the court that you had stopped paying. So I set a hearing regarding payment, and you didn't show up for that. So I did a show cause hearing to show cause why you didn't come to the hearing.
And you didn't show up.
And that was in November of 2025. And I waited 48 hours and then we issued a warrant for your arrest. And apparently you got picked up last night.
We found you.
Where did you get arrested?
At my residence,
Which is where?
804 Jefferson Street. And
Well, we don't need all that.
80.
We don't need all that.
How did they come to arrest you at your home?
I have a very out of control 15-year-old. And I actually called the police on him and they came and arrested me.
I called the police on my kid and they arrested
And they
me.
found this old warrant?
I'm assuming so, yeah.
Oh, no. Ungovernable child.
I was looking at the file. I've been on vacation. And
Sandy Graham, thank you so much for
this
the 5
file
gifted
was given
memberships.
to me at about 5 minutes to 8 this morning. Shana always thinks I need more to do, so she likes to give me extra cases in the morning. And I was trying to resurrect what happened, and I couldn't really figure out what the deal was. You had unpaid fines and costs, and we were trying to collect on them. You stopped paying. Matt asked me to do a hearing. I set a hearing, you didn't show up. I did a show cause, you didn't show up, and we issued a bench warrant. Mr. Huff, what's her probation status?
Well, I mean, she has not paid on her fines and costs. I think the last report, I just got out of the file in case you need to use it, but I'm going to get back in there to make sure I'm speaking accurately. And I can't spell names. Let's try this again. Was April of 2025. I reached back out to her because I knew that we had some fines and costs that weren't paid. I was trying to get her onto a payment plan. She did answer the phone, reach out, explain that she had some financial hardships. So I had spoken with you about what we could potentially do before her probation would have expired. And we set this for an order for show cause, and then she failed to appear for that.
Well, it was the conditions that she pay the fines and costs, pay her unpaid ticket, which she has not done, and complete anger management and other conditions of probation. Did she complete the other conditions of probation?
I'm looking at my email here for the completion notice because I noticed it's not in the file with Data Reporting Center, and I don't see a completion notice. So I do not believe that Ms. Richards successfully graduated from that program, but she could correct me if otherwise. I don't believe that's the case.
Well, this is in an odd posture. It should be a probation violation.
It should be.
There should be now she was given 10 days jail, credit 1. I deferred 9 days. I had 9 days of jail hanging over her head. And it should have been a probation violation. I guess I'll accept responsibility for that once she didn't show up for the show cause. So she didn't complete the anger management course. She didn't pay the unpaid traffic ticket, which was a condition. And she didn't pay her fines and costs. But she's here just on a fail to appear for a show cause. Ms. Richards, yes.
The anger management center could never get me into a classroom. And I think Matthew remembers we had a lot of issues with that. And then I work for ServPro still. It's no excuse. I just never got those letters. Like I never got a letter for a show cause, and it's probably because I hadn't even moved yet, so I don't understand why I didn't receive the letter.
Well, but one thing you did, payment or other, you just went off the grid. You haven't contacted the probation officer since last November. You just went AWOL. Now,
Can I-
let's talk a little bit about your circumstance.
So I contacted him back in November. He had told me about my warrant, or December, I think it was. He had told me about my warrant. A week later, I was involved in a car accident with Servpro. And it was, I do storm disasters, so I've just been really busy trying to get my finances and I'm finally at a place where I can pay everything. It's taken a long time because I'm a single parent and I'm the only income.
All right. So right now, you got 9 days jail hanging over your head. You did a very poor job on this probation. You didn't do the anger management. You didn't pay your unpaid ticket. You didn't pay your fines and costs. And then you went off the radar. But you're in jail. You're going to lose your job. Your 15-year-old son is the son or daughter?
My son, but I also have a daughter in a pediatrics hospital right now at Pine Rest.
All right. So you need to get out of jail.
Yes, sir.
But you're going to owe me 9 days of jail if you're found to have violated your probation. You assaulted your previous partner. She was bloodied, beaten pretty badly. You were on a probation and you didn't do any of the things I asked you to do. So I said, I'm going to defer this. If you complete the probation, I'll take it off your record. So 2 things could happen. It'll go on your record, and B, you could do up to 93 days in jail, but I deferred 9. So what I'm going to do is...
I'm gonna lot, Mr. Middleton, I'm in a totally different place than I was 3 years ago. Like, I know I didn't do your guys' anger management, but I do a lot of mental health stuff on TikTok. I do a lot of different things for other people because of my situation that I was in.
Do mental health stuff on TikTok? Is that what she just said? Like I doom
You're
scroll
still
Twitter
on probation. We've
for my
never
sanity?
actually completed it. When they arrested you last night, did they give you any sort of a drug or alcohol test?
No, sir.
I'm going to give you fail to appear for order to show cause. 1 day jail credit, 1 day. I'm going to direct your probation officer to file a probation violation petition alleging that you have failed to comply with the terms of your probation. And I will arraign you on that, and I'll get a lawyer to represent you. But I want to repeat, you did a very poor job on this probation. It would enter as a domestic violence conviction. You owe at least 9 days of deferred jail, potentially more, if you're found guilty of this violation. But I don't want to leave you sitting in jail without a plan for your job or for your kids. So I thought about just arraigning on a probation violation right now, but I'm just going to give you 1 day jail credit, 1 day for failing to appear for the show cause hearing. Your probation is continued. Tomorrow, I want you to call your probation officer, Mr. Huff.
Yes, sir.
If you don't do that, I'm going to issue an immediate bench warrant for your arrest.
Yes, sir.
All right, let me repeat. I'm going to let you out of jail. 1 day credit, 1 day for failing to appear for the show cause hearing. You're still on probation on a domestic violence charge. You still owe the fines and costs. You still owe the unpaid ticket. You still owe the anger management class. I'm not going to try to resurrect this. It's 3 years old. You haven't done anger management. You haven't paid anything. So he's going to file a probation violation petition. I'll arraign you on that, appoint a lawyer to help you with it. But as for now, you're going to get out of jail. You're still on probation. You're to call your probation officer tomorrow or I will issue a bench warrant for your arrest.
Yes, sir.
Do you have any questions?
No, sir.
All right, you're good to go.
Thank you.
All right, Judge. What a one to finish on.
Thank you, Mr. Stickley.
Appreciate that, Your Honor.
Do we go up to Judge Satterfield or down to Judge
Thank you, Your
Boyd?
Honor. I'll have that status report done here in the next 10, 15 minutes.
All right, thank you.
Let's check on Judge Satterfield real quickly. She's putting her Zoom team together. Everyone's joining. Come on in. Turn on your cameras. Keep calm and carry. James Watts is present.
Good afternoon. This is the preliminary hearing control docket. Mr. Moody, who is your client today?
May it please the court, good afternoon, Your Honor. My client is Carly Meyer.
All right.
Where's Mr. Moody? I don't see Mr. Moody.
County Zone B, Butler, J1.
She's not down here yet, Your Honor. I'm getting her from the dorm.
Okay.
Man, everyone's joining. There's Mr. Moody, at least the top of his head. Today is Bald is Beautiful Day for about half of us. I'm getting there. Give me time. I'll be there shortly. Maybe it's a little thin there on back. Mr. Watts pounds whatever's left.
Is
Is
your client in custody? No, she's made bond with AAA. I see that now.
Oh, well, there's two cases, Judge, and she was in custody on Friday when I went to go see her. I don't know if she's bonded since then.
Okay. Well, the only one that's mine is 2026 CR 236, correct?
That's what I was just trying to confirm online, Judge.
Okay. Mine's a flee and elude, and she posted a $2,500.
Oh, she's being held on the other case, I believe, Your Honor,
Okay.
because the GPS monitoring is to stay with that other case as well.
Okay. So, but what I'm going back to is I want to make sure the jail knows whether or not she's actually bonded on our case and what she's being held on, which would be the other case, right? Amy, what is the other case that?
I believe it's 26 CR 66, Judge.
Okay.
It's a misdemeanor case, and so I think this current case in front of Your Honor is they're trying to revoke the prior misdemeanor case based on the new case.
Okay.
And that's actually it's Judge Webster's.
All right. Let me know when we've got her up here. What prosecutor's handling this case?
Oh, it's me, Your Honor, Cole Store.
Okay.
All right, this is taking forever. We're going to go down to Judge Boyd. This one. There we go. I think this is the defendant walking in right there. In black. Not sure if it's a bench trial or a jury trial. Make sure your phone's turned
White
off.
vehicle at units are speeding?
Yes, that's correct.
She brought her drawing tablet. No, it's a laptop. Never mind.
We'll see you tomorrow, sir.
The record now posting city exhibit number 2.
Judge. Let's skip forward till she turns her camera on.
1050, 250. Okay. And what years? 2020.
I'm not sure what she's watching. Somebody's talking up there on the bench. She's wrapping some stuff up. Sidebar, and then this trial's going to kick off. Defendant's far right. So Lady in Black is assistant counsel.
Officer Vasquez, you said, why are you waiting to conduct the search right now?
Oh, it's body cam. We missed it.
Okay, and is that in compliance?
Yeah, this one. There's the green purse for the day.
And Deputy Laura, the other inmates?
Looks like
He's the only one left. He is Anita.
Is that
Perez.
cactus leather?
All right. Just one moment. I'm sorry. I'm sorry.
We have a chatter who's related to the lawyer on the last screen. You saw somebody like on this screen?
Okay.
At 1:30.
Okay.
By Zoom.
And that is Judge Lee.
Yes.
Philip Weiser Law.
1:30 Zoom. Okay, so I can file a motion and set it for that for the bond.
That's pretty cool.
Officer Vasquez, this is a view from your dash cam? Yes. The speed limit on this road is 45. Yes.
I thought this isn't the beginning, is it?
You know what road it is? FM 78.
45-mile-an-hour speed limit.
Now you're performing a turn here. What did you observe? I observed a white vehicle.
Observe the defendant's vehicle traveling opposite lane direction at a high rate of speed.
The white vehicle that you observed speeding? Yes, that's correct.
So this is a speeding ticket that he took to court. He's fighting. It's an expensive ticket.
We'll see you tomorrow, sir.
Dude was
The
chilling
record
for
now
his time.
posting city exhibit number 2.
Oh, sir. Sorry, sir. I'm sorry about that. I know it was probably like 65.
Actually, it's a 45 horse speed limit. You're going 77.
You're going 77 and 45.
Any right here?
No, so it changes from a 50 to 45. So.
I'm sorry.
Okay. Here, come on. Where are you heading to right now?
The address.
Sure. Oh, what are you saying?
20.
Place. Where are you coming from?
College.
College.
She's going 77 and a 45. 32 over.
Oh, 210-716.
And I'm getting all messed up right now. Hold on.
It's like the first you see it.
Oh, okay, so and the recovery insurance.
The insurance probably come back to like
Group insurance?
my bad, like I'm on my mom's plan.
Okay.
It's like 4 months. Are you universal or
University. Also lost it. University.
I seen what was it, SAPD, they was stacked up over on 604. I don't know something about it now.
Man, I'm not too sure, man.
Y'all not like close like that department wise?
No. So we work within ours. Can you open your door so I can scan up the numbers?
And then no one's right there.
Yeah, but it's not scannable. So I'm gonna just scan the.
What about phone if you want there?
I was gonna just scan the sticker you have on your door. It's Infinity. 250. Okay. And what years? 2020.
Trying to get the body cam thrown out of this one.
He said the insurance is going to be under who else is name?
Christy, Michael Hill,
Michael.
and Sarah's on that. Everybody should be on that plan.
Okay, awesome. Right, I was like, 4333 60 46. That's your book.
Yes.
All right, go ahead and set up.
That's beautiful.
Yes. You have any weapons on you?
That was the issue.
So go ahead and turn on the generator, right? Turn on the generator.
Officer, for the record, what's the timestamp on the video at this time?
Every time I point out, I see those inside the defense like that.
Again? Zero two four. Thank you.
Okay, could you rewind that back?
I apologize, Judge.
Please don't talk over the video. The judge doesn't like you talking over the video playing. She's done that before. I'm listening to the video.
So we have 40 documents and those type of people and stuff like that, okay? And else here, which is fine. But, you know, it just didn't seem right to jump in. But that's fine. But also, for you understand that it's I just see nothing under arrest, you just beat the same. And whether the next step is something I have to say, that I'm very happy. You don't have any on you, that's just like.
What? Just location.
Just not with a search badge watch, right?
Officer Vasquez, you said, why are you waiting to conduct the search right now?
Waiting for a secondary officer.
Okay, and is that in compliance with your policy and procedures for your city?
Yes.
Okay. Continuing to
Judge,
Yes.
one of our motions was we're going to rely on documents that we need to give a copy to those. This might be short notice, but I don't have any copies of the policies and procedures.
Do you want copies of
The state house
policies
would
and
like to, but
procedures?
obviously I don't want to delay this.
Oh, no, I'm here to listen. So, did you bring policies and procedures with you? Oh, all right. How long will it take you to get policies and procedure?
Unsure.
All right. So let's do this. If you can step down and call whomever you would call to see where the policies and procedure manual is, if you all have one.
Verify. Great.
All right. Thank you. All right, so I'm going to let him step down and do that if there is no objection.
No
And then if they don't have a manual, if it's just something that people say, then that's what we deal with. All right, so if you'll step down and if you will see if there's a manual or something. And then counsel, if there is a manual, if you could let me know how long it will take to get the manual here. All right, thank you.
Okay, now she's in a break. No manual. Okay, it's a little bit quiet and dull this afternoon, but it is what it is. So tomorrow we're going to go back to whatever that court is where that guy was facing the charges for the firearms and bond violation for turning in a firearm after you called the police and said, should I turn it? How do I turn in this firearm if I'm not allowed to have it? They said, bring it down to the police station. He brought it to the police station. Then they arrested him for bond violation for being in possession of a gun as he was turning it in. That hearing's going to go on tomorrow. I believe that's where we're at. Yeah, I didn't see the message. I wonder why my message got deleted. I just said have fun at the wedding. I don't know. So that's some happy wedding ones. Yeah, I think she's back. Hang on.
That little item that was on your phone.
What I,
The item that we were trying to use to scan the registration sticker. What is that?
that's a electronic ticket writer.
Okay. So is that standard issue for Universal City Police Department?
Yes, it was issued to us for patrol.
Is it standards? I'm sorry.
It's for, so it was issued for the police department and our codes enforcement, and also fire marshals for our fire department.
Okay. And is it standard for you or standard for the department to scan the registration of every vehicle that you pull over?
It's common practice, yes.
Okay. And I saw, was there a problem scanning the sticker?
Yes.
Okay. And I saw you ask the defendant to open the door. Did you ask him to open it or order him to order it? Order him to. Okay. And he did comply?
He did.
Were you able to get a clean scan off of the registration sticker or the registration barcode on the inside of the door?
The barcode inside the door jam, yes.
Okay. And you do that for everyone, right?
Yes. If I can't scan the registration, I'll see if I can scan the barcode inside.
Okay. Okay, let me ask you, what time of day was this? What time of day was it?
It was 9.
Okay. Are you able to see the race, gender, or number of persons in a vehicle when it's driving by you at 70 miles an hour at night?
No.
To your knowledge, that could be anyone that was driving 70?
Yes.
Okay. 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 Judge, we'll just continue playing state exhibit number 2.
Said okay like 3 times. Okay.
Ask for a little bit of search. Wow.
Yes.
And I just overheard counsel say they're going to fast forward to the search. I would represent to the court if counsel is okay with it. This material is eventually put in the car before the search commences, I believe. We're not challenging anything after this. I don't think we need to. Obviously, it's their case, it's your court, so there's nothing after this we're challenging.
Okay.
And so I would object for that purpose too.
All right.
And the need to show anything else.
And if I may respond, Judge.
Yes.
I'm merely fast forwarding to show the amount of time in between the detention and the actual search. As defense counsel stated, the length of time, the prolonging of the stop was one of their contentions. I believe I need to show the amount of time that took place in order to rebut that.
In this case.
The objection will be overruled.
Thank you, Judge.
While she's watching this, just wanted to let you know that over the weekend there was a manhunt in my part of
Now
the
pause it
woods.
right
Again.
here. Officer, is this when you began the search?
Yes.
Okay. And what is the timestamp on your body camera?
0246.
And the initial detention was at 0240?
Yes.
So 6 minutes have elapsed.
Yes.
Decided not to go there because there was no audio for the police scanner.
Officer, answer this plainly. Was there any kind of racial motivation or profiling into what you did regarding the stop or the search or the detention?
No.
Judge will pass the witness.
Defense?
May I proceed, Judge?
Yes.
could make sure your microphone's on and pointed at you, that'd be great.
Is it Officer Vasquez? Yes. Officer Vasquez, I'm Jason Todd. I represent Mr. Hill. If I ask something that if I don't communicate well, just let me know. Sometimes I get a little excited or talk a little fast, or not loud enough. There's lots of reasons why you might not understand it. That have everything to do with me. So I will try to do things the best I can. But please, it's no offense taken if you need me to repeat them. Right? So on the stand, you said, and I just want to be clear, the only reason you searched the car is because of the smell of marijuana. Is that correct? Correct. Okay. And then in the video, what we're seeing though is that you mentioned that you're doing it because he appears sweaty, he appears nervous, he appears hesitant, that he could not see. And I listed a bunch. Do you need me to go through those one at a time?
Is that all that's on the list?
I'll go through one at a time. Okay. On the video, you mentioned that he appeared sweaty. Was that a reason for the search?
No.
Okay. On the video, you mentioned that he appeared nervous. Was that a reason for the search?
No.
Okay. On the video, you mentioned that you could not see into the back of the vehicle. Was that a reason for the search?
No.
On the video, you mentioned that he was hesitant in opening the door. Was that a reason for the search?
No.
Okay. On the video, you mentioned that you were uncomfortable with the situation.
Correct.
Was that a reason for the search?
No.
No. Okay. So the only reason you made the search was because of the odor of marijuana.
Yes.
Okay. You mentioned that it wasn't clear to me what training and experience you have in the odor of marijuana. Will you please list the trainings you've had in the detecting the odor of marijuana versus the odor of hemp?
So during my training at FTO, we made encounters and arrests off of marijuana.
I'm going to object to non-responsive.
Sustained.
Specifically, what trainings have you taken on detecting the odor of marijuana versus the odor of hemp?
I don't know how I answered the question.
Have you had any training specifically on the odor of marijuana versus the odor of hemp?
No.
Are you aware that for a time, and specifically at this time, that hemp flower or bud was legal?
No.
Okay. Are you aware
They're winning.
that hemp flower or bud has a similar smell to marijuana?
No.
You would agree that Mr. Hill was cooperative with you, correct?
Yes.
Okay. And would you agree that he was not nervous?
No.
Okay. So you would say that he was nervous?
Yes.
Okay. What in the video indicated that he was nervous?
First encounter where he kind of had to think about his age.
Okay. What else?
Then I asked if he opened the door so I could scan the VIN number. Hesitant. Okay. But from there, also sweating from where he was coming from. That he was driving a vehicle and he was sweating.
And I want to break that apart. You said sweaty due to where he was coming from. Is that what you said?
From where he was inside the vehicle. Sweaty inside the vehicle.
Okay. So because he was sweaty in his vehicle, you saw that as a sign of nervousness.
Yes.
Did he give you any other reason to be sweaty?
So he was coming from Gold's Gym.
Is there a Gold's Gym near this area?
Yes.
Is there a Gold's Gym on Pat Booker like he told you?
Yes.
So would it make sense that he was sweaty because he was coming from Gold's Gym?
Awesome.
Okay. Would it make sense that he was sweaty because it was July in Texas?
Yes.
So there's another reasonable explanation for his sweat, correct?
Yes.
You thought that he was hesitant in the way he opened the door, correct?
In the way he opened the door? No.
I'm sorry, the timing of opening the door or his willingness to open the door.
Yes.
Now, you said you couldn't read the VIN, is that correct? Under the window.
my ticket right couldn't read the registration.
So you could see the registration with your eyes. Your ticket reader had some sort of reason it couldn't read, correct?
Yes.
And then you come to his door and you scanned it inside his door, correct?
Yes.
Why did you go back to look at the front bin again?
So when I scan the barcode, it auto-populates the VIN number. And from there, not the registration, but the actual VIN number to match both that are correct. That they're the same.
Okay, I understand that. You tell me, why did you go back to look at the window? That's what I don't understand.
So there's your registration sticker, right? All right, at the bottom, there will be a VIN number. So I match from the code from the door jamb to the VIN number that's on the windshield.
Why do you do that?
So it's very common for, if you've heard of VIN swapping. So stolen vehicles or salvaged vehicles will be purchased, and a stolen vehicle will basically swap the salvaged VIN numbers to that new vehicle.
So you're checking to see if the vehicle was stolen?
I'm checking if the VIN numbers match from the door jamb and the VIN number on the windshield.
Okay. In your police vehicle, do you have a way to run the license plate to see if it goes to a particular car?
Yes.
Okay. Had you done that before, prior to the stop?
Dispatch did. I didn't manually type it in. I radioed in, and it will auto-populate on my cab.
Okay. What information did you get when you did that?
The vehicle's information, Mr. Hill's vehicle.
And did Mr. Hill's vehicle match up to Mr. Hill?
I believe so, yes.
And so when you went to the window, in your mind, this was a vehicle owned by Mr. Hill, correct?
Correct.
And then when he gave you his ID, he confirmed that he was the owner of the vehicle, correct?
Yes.
Why did you need to check for the swapping if at that point in time you knew the vehicle was his?
If I may. So there's been, so when it comes to VIN swapping, the registered owner will come back to the driver. Now, if there's any identifying marks, like if the VIN plate is not in the right position, or if it's fictitious, or if you can't see the VIN number in the windshield, you double check for that.
Did any of those things exist in the case of Mr. Hill?
At that point, no.
So there was no indicators that VIN had been swapped when you looked at the VIN?
After confirming both VIN numbers match.
I'm sorry, I guess I misunderstand, because what I understand you just to say is that if he had swapped out the VIN in the window, there'd be some sort of indicator. Maybe it's a skew, maybe it's scratch, or maybe it's something like that. And that would give you a clue that although this car registered to Mr. Hill and with Mr. Hill in it is not his car.
Correct. Or the wrong VIN number on the windshield.
So prior to scanning it, was there any indicator that that VIN was the wrong VIN number?
No.
Was there any indicator that the VIN had been tampered with?
No.
Okay. No further questions, Your Honor.
Brief your right, Judge.
Yes.
Officer,
Remind me
you
to
do
share
this ticket writer
another story
scan
with you.
for every vehicle you pull over, right?
Yes.
Did you coerce Mr. Hill to open the door?
No.
Did you order him to open the door?
No.
Did you draw your weapon and tell him to get out of the vehicle?
No.
Did you ask for consent to scan the barcode inside the door jamb?
Yes.
And what was Mr. Hill's reaction?
He complied.
So you had consent to scan the barcode inside the vehicle?
Yes.
That's when he smelled the weed or the hemp.
No further questions.
No further questions, Your Honor.
All right, is the witness excused?
Excused by the state, Judge.
Nothing else from the defense, Your Honor.
All right, thank you. If you'll leave the exhibits with the court reporter, please. All right. State, you may call your next witness.
State will rest, Judge.
Defense.
Defense rest, Judge.
All right, the court will hear argument.
Judge, the state reserves for rebuttal.
This is my motion, Judge, so
Yes.
we'll reserve for rebuttal.
Okay. In that case, I will go then.
Oh, officer, you're excused. You may step down.
That's funny. State wants to go last, and he's like, nope, it's my
Judge,
motion.
I have 4 cases that I would like to present to you for your review. They would be Pennsylvania v. Mims, citation 434 U.S. 106.
Okay.
U.S. Supreme
Johnson
Court
v.
case.
State, which is a memorandum of opinion out of the 14th Court of Appeals of Texas. And Stringer v. State, which is 605 Southwest 3rd, 693. And lastly, Morgan v. State, citation 906 Southwest 2nd, 620. I would like to present those for your review, Judge.
All right, thank you.
Inverted Lisa, or sorry, introverted Lisa. Might be inverted as well if we turn upside down. Welcome.
Judge, the state has the burden
Thanks for
to
joining
show
us.
that under 38.23, there is no illegality on behalf of the state in acquiring evidence against the defendant. And Judge, I believe that we have done that here. The traffic citation or the traffic stop was done legally. Mr. Hill was found going over the speed limit in a 45-mile-per-hour zone. I believe in the video he even admits that he was going 65.
I think he said 70.
When the officer came up to the window, he said that he smelled the aroma of marijuana coming from the inside of the vehicle. And that goes to Johnson v. State, which I'm sure defense counsel will bring up that there is no difference between the odor of marijuana and the odor of hemp. However, Johnson v. State says, and I quote, Officer Scaro testified he smelled what appeared to be marijuana, burned marijuana emanating from the vehicle while questioning appellant during a
All right,
traffic
you're
stop.
reading too quickly for the court reporter.
I'm sorry, Judge.
Thank you.
It is well settled that probable cause to conduct a warrantless search of a validly stopped vehicle exists when the searching officer, experienced in detecting the odor of marijuana, smells burned marijuana emanating from the vehicle. Appellant's probable cause challenge is founded on Officer Scaro's cross-examination explanation that he only reported smelling what appeared to be marijuana based on his previous police experience because he did not want 100% to say it was marijuana and be wrong, and that he could have been wrong about the smell, but probable cause deals with probabilities requiring more than mere suspicion, but far less evidence than that necessary to support a conviction or a finding of preponderance of evidence. The law does not require Officer Scaro to have 100% certainty that the odor he smelled emanating from the appellant's car was in fact first marijuana odor. Judge, the fact that there is no difference between the odor of hemp and the odor of marijuana is a moot point. Both smell the same, but marijuana smells like marijuana, and that is still an illegal substance under the state of Texas. Further, that goes towards Stringer v. State, which says, and I quote, a strong odor of marijuana from a small enclosed area, like a car, gives a peace officer probable cause to make a warrantless search of both the car and its occupants. As marijuana possession is a crime, its odor evidences criminal activity. Thus, the strong odor of marijuana may give a peace officer probable cause to make an arrest. And lastly, Judge, I believe to the defense counsel's point that he ordered the defendant out of the vehicle, I go to Pennsylvania v. Mims, which states, and I quote, the state freely concedes the officer had no reason to suspect foul play from the particular driver at the time of the stop, there having been nothing unusual or suspicious about his behavior. And we have specifically recognized the inordinate risk confronting an officer as you approach a person seated in an automobile. We think this additional intrusion can only be described as de minimis. The driver is being asked to expose to view very little more of his person than is already exposed. The police have already lawfully decided that the driver shall be briefly detained, that the only question is whether he shall spend that period sitting in the driver's seat of his car or standing alongside it. Not only is the insistence of the police on the latter choice not a serious intrusion upon the sanctity of the person, but it hardly rises to the level of a petty indignity. Pennsylvania versus Mims basically states that an officer can ask someone out of the vehicle during a traffic stop for little or to no reason. whether it be officer safety or whether to conduct a traffic stop in the back of the vehicle or to the side of the vehicle out of the way of traffic. Basically, Judge, this comes down to the officer performed a traffic stop. He smelled the odor of marijuana immediately coming from the open window. He observed the defendant inside of the vehicle. And I'll lastly go to Morgan v. State, which says, and I quote, "The VIN, which was the clear initial objective of the officer, is by law present in one of two locations, either inside the door jamb or atop the dashboard, and thus ordinarily in plain view of someone outside the automobile. Neither of those locations is subject to a reasonable expectation of privacy." Not only is the scanning of the VIN standard practice of this officer that he does to all people, regardless of day or night, race, color, creed, or anything else, it is also not protected by the Fourth Amendment. There is no expectation of privacy in the VIN on the dashboard, nor the VIN on the door jamb. The officer was within his rights and even asked politely for the defendant to open the car door so he could scan it. He had consent, which further waives any kind of Fourth Amendment protection. And after all of this, the officer only detained the vehicle for 6 minutes. He did not ask for a drug dog to come by and do an open air sniff of the vehicle. He did not prolong the stop any more than was necessary, even though he had probable cause to search the vehicle as soon as he arrived at the driver's side door.
Did he say on the video that one of the things he found suspicious was the fact that he was hesitant to open his door for him to look at the VIN number?
He said that, Judge. He also laid down a number of other reasons, but
my question is, he said that, and so from the video, my question becomes, was the defendant hesitant to open his door?
Judge,
because I didn't see that on the video. And if somebody can show it to me on the video where he's hesitant to open his door, then that's my mistake. So was he hesitant to open his door?
Judge, the defendant did ask why, and there was a bit of a hesitation and a pause.
Okay.
But I don't believe that ultimately it is subjective as to whether there was hesitancy or not. Okay. But the odor of marijuana is beyond being subjective. It is an objective standard that can be recognized by this officer who, through his training experience, can smell the odor of marijuana. Would you like, I can play the video again, Judge, if, of course.
Thank you. I wanted to make sure I heard everything correctly.
The judge is leaning on not allowing it in, maybe? It'd be interesting. Open air sniff.
No, so we work within our city. Can you open your door so I could scan the VIN number, sir? The VIN right there? Yeah, but it's not scannable. So I'm gonna just scan the. I was gonna just scan the sticker you have on your door.
Can we hear the officer going when he opens the door to get a good whiff?
All right.
Thank you.
Thank you. Summarize, Judge. There's been no violation of Article 38.23 of the Code of Criminal Procedure. There's no illegality on the part of state agents to acquire the evidence or contraband that was found in the vehicle. Everything has been in compliance with the case law and with the laws of the state of Texas. No illegality has occurred. Because of that, the exclusionary rule under 38.23 is not triggered, and we ask that you deny the defendant's motion to suppress.
All right, defense?
Judge, may I approach with my cases?
Yes.
Judge, the first case that I will be citing, and I'll go through them by name when I get there, is Rodriguez versus United States, 135 SCT 1609. The second is the state of Texas versus Dominguez, which is 714 Southwest 3rd 42. The third is Seifert versus State, 290 Southwest 3rd, number 478. And then the final one is Isaac v. State, which is, all I have is the actual, it's 2023. I apologize. It's 675 Southwest 3rd, 116.
And State, have you had a chance to review their cases?
I have, Judge.
All right, thank you. All right, you may proceed.
Yes, Judge. So, Judge, what we're challenging is under the Constitution, it's under the Texas Constitution and under the Constitution of the United States, that we are to be free from unreasonable search and seizure. What the argument in this case is that this is an unreasonable search due to an unnecessary delay and an unreasonable delay. That's what makes this an illegality. If you look at Rodriguez v. State, Your Honor, this is a Supreme Court case from 2015. And if you go to Roman numeral 2, which would be 2, 3, 4, 5, 6, 7 pages in, and I apologize if they're not numbered. What that court said is that, like a Terry stop, the tolerable duration of the police inquiry into the traffic stop context is determined by the seizur's mission to address the traffic violation. Addressing the infraction is the purpose of the stop. It may last no longer than necessary to effectuate that purpose. Authority for the seizure thus ends when tasks tied to the traffic infraction are or recently should have been completed. It goes on to say, the officers may not act in a way to prolong the stop, absent the reasonable suspicion ordinarily demanded to justify detaining an individual. And what that ordinary standard is that there are specific articulable facts for that detention. If we look at State versus Dominguez, this is a case where a person was pulled over. There was a person who the officer was, so in Dominguez was pulled over by an officer that was familiar with him. He'd been following him around town. They said Dominguez was nervous, his hands were shaking, he lit a cigarette to attempt to calm his nerves. They saw a radar detector in the vehicle. They thought that was suspicious, and they found a faint odor of marijuana. They thought he was in the drug business. And what the court says there is reasonable suspicion to detain a person exists when a police officer has specific articulable facts. A traffic stop made to investigate a traffic violation must be reasonably related to the purpose. So this is taking the Supreme Court case. This is the Texas case that continues that idea in Texas.
If this gets thrown out, the case is out.
In this case is that there aren't specific articulable facts to prolong this. What this officer discussed was he originally said it was based on the smell, and then in listening to the video and in cross-examination, he brought up other reasons that may have led to the stop, although in the video he mentions them in the body cam video, but then on the stand he said they weren't. So it's not really clear to me where he is on those issues. The point being, Judge, is that first of all, if he thinks that Mr. Hill was nervous or hesitant, I think the body cam, I would argue the body cam speaks for itself. Mr. Hill did what we hope anyone being pulled over would do. He had his license ready. He was polite. He was apologetic for he understood that he was speeding. There was some discussion about how much. He did everything someone is supposed to do. And in response to that, based on a smell, he was pulled out, cuffed, and eventually put in the back of a car. That's what prolongs this. The stop was effectively over. If you look at Seifert versus State, this is another case that continues along that line. And I won't go into all the details, Judge, but it is a case that would say the legal justification of the purpose of the stop was to either warn or cite the driver when there's no reasonable suspicion to conduct any other investigation. or is just based on a hunch, officers cannot continue stops and continue investigations that detain somebody based on a hunch. And that's what this officer seems to be doing. Finally, Judge, I present you Isaac v. State. I will admittedly say that the nature of the smell of marijuana in a vehicle is mixed. What all the cases prior to Isaac say, Judge, is that it's got to be based on a totality of circumstances. Isaac v. State, it's brought up, look, the smell is not enough. And what the court says is, look, marijuana is still illegal. But in this case, it's part of it. The smell can be part of it when there's a totality of circumstances. And then they go on to list the other circumstances to proceed. The smell of marijuana by itself, there's been no case presented that that's enough to continue this investigation. And that's all there is. For those reasons, Judge, I would say this was an unreasonable delay, that the illegality is putting Mr. Hill in cuffs and putting him in the back of the car when there aren't specific articulable facts to continue the stop. And for that reason, we would ask you to suppress everything after the initial stop.
All right, so here's my question, and if parties want to address it, they can. All of the case law basically says a variation of the same thing with traffic stops. The first thing is that when you have a traffic stop, the stop must not last no longer than necessary to address the purpose of the stop. So in this case, I think both parties have stipulated to, and the evidence shows that the stop was for a traffic violation, and that traffic violation being speeding. So an officer can question someone with regards to the speeding. You know, are they going to write them a ticket? Do you have your insurance, your license, your registration? Does anyone want to address that?
Judge, I would address that in two ways. First of all, if I may.
Go ahead.
First of all, he had the ticket writer in his hand. He said that. So he can write the ticket there. I think, so that would be that it's done. That he had all the information he needed at that moment to stop it. I think the second issue, Judge, though, is, in addition to that, is the smell of marijuana is based on the officer's credibility. There's no extrinsic proof. So first of all, I don't think he's qualified. That's my argument. That's for you to decide. That's one argument. The second is, you have to believe, if you believe everything he said about this stop, I find it incredulous what he said about the stop. That Mr. Hill was hesitant, that he was nervous, that he acted in any way inappropriate. All of that goes to his credibility. And the smell is only based on him. So even if you believe the smell's enough, you still have to believe him. And so first of all, yes, with the ticket writer, that stop was done. But second of all, I don't know how someone can believe that he smelled it if you listen to everything else he said.
May I respond, Judge?
Yes.
Judge, the initial reason for a traffic stop does not then bind the officer to that reasoning. If the officer pulled over the defendant or anyone else for speeding, and there was a dead body strewn out in the back seat, the officer cannot then say, by that logic of the defense, he was only pulled over for speeding, ergo, pay no attention to the dead body in the back of the trunk, I can only do a citation for speeding. The reason for initial detention can metamorphose as the evidence further makes itself known. In this case, the officer said that he pulled the vehicle over for a reasonable traffic violation. And then when he approached the open window of the defendant, he smelled the odor of marijuana. And I believe defense pointed to Isaac v. States. In that opinion, the Fourth Court of Appeals does say that while the odor of hemp, and hemp is legal, marijuana is illegal. They may both smell the same, but the smell of marijuana evidences the showing of contraband. So, Judge, that is going to be our contention, that this was a reasonable traffic stop, it was a detention, which then once the officer smelled the odor of marijuana on top of other factors, the time of day, his subjective opinion of the nervousness of the defendants, the fact that he was sweating, all of those go to the totality of the circumstances in his mind that he is justified in performing a search of the vehicle. And Judge, I would further state that from the defense counsel's own case law, that the smell of marijuana is still evidence of contraband being inside of the vehicle.
But does opening the door or requesting that the door is open to search the VIN number, does that have anything to do with the traffic ticket?
I don't believe so, Judge, but he did ask for. Yes. Judge, the state has already put in case law that says that there is no reasonable expectation of privacy in the VIN number that's on the door jamb or the VIN number that's on the dashboard of the vehicle. Even more so, the officer asked the defendant for consent. He asked if he could open the door. He at no point ordered him. He at no point drew his weapon. He at no point tore him out of the vehicle. He asked, and the defendant complied. There was no Fourth Amendment violation, and there is no, from the case law, there is no Fourth Amendment protection to be had here.
No.
The officer was completely within his rights to do so.
No. According to the case law, if you pull somebody over for speeding, the time delay has to do with how long is it taking you to investigate or to address the issue for the stop. For example, if you're pulled over for speeding, does that mean that somebody opens their door, you take the VIN number off the door? We're beyond whether or not he consented to opening the door. He opened the door. But I go back to the point, for all of the case law, it says whatever the violation is, whatever traffic violation it is, the actions that are being taken by the officer or whatever agency pulled a defendant over, are those actions related to whatever the traffic offense is?
Judge, from what I remember the officer testifying to, that was his standard procedure. The UCPD officers are issued that ticket reader, and they do that for everyone, for every traffic stop that he does.
I mean, but just because they do that, does that mean that it's right? It's the question I go back to is, if you're pulling someone over for speeding, and the law says, all of the case law, all of the cases that the state has given me, the defense has given me, in some form or fashion, they go back to whatever traffic violation you're pulling someone over for, the officer is supposed to be addressing that issue. If it's running of a stop sign, all right, how are you addressing it towards the running of a stop sign? And so in this case, I think both parties agree that the defendant was speeding. In the video, it says that he was speeding. In the video, he admits to speeding. Nobody's going to suppress any statements. So the question becomes whether or not, when he was stopped for speeding, the actions that the officer was taking, was it to address the speeding? Now, of course, if there's a dead body in the back of the car and somebody sees a dead body, that's completely different. But the first thing becomes the ticketing for the speeding.
And just, if I may address that concern.
Yes.
So, from what the officer said, well, first, from the case law that was given by the defense, I overlooked it. And it has to do with the prolonging of the stop, whether a dog was called out to do an open air sniff around the vehicle. In some of those cases, I've seen those cases, Judge, they take hours to get there, 15, 20, 30 minutes. Here, the only amount of time between the detention and the search of the vehicle was 6 minutes. I would argue that this amount of time, compared to the other case law where the stop was prolonged, to 20, 30 minutes, compared to that, 6 minutes alone is a de minimis and a small intrusion into the defendant's Fourth Amendment rights.
But Judge,
Hold on,
Judge,
if I may.
Oh, just 1 second. If you let him finish, then I'll.
I'm
hear.
sorry, Judge.
No. I
That's the point. It's an intrusion
no,
into his Fourth
no
Amendment
problem.
rights.
I'm going to hear everybody.
Forget my manners.
That's okay.
And further, Judge, he was going through the motions of writing him a ticket. He had his ticket writer out that it was issued to him. He was trying to scan the VIN of the vehicle on the dashboard as well as the door jamb. All of this was still in compliance with the ticket writing procedures that he had done. And that was after he had already smelled the odor of marijuana emanating from the vehicle. Because of that, Judge, this stop was not prolonged further than was necessary, even though the officer had probable cause to perform a search. And because of that, Judge, he is justified in his actions.
Yes.
The point is that even a moment too long is too long. A moment of a violation of the Constitution is too long. And that's the point here, Judge, is Mr. Hill's constitutional rights were violated because he was held too long, because the reason for the stop was complete.
All right. And here's the court's other. Oh, you all maybe see it.
Thank you.
And
Here's my question, though.
Of course, Judge.
And then I promise I'm going
Make a
to, you all
ruling.
can argue as long as everyone needs, because I want to make sure that the questions I have are addressed. And it appears from the officer's testimony that his checking of VIN numbers is because that's his policy. Am I wrong in that?
Judge, I spoke with the officer that
Well, no, I mean his testimony.
his testimony is that he needed to do this because that was how the ticket writing cell phone that he had works. He has to scan the number, it auto-populates so that he may issue a citation if he chooses to. He may issue a citation or he may issue a warning. But that is part of what he needs to do in a stop. And this was after he had already approached the defendant's open window, and after he testified, he already smelled the odor of marijuana coming from the vehicle. So, Judge, we would argue that the officer had probable cause at the moment that he arrived at the open window of the vehicle, and this was before the reason for the stop had concluded. The officer, in the middle of performing his investigation of the traffic violation and possibly issuing a citation, already had probable cause to move on to the next step, which was the search of the vehicle, which is the automobile exception that we all learned
That's a
in law
good
school.
argument.
Because of that, Judge, the prolonging of the stop is a moot point because the reason for the stop had not yet completed. The officer had not yet decided to, and had not yet done the decision to issue a citation or issue a warning. It was in the investigation of the traffic stop that this metamorphosed into probable cause for a search. Because of that, Judge, because there's no prolonging of the detention, as the reason for the search was within the confines of investigating the traffic stop, I believe that the officer's actions are justified and no illegality exists.
I think you have it all in front of you, Judge, and I'll rest on what we've already.
All right. Thank you.
Thank you, Judge.
All right. I just need some time to watch the video. So if y'all will play the video again.
Roll the
please.
tape again. She still hasn't made up her mind. And we're live, so we have to wait. She's going to roll the... We have to sit here until she makes a ruling. Oh, let's see what... We're on 7 here, so we put 7 up there. We can go back here. That way you can see it, we can hear it. Well, if she comes on live, we'll hear it. How's everybody doing today? It's reaching the end of the day here. Metamorphosized. Word of the day, metamorphized. We've heard about 6 different ways, I think. What I don't like about this is the officer says, oh, I have to scan the VIN number to write the ticket. Oh, my scanner's not working on your window. I'm going to need you to open your door. Open the door reveals more of the car. It reveals inside areas they could not see or readily see during a normal stop. It does open them up to a good open air sniff test that they wouldn't normally get. I don't like it because any officer is like, oh, it's not scanning. Funny thing, open your door. That's like a freebie to a partial search. If it doesn't scan, you put in the license plate number and say VIN not readable. Do that. Don't, I have to put the VIN on here. It's my policy. You've got to open the door. No, I tell you what, I'll pop the hood. You find the one on the engine block. Scan that one. That's what I'll let you scan. You're not opening my door. What is the big counter on your desk for? I've been gone a while. Debbie. This is how many times somebody's clicked the like. Well, how many people clicked the like button today? It updates about every 10 or 15 seconds or so. And so if you click the like button, if you haven't before, then within the next 10 or 15 seconds, it will go up by 1 or 2 or 3 or 4, or however many people click during that time. So it's a likes counter for each live, and I love it. And it makes noise all day. I might put some rubberized feet on it to sort of lift it up off the counter, so it doesn't get vibration. The sound doesn't carry through this, because it does. That's where you're hearing most of the sound, is through this. So it makes RA's heart flutter and the counter flutter. It's good fun. Thurston Arraignments started. Have we talked about BK yet? Yes, we did. He wants a new trial. Well, he wants to withdraw his guilty plea and go back to trial, even facing the death penalty again, which is crazy because the death penalty was off the table. That's why he took the deal. And now he's like, I don't like it anymore. I want to go back and do it again. Try again with the death penalty. Fran Fitzgerald gifted a membership. Thank you very much, Fran. If this attorney wants to set precedent on the hemp and marijuana smell, he'll appeal it. I think he will. The judge, what does she have to lose, right? If this is an issue that she doesn't like in the law, she's at the point in her career, it's like, what are you going to do to me? I've already lost my job. Yeah, I'm a lame duck as far as judges go. What are you going to do? If this is an issue that she wants to push and drive change on, it's going to be good. But we like the sound. The sound will still be there. It'll just be a little quieter. I do have screaming goats as well. There's one right here. It's a Christmas goat. But the cow does not scream, but it's about to burst. This thing is seen better days. We're going to have a catastrophe. It'll be an utter disaster when that thing pops. I'm escaping the Clancy trial. It's everywhere and so sad. It is, Laura. We've made a decision not to go there because it is everywhere and so sad. And unfortunately, it has some important issues wrapped up in there about mental health, about possible effects of drugs or combinations of drugs and things. I've got personal stories and families and friends that that have similar situations where some medication was involved, and erratic behavior was observed that caused outcomes that we couldn't ever fix. So there's a lot to talk about there. Unfortunately, that case is just it just makes you want to cry. And watching the husband get dragged through this as he's tried to rebuild his life from scratch, with a new family from scratch. Yeah, it's heartbreaking. Another joke incoming. Let's go cow tipping. I don't think I should. I was going to tell you a story. Okay, this is a sad story as well. I'm sorry. What do you call a cow in an earthquake? I don't know. Do I want to know? That's the question. Milkshake. I like it. Quick story, and this one makes me frustrated, like mad frustrated. In North Carolina, where I'm located, in my county, Pitt County, the Pitt County Sheriff's Office made a post where they let us know that one of the police canines had passed away. due to being left in a hot car on a day where the Pitt Green Airport measured 99 degrees. This was on January 22nd, or excuse me, July 22nd. It was hot. It was ridiculously hot. They won't release the info about who it was, what officer was involved or the situation, and there may be something there. But I'm looking at that and I'm saying if it was any one of us and our dogs, there would be animal cruelty charges. And here we have a police dog, a working dog, taxpayer-funded dog. And they found that it was accidental. Last I saw, there were no charges. The sheriff's office came out and basically used this announcement to sort of piggyback their request for additional funding for like high temperature sensors and escape mechanisms for the dog if this ever happens again. They say that this officer has, had a previous dog before that got cancer, and he adopted it and cared for it until it passed away. And he's a pet owner and has all those pets, and he's great and fantastic. And this is just a tragic situation. But I'm sorry, you've got to do better. And there's got to be equal treatment. If this was anyone else, there would be charges, and it would be public, and you might be found not guilty, and it might be an accident, and there might be a million reasons that the court could find that there's no animal abuse that took place. But having this all done with an internal investigation in a couple days, because it was 5 days ago that this event happened, and the investigation's done and nothing's been released. Anyway. I thought I had to share that with you guys. I'm sorry. I wish it was good news, because I've been there and watched some of these dogs. Literally, the dogs in my county do demonstrations. We helped set up a venue where the community could come and watch, and the officers came, and we got to see the dogs work, and everything was amazing. That's just not right. All right. That said, right now Judge Boyd is watching the traffic stop again and making her determination. I know the state in this one has made an argument that's rational and makes sense. It's a sound argument. But I don't know if the video supports the argument that he's made. If the video says, hey, smells like marijuana in here. You been smoking marijuana? Oh, no, sir, I haven't. Nope, I just gave a ride to some stranger, and he smelled like it. Whatever that was. And then he's like, well, let me finish writing you the ticket. Scan the VIN. Oh, it's not working. Can you open your door? If it happened like that, this guy, go on to the next bound over for trial. Or don't, I guess this is they're trying to rule this evidence can't come in. And so this evidence would come in that case. But if we have no indication whatsoever from the officer that he smells something funny beforehand, and he's like, oh, I'm just checking you out, I think Judge Boyd sees that this was like a targeted stop, and they wanted to pin something on this guy. I think she does. I would not be surprised if she says that this is everything that comes after this is fruit of the poisonous tree. Okay, we're coming back. No animal stories unless it's good, please. Love true crimes. I wish I had more good ones. We'll look for some. Tell you what, a good story. It's not animal, but a good story also in my neck of the woods.
Yes, that's not the beginning.
I'm sorry, and I'm not understanding, Judge. You just.
I'm not sure why she unmuted us. Just
Did I go back more? Okay. Bueno? Good? Okay, let's start again.
It's 50, Infinity, Q50. Okay. What year is it? 2020. 2020.
Oh, no, he's already outside the car.
Oh, it's fast forward now. Okay.
Everybody.
I think the state's playing fast and dirty here, trying to show just what they want to show of this. Here's the good news. Eddie Smith, local guy, built a company called Grady Boats, Grady White Boats. They're a boat builder here in eastern North Carolina. Built it up, builds amazing boats. They're really popular in this area. It's worth $400 million. He has no heir. He's getting older. He could have sold it and done whatever he wanted, but instead he built a trust to take over the business, to keep it running for all his employees, and donate profits to nonprofits and charitable causes. So instead of cashing out and buying a quarter of a state or a chain of islands or something like that, he set up a legacy that's going to keep going. They're going to keep building Grady White boats. Employees can keep earning great money, having great income, building up retirement, and owners, just because they pay well and everything else. It's just amazing. And to do that, he basically gives away his company to his employees and to charitable causes instead of selling it. $400 million company. That was impressive. All right, that's a better story. Good guy. I think it made the New York Times, that story. Sorry, and we're watching me because there's nothing to see right here. I could show you this, but that just gets boring. So here you can at least see in the background over there. Court. I don't like... If I were the state, I wouldn't like the tone that the judge has, because it sounds like she's going to rule against you, or that she's not happy with having to rule with you. Everybody's talking about Brian Koberger seeking to withdraw his guilty plea, wanting to go to court. Let's see. The thing that he has to have a valid reason, because usually when you take a plea, you're waiving your right to appeal, right? We hear it, especially in Judge Boyd's court, over and over. If you accept this plea, you do not have the court's permission to appeal, right? That's standard. But there are a few exceptions where you could appeal even after taking a plea, and one of them is ineffective assistance of counsel. This is going to be a tough one to prove because they were literally the best of the best. And they put in a ton of work. Absolutely. And they fought hard for him. It's going to be interesting. If he says it's an involuntary plea, I know he testified that under oath, he said it was voluntary and he chose to do it. No one had promised him anything. Ooh, there's another option under a June 2026 Supreme Court ruling. If enforcing the waiver mean the waiver where he's not allowed to appeal, would cause a miscarriage of justice. Okay, we're coming back. Here we go. Judge, make a ruling for us.
All right, we will all be back tomorrow.
No! No! She didn't tell us what it was. You can't do that. Am I happy with the counter? I am. Initially, I was unhappy because I had some calibration issues. But I reached out to Smurl, and they took like 48 or 72 hours to respond to me. When they did respond, the way to fix it is super easy. I don't know why they didn't include those instructions, because it should have been included with it, because you just go to the IP address. When you plug this into your network, you go to that IP address /calibrate, and it just steps you through, and you say what you see on the screen, and it makes adjustments and spins, and it says what you see now, and you make adjustments and spins, and it fixes it. It recalibrates it. So if it does get mixed up or shaken or something, and the sensors are a little off, you can fix it by yourself. So now I absolutely love it. Yeah, and it keeps going up. We're almost to 400. What about Koberger? He wants a new trial. He wants to withdraw the guilty plea. Says it was not the deal he was looking for. It's 4 p.m. in Bexar County. They should be done soon. They're done, and they left. So I guess we'll have to look in the court records if we can find them and see what the ruling was. If we can get 2 more likes, though, I'll go ahead and let you guys go for the evening. He wants a trial, not a new trial. Yeah. Boom. We got it. There's 400. There we go. That's all we needed. He's also saying he has mental issues and didn't understand the plea. That's on the table. I think he has to put all his eggs in one basket and claim ineffective assistance of counsel, the miscarriage of justice, mental insufficiency to understand, everything. He needs to throw it all at the wall if he wants this. Honestly, I'd like to see this go to court, because this is one of those trials where there was a ton of speculation, right? Just like with the Tyler Robinson case, there's a ton of speculation. There's a ton of conspiracy theories. There's even lawsuits and cases that have evolved around this thing. So anyway, I'd like to see it go to court, just because it puts so much of that to bed, puts it to rest. We get to see what happened. And for the most part, it's tragic, it's terrible, it's hard. The families get justice. There's no question about, the backroom deals and why things are happening the way they do, and who knows who, and why the connection is, and who's being protected. All that disappears if we have a public trial. And I think that's his right. I'd like to see it happen. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow. We have a case tomorrow out of Wisconsin. I think it's Wisconsin or Michigan, one of the two, or one and the same for me. I'm sorry. I haven't been to either state. Wisconsin has cheese. Michigan doesn't, I guess. But we've got a case tomorrow we're going to try to find and follow. It made me so frustrated, but we'll see. It's going to be fun. You guys, you're amazing. Thank you for all your mods and everything. Thanks for being here and hanging out with us during this little break. We'll have a big court case coming soon. We'll see you guys soon. Bye-bye.
There's nothing in the order that restrains you from talking to cats.
Thank you.